Bonjour, and welcome to this third edition of the conference Regulating the Internet. Really, Dentons is happy to cooperate with the International Commission of Jurists once again on tackling this core societal issue, really. How do we transpose the rule of law to address issues, harms, challenges on the internet? Before I go any further, I want to acknowledge that I am speaking to you from Ottawa, which is on the traditional unceded lands of the Algonquin Nation. I'm joined by my colleague Monica Song, who is organizing this conference with me, and Manette Maillet, who is the Vice President of the International Commission of Jurists. So I will turn over to Manette to tell us more about the ICJ.
Thank you very much, Chantal. Hello, everyone. I'm just going to give you a short blurb about the International Commission of Jurists Canada. It was established in 1958 by Chief Justice of the Supreme Court, Ivan Rand, along with other leading judges, lawyers, academics, civil society supporters, and human rights champions. The organization seeks to promote greater understanding of the rule of law in the operations of our laws and our institutions. Given the current challenges to the rule of law and to democratic institutions, both here and around the world, we feel that the work of the ICJ is as important as ever. We encourage, therefore, that the participants today join us in this endeavor and become active members of ICJ Canada. I encourage you and those in your network to check out what we do in promoting the rule of law at icjcanada.org. And for those who are not already members, you can join online at the ICJ Canada website and invite your colleagues to do as well. So that's my pitch. Back to you, Chantal.
Thank you so much, Manette. So today we are going to tackle the issue from a third angle. Our very first Regulating the Internet conference really explored the array of legal issues that were arising in transposing the rule of law on the internet. We looked at e-commerce, we looked at competition law, we looked at privacy, obviously, we looked at human rights law. Then the second edition, we focused on accountability and enforcement. Who's accountable for compliance on the internet? Is it the platforms? Is it the government? Is it the users? And then who enforces it and how to enforce it in a manner that still keeps the preservation of human rights and is effective? This year, we decided to address managing the tensions of competing rights. We see it playing out in the House of Commons at the moment, in particular on the bill that my colleague Monica will address in her first panel. We will then move to how we are going to look at preserving privacy in its tension, or not, with innovation. Then we will have at lunch our keynote speaker, the new Privacy Commissioner of Canada, who will talk about how he sees the preservation of the right to privacy in regulating the internet. We will then move to tackling the issue of how do we regulate online advertising while still keeping a free, accessible internet. And then we'll look at the tension between addressing harmful content without creating a surveillance state. So this is really what we wanted to tackle this year, managing the tensions. I'm very happy then to move to our first speaker, Christopher Parsons. So Christopher Parsons, Dr. Parsons is with the Munk School Citizen Lab of the University of Toronto. I have known him for many years because when I was at the Office of the Privacy Commissioner of Canada, Dr. Parsons was a resource person for us, and I assume he still is for the staff who are still there. We wanted to ground our research, we wanted to ground our guidance in the reality of what happens on the internet. And that is precisely the topic of research of Dr. Parsons. So today, before we start addressing the challenges of regulating the internet, we wanted to have that reality check with Dr. Parsons as to what is going on in the internet. What is it that we should be looking at for regulation, for bringing some discipline around it? What is it we should worry about? What is it we should not worry about? So this reality check comes with this presentation. And Dr. Parsons, then over to you. And thank you so much for being with us this morning.
Thank you very much for having me and for that introduction. And thank you to everyone for attending. And most especially, thank you to all of the staff who are working tirelessly behind the scenes to make sure everything is running smoothly. This would not be possible without them. And thank you so much for all of your efforts. So I'm going to be speaking to try and give some context for where future panels will pick up and discuss things later on in the day. And so I'm going to be talking about today's harms, yesterday's decisions, and paths ahead. Now, in case the internet dies in the next 30 minutes, either on my end or yours, because there's another, massive telco outage, I want to give you sort of the takeaway up front. The internet and the activities that are occurring on it are increasingly seen as a need of regulation. Things seem wrong, frankly, to a lot of the participants in the internet space, be they civil society, be they government, or indeed be they companies. But the harms that we experience today, the challenges that we've experienced today have not come from nowhere. In fact, many of them have their origins, their root stories in decisions that were made 10, 15, 20, 30 years ago in some cases. And so it is imperative that as we look at the harms today, and as we look at the regulation proposals, the law proposals, the different ways of regulating the internet writ large, it's imperative that we reflect, what are we trying to solve? Will this solve the problem or a symptom? And moreover, what kind of challenges might this create in the future in 10, 15, 20 years for the next generation of regulators, lawmakers, and policy experts? So you'll note that I'm looking down periodically to look at my notes. And so I hope that my melodious voice is enough to keep you awake along with the coffee you have beside you. Now, I'm going to be speaking about these topics in the following order. First, I'm just going to walk back and talk about the internet that was, the one that so many of us remember, and sometimes positively, sometimes a little bit less so. But what was the old internet that we have come from? And what were some of the principles and challenges that existed there that have subsequently metastasized? Then I'm going to touch on a bunch of those challenges, many of them that will then be taken up by later panelists, and come to argue at the end that we are at an inflection point. We are at a point in Canada where there's a number of decisions, and as such, we need to be very mindful about the decisions we're making, why we're making them, and how they might intersect with one another. And then I'll offer a couple concluding thoughts. So first, let's turn to the internet that was. So I have been on long, probably too long, to be honest. I remember the internet before we ascribed it with terms such as 1.0 or 2.0 or web squared. And it's worth thinking about what the internet used to be. So we're so used to a very fast-paced internet right now that not many of us sort of slow down and think of what it was like to listen to the dial-up modem and use an FTP service to bounce around university networks to get access to information. And the internet that we often think about sort of charitably was rife with challenges, but also opportunities. So what kinds of services existed in that 1.0 or 2.0 world? Well, we had message boards, which have been the lifeblood of the internet for a long time, second only perhaps to email. We had, during the 1.0 era, the ability to create websites without requiring code. GeoCities innovated in a meaningful way and enabled individuals to communicate with the world and present sort of wacky ideas as to how they thought things should look on the internet for the first time. It was an empowering moment. It was a moment where parties and individuals who historically would not have been given a platform could speak to anyone who wanted to visit their website. We saw the rise of absolutely massive challenges and questions and fights, frankly, around copyright with the rise of peer-to-peer network sharing, rise of Napster for those of the right generation, and then, of course, all the other sharing services that have followed. And then we also had a number of increasingly social systems that indicated the migration from a 1.0 era to a 2.0 era. Services such as MySpace, which is now almost the butt end of a joke, but was a meaningful way for individuals to communicate and network and find other people, and most especially its founder, Tom. There's also early methods of sharing information amongst users. And so you can look at services such as Dig, which maybe only people who are spending a lot of time in technical environments spent time reading. And it was an early system that let members of the internet rank up and down news to sort of identify what was valuable, what was not, and to try and surface things to the top of people's reading lists that otherwise would have been unnoticed. And then there were also services such as Delicious, which just looked at the way that bookmarking services could be made social. So rather than being locked into Internet Explorer or Firefox, you could create a social environment where you could tag links, add semantic knowledge to the 2.0 environment, and then enable other people both find and access information and also read the summaries, comments, and thoughts that are attached to those bookmarks. And then there were blogs, which in many ways were the progenitor of the contemporary news environment, insofar as they disrupted news and made it both widely accessible, free, and also relied on standards that are used to this very day for the communication of content back and forth. Now, why is it worth looking back? In part because many of the services that we saw arise were built and made possible by a series of principles in legal decisions that sometimes were contemporaneous with those services and their emergence, but more often than not happened beforehand. And let's touch on some of those just to remind us how those often perceived positive services have metastasized into the internet that we know now. During the 1.0 and especially the 2.0 eras, I think that most internet policy experts were most attached to issues of network neutrality and copyright issues. And so in the area of network neutrality, of course, there was this massive push that the ends of the network, the laptops, the desktops at the time, we didn't have a lot of smartphones, so the BlackBerries were certainly prominent. But the ends of the network should be responsible for the communication system. It should not be a party in the intermediate of the communication that should be able to influence it. Content should not be regulated, it should not be charged, some should not move faster or slower than others. We thought that it was important to have an egalitarian internet where all communications traffic were relatively similar or similarly handled as one another. We also saw discussions of copyright. What should be copywritten? What shouldn't be copywritten? Under what terms should material be available for commercial or non-commercial use? Folks like Larry Lessig and who will be on the panels later on, Michael Geist, were instrumental and remain instrumental in understanding the contours of copyright and the sharing of intellectual property and the regulation of intellectual property when it comes to individuals and amateur creators versus corporate creators. That both of those positions really have threaded and created a lot of the environments that we look at now when we're talking about to what extent should intermediaries be able to prevent some content, accelerate some content, or otherwise get in the way of content from A to B, perhaps for cybersecurity reasons, perhaps to promote content of Canadian origins, for any number of reasons. But the decisions of the early internet are in part what make the issues of today interesting, because it seeded the ground. Now, while there was a discussion, a prominent discussion, so let's say too much discussion, I think, over copyright and network neutrality, at the same time, there were a number of pernicious harms that were sort of set aside. And so scholars such as Bill Coleman have gone and done extensive research in the early hacking communities, in the early technical communities, in the late 80s to mid to late 90s. And what she focused on and what she found in reviewing and speaking with people who were around during those times was that certain issues were important, capital I, important, and others not. And so we saw a very libertarian, almost American free speech approach to the internet that really took over. The ability to say things in an anonymous or pseudonymous way was absolutely central. And there were flame wars aplenty that justified why that should or shouldn't be, with those justifying it should generally winning out in the end. Moreover, we saw that the ability to connect and distribute information was central and seen as key to the way that the internet should function. And we see a lot of those principles today and the way we think about the internet as a free speech platform, as an environment where people should be pseudonymous or anonymous, where it's important to surface communications and individuals and content that otherwise might not be. But there were other harms that were not particularly well addressed. Cybersecurity was prioritized to different extents, but was seen as important. But other kinds of security, other kinds of harms were not. In 1993, there was the first rape of cyberspace, which was a situation on a messaging platform where an individual was able to take control of other characters and make them do things in text on screen. Online harms of one sort or another are not new. And indeed, during the early era of the internet, as someone who lived through a lot of it, doxing, misogyny, and other kinds of lawful but awful activities were common. And they were seen as just part of being on the internet. You were expected to have a thicker skin or get out. Well, that didn't work then, and it certainly doesn't work now, as we all know, based on the harms that we see. Moreover, during that early era of the internet, that 1.0 and 2.0 era, we saw the rise of cybercrime. But it wasn't regarded as a real issue. And in fact, when you speak with many law enforcement professionals at the time, there was frustration amongst those that were specialized that they were seen as sitting in a computer and playing games or browsing social media. Why weren't they going out and doing investigations to capture real criminals? And again, that has meant that there was an under-resourcing and under-prioritization of cybercrime responses. Move to today, and we see some of those results. And much of the internet, both in the 1.0 and 2.0 era, but I would argue today as well, is predicated on a myth, I would actually say, of consent. That individuals click yes to terms of service, they have access to a privacy policy, and therefore they have consented to whatever the organization, the application, the service happens to require them to do. And the data collection thus is permitted, it's contracted, you agreed. But this individual model of consent, while always problematic, frankly, has again become more challenging. We now live in a data economy where consent is challenging or simply not sought at all. How exactly do we handle that in a contemporary internet era when individuals still at least nascently think consent matters? And attached to consent has been the growth of surveillance, in some cases for marketing and in other cases for more pernicious reasons. Surveillance is just part of the internet. And I think if you speak to anyone who spends time on it, they just sort of shrug and groan and just accept that perpetual surveillance of one type or another is just required. That has led to a massive issue in the internet space, and indeed the internet policy space, as to how much surveillance is too much, how should it be handled, how should it be regulated. And then finally, one of the core principles, one of the core issues that has made the issues that we have today what they are, is the structure of monopoly and competition law. When you look at the United States, where many of the largest internet giants operate out of, we know, we can see that because companies have been able to merge and acquire one another, so long as they do not cause economic distress or harm to consumers, it has meant that we are now dealing with this behemoth companies that have almost on towards size and power. And we're now faced with the real challenge as to how do we deal with this? Now, I raise these issues. I point to network neutrality, copyright, harms that were and were not seen as important, the challenges of cybercrime at the outset of the internet, competition policy. Not to say that we made terrible mistakes at every stage, because I don't think that we did. But rather that it's important to recognize that individuals during the earlier stages of the internet came to what were often very principled positions, but have led to the challenges that we have now. So now let's turn to some of those challenges, some of the harms that we face today, so we can identify the different kinds of inflection points that we're at and why it matters to reflect on the principles that will guide our actions today and in the near future. So where is the internet at now? What kind of harms do we experience? I think that it's probably pretty fair to say that the internet today, in many respects, be they the way that service providers operate, the way that platforms are regulated, the internet is a 20 or 30-year-old, depending on how you count your age, that really hasn't had a good dose of discipline to date. And there are reasons for that. We wanted a hands-off approach to the internet. We wanted to ensure that different services would grow. We didn't want to suppress competition. But we're past the early stages of the internet. We are now at a stage where it is used in all aspects of our lives. It has become the critical infrastructure, especially during the pandemic, that has fueled and enabled our economies to sputter along in the digital services environment. So what kinds of harms are we up against, and what might we do? Well, let's first turn to some of those cyber harms that have become more prominent, especially in the past 2.5, 3 years, as the majority of office workers in particular have worked from home, but also we've seen a digitization of other parts of the economy, such as manufacturing, labor, transport, and so forth. So if we go back a couple of years, Edward Snowden released documents, and up until then, most of the internet was unencrypted. Edward Snowden and his revelations, combined with the decreasing cost of compute, meant that all of a sudden it was possible to encrypt wider and wider and wider and wider swaths of the internet. Moreover, innovations in cryptography meant that chat could be encrypted end to end. So for an already struggling law enforcement approach, this meant that all of a sudden those struggles were magnified. Encryption was common. And there are harms that are attached with this, we should be honest. The ability to groom children in some social networking environments is easier because of end-to-end encryption. It is more challenging to detect those kinds of activities. Similarly, it's possible to collect and distribute child sexual abuse material due to, in part, the availability of encryption. We also know, certainly during the course of the pandemic, that ransomware in particular has become incredibly pernicious. This is an instance where encryption has been turned against users. We are now seeing what was seen as a protective tool being weaponized against individuals, businesses, and governments. But encryption is also critical to the very ability to do what we do online. The ability to communicate freely, the ability to communicate with friends and loved ones, the ability to share our own intimate or personal information without fear of other parties capturing it, the guarantee or assurance that when there are data breaches, the scope and caliber of the breach may be lessened because data can be encrypted. The very encryption of our smartphones, while frustrating for law enforcement to be true, means that when we lose our phones, they're no longer an immediate treasure trove of personal information for whoever picks it up. So I raise this because the burgeoning cyber harms that we have online, be it online grooming, cyberbullying, or any of the other communications-based harms, in some ways are directly touched by encryption. But at the same time that there is a discussion in Canada and around the world about whether we should or shouldn't raise or lower the amount of encryptions available to consumers to enable law enforcement to pursue crimes, we also see new legal instruments finally coming online. Things like the updates to the Cybercrime Convention, things like the Cloud Bilateral that's being negotiated by Canada and the United States. These things will expand Canadian law enforcement's ability to collect information that historically they would have often needed to issue warrants that would go to the United States and perhaps never receive a response. So it's possible that we can actually address some of the cyber harms that we have today by both acquiring and hiring new officers and using the emerging legal tools that will be coming online in the near to midterm future. But either way, we are at an inflection point around what kinds of powers should law enforcement have? What kinds of powers does it need to address the most awful activities that occur through the internet, criminal activities One of our inflection points then is, what kind of power do we ascribe to the state versus what kind of power do we ascribe to individuals in their ability to keep their communications safe from all parties, including in some cases law enforcement? That decision will reverberate. But there are other inflection points as well. And I think one of them sort of cheekily listed on my in front of me is consent required? We have come to a point in the internet ecosystem and process where consent is quite rarely asked. You click yes to a terms of service and then data is collected. And frankly, very few people understand what they're consenting to, even if they happen to read those terms of service. And as someone who reads them, they're often vague and unclear. And in fact, this is something that users have almost given up on. But they haven't at the same time, because we see this when it comes to asking individuals to download and install applications, be it the COVID-19 or the COVID Alert app during the pandemic, and people hold off because they're distrustful of the kind of surveillance that might be attached to it. And when we look at the legislative movements at the moment in this country, we can look at previously in the last legislative session, Bill C-11, and the current legislative session, Bill C-27 or C-27. And we're seeing legislation recognize that the internet depends on the free flow and capture of data, but that is impeded if we require meaningful consent ahead of those activities. But the pieces of legislation go one step further in many instances. So we see exceptions to not just consent, but also knowledge in the way that some legitimate business activities might take place, which raises an important question. Are we at a point where consent is needed or not? Or are we at a point where we can set aside consent, but knowledge still is very critical? And I raise this because the decision that we make now has important reverberations for how we regard agency on the internet. Perhaps it may be the case that for several situations, businesses may be required or be empowered to collect information without first obtaining consent. But surely knowledge should be required. Surely individuals and consumers should be able to be knowledgeable about what is being done with their data, how it's being collected, how it's being used, how long it's being retained, to whom it's being shared, and why, in order for them to then exercise their own agency and opt out should they choose to. Now, of course, opt out is in many places, I'm one of these places, not ideal, but it is providing agency to the individual. But to provide that agency requires knowledge. Are we at a point in the internet where we have gone in the internet policy debates, where we've gone so far beyond, is consent required? Are we at the point now where is knowledge even required? And this has, again, important impacts on the way that we regard the ability for individuals to exercise agency when they're operating online. And there are at least two other kinds of harms that I will touch on, however, briefly. First, what are the acceptable gradients of surveillance? So anyone who looks at the data brokerage economy or the surveillance economy, or to a lesser extent, the advertising economy, we know that there is rife collection of personal information, that companies routinely track you around the internet. Work from Mozilla, as well as some of the work from the Citizen Lab, has showcased just how prominent and prolific those advertising networks are and how invasively they can track individuals as they wander the internet. Moreover, when you do go and read those terms of service and privacy policies, and then you do a technical analysis as to what applications do, you often find a disjunct. And that isn't because I think that companies writ large are trying to, lie to customers, because I don't think that's really the goal. Maybe for some bad actors, but I assume most are not that. But rather, it's a clear situation, even the largest companies in Canada, where legal teams, policy teams, and technology teams or engineering teams are simply not in the same room using words that everyone understands. And so first, we have a problem in understanding what companies themselves are doing, but then there's the question of, is what they're doing too much? So in some cases for marketing, you can certainly see the appeal. You can see the value in advertising, or at least historically being able to advertise on Facebook as an example, and then get analytics and information that tracks not just was my ad served to someone, but then what did they do with that afterwards? And did it even lead to an in-person commercial transaction? Now, I think a lot of consumers would be shocked and surprised that that level of surveillance and monitoring is possible, but nonetheless, that has, at least until recently, been a key part of the digital economy. changes that have changed, obviously, with some of Apple's decisions. But that's only the most high level, and I would argue in many ways the most banal of collections of information. What do we do of situations where individuals have an application installed on their phone and it requests geolocation information? Maybe for legitimate reasons. This isn't the flashlight situation, in other words. This is a genuinely useful service that's being provided when it requests location information, such as you have a camera app and you would like to geotag your photos. So as an individual, you say, okay, I trust the application. The developer seems fine. I say yes, so I can geotag my photos. But what is unknown to the individual who has consented, and quite often, frankly, to the application developers as well, is that the application developer didn't build the code that's collecting the geolocation information. They bundled in code from another provider, and that's exactly what they do, is they facilitate geolocation lookups. It makes apps faster and cheaper. But unbeknownst to the individual who consented and unbeknownst to the individual who integrated that code into their app, they've brought a data broker into the phone. And this has had very serious effects. There have been situations where data brokers with access to geolocation information subsequently resold that information to, say, the US government, including very intimate information such as religious status and locations of individuals who worship different religions. Moreover, this information has been used for doxing, to out priests, as an example, to reveal that they are homosexual as opposed to what their faithful thought they were. And we also see situations where this kind of geolocation data is useful for other purposes. On the one hand, during the COVID-19 pandemic, it has and continues to be used by some governments around the world, not to track individuals, but to understand the mobility of their populations and assess and plan and respond to emerging crises of the pandemic. I think many people would say, okay, I understand that. But there's also the risk that this kind of data could be used in Canada, should legislation be passed, for socially beneficial purposes in excess of the pandemic, or in ways that are not immediately imagined by the population. Let me give you just one example. You can picture de-identified, aggregated information, so nothing about individuals, being provided to to the federal government, I should say, such that it could ascertain whether or not women are having to travel significant distance to receive abortion care. Now, on the one hand, that could be regarded as this is a baseline right for women, which it is. And as such, there should be more funding available to make abortion care more widely available based on looking at aggregated information about how far people have to travel to these sites. This right needs to be enforced. That's certainly one approach. But you can imagine another way of this data being used. You can have a different analysis of what is the socially beneficial good at hand and see, in fact, the availability of these services is too much and it endangers fetal life. And as such, different policy decisions must be made. Now, I don't raise this bombastically, but rather to indicate that even when we're talking about de-identified information that is ostensibly anonymous, it can have substantive impacts on individuals and their communities. Thus, when we're thinking about surveillance, we have to move beyond simply thinking about surveillance of the individual, though important, and surveillance of the community and the population and how that might be used. So again, we are at one of these inflection points. How do we regard privacy and surveillance? It is imperative that we think more broadly than individual privacy, individual consent, and individual surveillance, and in fact, move on to think, how do the decisions of the individual, or how do the collections of an individual's information more broadly affect the population? We also are in a situation of harms attached to the monopoly situation that we have with some of our largest internet service providers. We now see the largest internet companies are essential to our lives: Facebook, Google, Apple, the list goes on. The large unicorn-style companies. How exactly do we handle them? There's, of course, one school of thought that the solution is we need regulation. We need to find ways of ensuring that their activities are contained. They can no longer externalize the harms that they generate, and they must be responsible for them. They have to enforce their terms of service. They must provide funds to media organizations that they impart their services have badly harmed. They have to find ways of supporting Canadian content. The list goes on as to what's being asked of these large providers. But there's another approach. There's a response that sort of comes from Shoshana Zuboff and surveillance capitalism, which is regulate, and the other, which is thinking more deeply about competition. And the question is, are some of the harms that we're experiencing linked to the fact that we have companies of the size they are? Do we need to be in a situation to empower real data mobility between providers such that it is no longer the case that once you go into one of the large companies, it's like a roach motel and you're stuck and you can't get out? Is that the solution, such we break down silos and we actually see individuals able to move more quickly, so companies are incentivized to behave better to their users, not because of regulation exclusively, but because if they don't, their customers can and simply will leave. So we are at a real decision point as to how we conceive managing these large companies. Do we regulate their activities and their actions, or instead, do we say, enough is enough, you're too big, no more roach motels, with the hope that this will spawn greater competition and bring us back to that earlier 1.0 and 2.0 web era? So I think as a parent, we are at, as I've said many times, inflection points generally, but in particular in Canada. And I think that this conference showcases how many issues have come up almost simultaneously on the social and political agendas. Just think of the list. We have Bill C-11, Bill C-18, online harms consultations, Bill C-26, infrastructure security, Bill C-27, privacy regulation, Expected Privacy Act reform, competition reform is possible or being agitated about. And this is just in Canada. When we look around the world, we can see other governments also doing the same sort of thing, also asking, how should we regulate this 20 or 30-year-old internet and the services that ride on top of it? But the decisions that we make today will have ongoing effects. And it's imperative that we reflect on what the relationship is between the regulatory ambitions today and the positive values and understandings that we developed in the earlier ages of the internet. To what extent do we still value network neutrality? To what extent do we still value anonymity and pseudonymity online? In what ways do we need to improve past responses? What kinds of harms should be responded to and in what ways? What deserves a criminal response versus a non-criminal response? In what ways should infrastructure providers be permitted or required, in fact, to stand between communications to provide cybersecurity or information security to those communications? Decisions that we make today matter. And there's a real danger that we may quickly pass legislation with the effect of saying, we can just revisit that in a few years if we get it wrong. And while I understand the ambition and I understand the intent, legislative history showcases that quite often when we pass legislation, it remains as it has been passed for quite some time. And so understanding the complex and nuanced interrelation of all the legislation and regulatory measures we're looking at will matter, because we run the risk of generating new harms or amplifying existing harms should we regulate or pass laws ineffectively. So just to offer a concluding thought or two, I actually think the future of the internet is bright, notwithstanding all of the harms in front of us. I think one of the things that's most important to recognize is there are more individuals and more groups and more government agencies that are attuned to digital issues today than there were 10, 15, 20, 25 years ago. And while on the one hand, that means that there's an awful lot of people involved in the regulatory process, it also means that we have a more diversified and engaged group of diverse people who are trying to figure out what to do. It used to be that privacy was the issue on the internet, and while it certainly is, along with free speech, we increasingly see any number of groups say, actually, doxing is a real issue. The misogyny that is rampant through the internet is an issue. Competition policy is an issue. We are seeing a diverse set of voices, a diverse set of issues, and novel and new perspectives coming out, which gives me hope that even if we get some of the rules or regulations right now wrong, nonetheless, we will have a large and attuned and engaged cohort of public policy experts and governments agencies that take these issues seriously, are thoughtful about these issues, and hopefully can course correct any errors that are made. But broadly, I think what's imperative for us to really think about is these complex interdependencies between legislation, the intended and unintended consequences. And most importantly, what kinds of harms might emerge? In what ways might we only address the symptoms as opposed to the root of the harms we face today? And when we are only dealing with symptoms, we know they will simply remanifest in another format. Thank you.
Thank you so much, Chris. So, so many questions come to mind. The word double-edged sword is also flashing and clearly shows that managing the tensions is the challenge in front of us. We have one day today to talk about it. Clearly, it's a nice start, but it's huge. So my first question to you, Chris, is this. You talked about the issue of encryption, a double-edged sword, reminding me of the feud, if you want to call it that way, the tiff between Tim Cook and James Comey over breaking into the cell phone of the San Bernardino terrorist. And the whole question was, well, do you give law enforcement authorities, as you were mentioning, the capacity to act when they have to, versus Tim Cook's argument, if you build a back door, you build a back door for every cell phone and therefore expose everyone to this kind of intrusion. So my question, narrowing it down to this, Chris, is this. Where do you see the role of the private sector? You spoke of the rights ascribed to the state and the rights ascribed to individuals. In the middle, there's the private sector who holds the information that may link an individual to a harmful use of the internet. How do you see the role of the private sector?
I think that the role of the private sector is rapidly evolving, especially in the Canadian and American context. So to explain that a little bit, first, in response to some of the Edward Snowden disclosures, we obviously saw the corporate sector, or parts of the corporate sector, I should say, start releasing transparency reports to expose this is what we're actually doing. And here are the terms under which it happens. So we know that corporations have a role writ large in providing assistance to lawful requests from the state in order to, engage or assist the state in its evidence collection in investigations. But we're also seeing this expand in the near future. I mentioned there is the Cloud Act bilateral that's happening between Canada and the United States. And I think for a lot of Canadian businesses, once that is finalized, what they can expect is to get a lot more requests from government agencies. And so what's going to be imperative is that the legal teams that are parts of companies very carefully assess and understand the kinds of requests that are coming in and confirm that they are indeed scoped appropriately, such that individual subscribers are handled, their data is handled appropriately. But we're also seeing in Canada sort of a novel shift, I would argue. Colleagues of mine have said almost ISED is becoming a new regulator and setting aside the CRTC in some ways. And here you can look at proposed requirements on critical infrastructure providers that are federally regulated to adopt a whole new range of cybersecurity capabilities, as well as share information up with the federal government. And so here again, you have this interesting back and forth challenge with companies where they obviously need to provide security for their services, their customers, and their clients, while also they're going to be pulled to follow the edicts of government. And so I think the private companies are in a fairly challenging situation. They do the best that they can, but we're at a stage now where legislation is coming at them fast and furious. And that means that it's likely going to be challenging to say to government or to consumers, don't worry, we will regulate this, we have you, because it increasingly seems the government has come to the position of, well, we appreciate that, but it's not enough anymore. And so things are going to have to change. So I think we're going to see a lot of changes, and the role of industry is going to then be to say, hold on, not just oppose because we don't want regulation, but the regulation, the law, the legal mechanisms are insufficiently scoped, and then explain both to government and the public as to why, to improve the state of discourse, as opposed to keeping it in sort of closed Ottawa backrooms where much of this often takes place.
I'd like to underscore the importance, in my modest opinion, of transparency reports. In fact, just before I left the Office of the Privacy Commissioner of Canada, I tabled a special report in Parliament on precisely, and it was following up on Edward Snowden's revelations, precisely on ensuring that we had privacy protections in our system in relation to national security activities. And one of the recommendations we made was for organizations to issue transparency reports. And it was immediately bought into by the organizations because they said, yes, that puts the responsibility where it belongs, meaning the government who comes to us. And you used the word imperative a moment ago, with an imperative to provide information. Well, Canadians should know about that, and Canadians should therefore be empowered to make a decision as to whether they approve of that or not. So on that, or in relation in general to that regulatory framework, is there any country that you think is doing it right?
So I think for any number of the issues that we're looking at, there's lots of places we can cast our eyes around to. If you want to look at, where transparency reports done best is one example. I think you look at American telecommunications companies, in particular Google, Facebook, Twitter, actually have remarkably robust ones compared to what we often see in the US or seen in Canada, notwithstanding a few of the smaller ISPs that produce these. But I think what we're seeing in sort of a general sense in Canada is a casting about to other countries that are a bit ahead of us in developing and passing regulations and laws. And so I think, looking to Australia for how they're handling news or critical infrastructure in some cases, the UK and the United States certainly for critical infrastructure, Germany for online harms. You can just go through the legislative breadbasket over the past 2 years and you can sort of see the fingerprints of other jurisdictions on it. And that makes a lot of sense. There's no need to, rewrite everything that someone else has done. But I think one of the things that's imperative in Canada, and I really use that word very deliberately, is to avoid sort of just grabbing at another country's legislative policies without contemplating what it will mean in the Canadian context. What exactly does it mean to just, copy paste from Germany on some speech issues where they do have a different culture of speech and speech regulation than in Canada. And that isn't to, disparage the Germans by any stretch. It's simply to recognize that we do have a different political and regulatory culture. And so I think it's important that when we go through these processes, we think, what is the ultimate goal and how can we achieve that goal in a way that comports with Canadian jurisprudence and Canadian norms? And in some cases that may say, well, actually, we think that Canadian norms are, a little off kilter. We have a little bit too much balance towards the Americans, and the free speech in the internet is a bit of a problem. So we want to find ways of tempering the worst of it, but also recognize that we're making a choice when we do that. And I think it's a real challenge when we often say, well, the Europeans are doing X and therefore we should do it too. I think a lot of what's going on in Europe is excellent, but it's also a different culture and a different political and regulatory culture. And so we need to be mindful of what's different there from here. And in the process, critically assess what we're, not lifting quite, but substantively copying from, our allied countries and friendly countries.
So, building on the culture, taking into account culture, you were showing how we seem to have a different culture about rights on the internet and rights out on offline. So, for example, you spoke about how we have become accepting of capitalist surveillance. In fact, the very first investigation of the Office of Privacy Commissioner of Canada on Facebook in 2009 said we need to look at the issue of advertising online, and we will address that after lunch, in the context of a new business model where you get free access to a platform. Well, if it's going to be free, it's got to find a financial source somewhere, and that'll be advertisement. So there's, well, how slippery is that slope? Then you talked about consent. Well, can we really talk about consent online? So what I'd like to hear you on is, how do we then transpose in an effective manner these acquired rights or these notions that we've always had, but they don't seem to quite fit online. So how do we make sure that we transpose them while still preserving their essence?
So I think, on the topic of consent, one of the, at the Citizen Lab, one of the projects that we do is we file requests for our personal data on companies all around the world, or that have a substantive commercial connection to Canadians. And the response is highly variable. But at least in those situations, we have some inkling as to where to go. We've signed up for the services. We know to send a request to an airline or to a dating company or to a fitness company or a telecom or whatever the case may be. But we've moved to a point where data is moved with such frequency and in such opaque ways that individuals, even if they're trying to use their access rights, frankly, are frustrated. And more to the point, when information comes back, it will often be so general that it's not helpful. There's an empowering element to that. I know that there are classrooms across this country that use our tools as a way of educating. This is the kind of data that's available. So one of the ways that I think that we can, try and address these issues is to make knowledge an increasingly important element of how this works. And you can look at suggestions and advice from DPAs in Europe, as well as what some companies are frankly doing in Canada, to try and have the legalese, because the lawyers definitely need to be there so that you're legally protected. But on the same page and in a separate column, they boil down, this is what this actually means, what we're actually doing. I think that that's empowering for the individuals that care, and it also ensures that everyone within companies and external to companies knows what are going on. And then, you could get a situation where, imagine Tim Hortons had been a little bit more upfront about the ways that they collect and share data. Well, you wouldn't have had to have an enterprising journalist dig it up. You would have had a university student who was writing a paper and then gone to the news. That would have happened years ago. And I think that we are at a stage now that, while we have an increasingly online population, that isn't correlated with a technically savvy population, and we shouldn't expect that population to exist in order to police their own rights. We don't expect every person to know how to, machine parts in an engine to drive a car. And we shouldn't have a similar expectation today. Rather, services that are provided by companies should be open, they should be transparent, and there should be decisions made as to whether this should be a free service. Will it be based on advertising and data brokerage? Is that the economic model? Or do we need to move to a different model where there is more people paying for services? And I think one of the real challenges of the internet ecosystem today is, to what extent should advertised drive everything? Is that the way that things should operate, or should it be increasingly paid services? I think back to what has replaced a lot of the pre-1.0 services, news, cable channels, and the rest, and their revenues have been devastated. Were those better systems? I think you can agree or disagree about the quality of paper as what was written in them in the past. But I think similarly, we've had that transition. We may be in another transition now. We've gone to free. Was that the best decision? And if we're going to continue data brokerage, how do we do it in a way that empowers and provides agency to individuals, as opposed to deprives them at a legislative and technical level?
Thank you so much. Chris, you know that I could go on talking to you forever, but we do have to close to move on to the panel precisely on online streaming. You mentioned a moment ago copyrights, and my colleague Monica Song is there to moderate that panel. Listening to you, I see 2 points going forward: focus on digital literacy and transparency. And so I definitely take note of that and believe that that is a good way, it seems to me, listening to you, to focus our efforts. Thank you so much. You really have laid the ground for our discussion for the rest of the day. We are so privileged to have the benefit of your decades of research and really an amazingly clear presentation this morning. So many thanks, Dr. Parsons, and I will now move to my colleague, Monica Song. Thank you, Chris.
Thank you.
Thank you, Chantal and Dr. Chris Parsons for that very engaging opening presentation. I'm waiting for my panelists. Good, so we have our panelists now joining us. I'm delighted to be joined today for this first panel of Regulating the Internet Really, Part 3, joined by two leading intellectuals in the area of internet law to talk about Bill C-11 and the Government of Canada's impending reform of broadcasting legislation in Canada. Just briefly, Dr. Michael Geist is a law professor at the University of Ottawa, where he holds the Canada Research Chair in Internet and E-commerce law. He's completed graduate degrees in both the UK and the US at Cambridge and Columbia. Prolific columnist and book author. He has written numerous books on copyright. He has served on, or he is currently serving on boards and has received numerous civil and academic awards for his work. Dr. Emily Laidlaw is a law professor at the University of Calgary, where she is Canada Research Chair in Cybersecurity Law. She has also completed graduate degrees in law at the London School of Economics and has privately practiced as a litigator in Canada before turning to academia full-time. Dr. Laidlaw, as a scholar, has actively contributed to law reform and other advisory work, and most notably, she co-chaired the expert advisory panel on online safety appointed by the Government of Canada. But that's not what we're going to be talking about today. Dr. Laidlaw has also been recognized as a Peak Scholar for the impact of her work outside of academia. So we're extraordinarily privileged today to have with us two academics, but two extraordinarily engaged academics, if I could put it that way, to talk about the regulation of online streaming in a free and democratic society. So with their permission, I'm going to be referring to them both as Emily and Michael. So that's what I'll do, but the audience, I think, recognizes how deep the expertise and knowledge of our panelists are this morning. Okay, so just to start things off, I'm going to set a bit of the background and current context of Bill C-11. Bill C-11 is a bill of the 44th Parliament. As probably most participants in the audience would know, it was preceded by Bill C-10 of the 43rd Parliament, also entitled An Act to Amend the Broadcasting Act and to make related and consequential amendments to other acts. Bill C-10 died on the order paper following the call of a general federal election. And so C-11 was introduced in only February of this year. It progressed very quickly through the House, including in the Senate Committee on Canadian Heritage, Patrimoine Canada, where it emerged in June of 2022. And since that time, The Senate has been reading and studying this bill, including a pre-study process by the Senate Transport and Communications Committee. The study by the Transport and Communications Committee of the Senate is ongoing. It's not known yet whether the work of the Transport Committee and the resulting report of the Transport Committee will be available before the Senate rises just before the Christmas break. But to set the stage, that's where the current bill lies. So the government is obviously pushing this bill forward as a priority with some haste. The Senate has taken the time that it needs to deliberate on it, and many witnesses have come before the various committees and of both the House of Commons and the Senate to testify, including both of our esteemed panelists. So this conference is dedicated to promoting discussion and debate around internet regulation, and the title of this opening panel is regulation of online streaming in a free and democratic society. We know from the preface or the summary of Bill C-11 that, among other things, it seeks to add online undertakings as a distinct class of broadcasting undertakings, and seeks to ensure that these undertakings make the greatest practicable use of Canadian creative and other human resources in the creation, production, and presentation of broadcast programming. It also intends to apply to social media programs uploaded by users if the programs are prescribed by CRTC regulation. And the bill proposes to update the broadcasting policy for Canada to make room for currently underrepresented segments of Canadian society in the Canadian broadcasting system. So perhaps we can ease into this topic this morning by a general question, perhaps a slightly normative question of what does this bill get right, and where does it tread on dangerous ground in your study of this bill?
All right, Emily's pointing at me, so I'll start. Sure. So thanks for that, Monica. It's a real pleasure to join both you and Emily on the podcast. It's a topic obviously I've talked a lot about, and you're two of the best people to talk about these issues. You've both been on my podcast, so it's fun to get to talk again in this context. Yeah. So, well, anyone who's followed this or who has followed anything that I've had to say for the last while on C-10 before and C-11 now will know that I've been pretty critical of the bill, and very critical, I guess. And generally speaking, I must admit, I don't think it gets a lot right. You know, there are some, I think the fact that we are examining the Broadcasting Act and seeking to update it, I think is a very positive thing. I think the fact that definitions of CanCon appear to be part of the scope of what might be reconsidered, I think is a good thing. And I think the general intent of saying that we recognize the broadcasting world has changed, and so we need to bring internet-related services or provide greater certainty about how we might regulate those services, I think is a good thing as well. I would say, though, that my list of what's not great about the bill is far, far longer. We'll talk more about user content, I'm sure, soon. And so I think that the fact that it extends the scope of broadcast regulation, I would argue, into user content in this way, which I see as just a core expression issue, I think is enormously problematic. I'm also, I must admit, not wholly convinced that its approach to some of the large streaming services is ideal either. That's not to say that I don't think there isn't an appropriate role for regulation of large streaming services, but it has such an aggressive approach with respect to a jurisdictional approach, basically saying that any service anywhere is theoretically subject to this. And the notion that somehow Netflix is indistinguishable from, say, CTV or Global, and so we ought to regulate it in the same way. I just think is wrong. And that's not to say that there shouldn't be some kinds of regulations on some of those services, but they're not the same. And the notion that this is creating a level playing field, I think is false. But there's lots more to talk about. I'll just close my opening by saying that, the ship has sailed on some of those issues. But where some of these issues still remain, I think, front and center, certainly before the Senate hearings that you talked about, especially is sort of those broader implications around internet regulation, particularly individual speech.
I agree with everything that Michael just said, and so I might not dwell on it. I actually liked the question where you flip things and ask what got right, because it made me pause to try to think through precisely where they might have hit the mark. And I'd say that at this stage, the objective of modernizing broadcasting legislation and regulation generally is critical. What has caused concern for me is all the subjects that Michael mentioned that we'll be diving into. In particular, the area that I look at so much is user-generated content and social media, and so that's really my entryway of interest with Bill C-11. But what has given me more general pause about this is I don't understand why, when this is so critical to push forward, that we need this modernization, there hasn't been more thoughtful discourse and kind of engagement with some of the feedback about the concerns about, the regulatory structure, how this intersects with internet regulation more generally. How this really is quite different when we look at different types of platforms like Netflix, or when we're trying to think through, what TikTok is and whether it fits with any of this at all. Because, there are so many implications and ripple effects. And I think that Chris in his, remarks this morning was noting just all these different legal developments going on. So it's not just about Bill C-11, it's about all the different bills that we're going to be talking about with this conference today, and they intersect in some ways that might be unpredictable, but we kind of need to think through.
Mm-hmm. Mm-hmm. All right. Well, thank you for those opening thoughts. I guess we may as well get to wrestling with the biggest elephant in the C-11 room. Which is user-generated content. I think everyone will remember that in the era of C10, the elephant then was the notion of taxation of online streaming services that consumers so dearly loved and have adopted. But it seems like that issue has receded, and instead it's been taken over by the debate, much of it public and in the public sphere, on the apparent foray of the government in Canada to regulate user-generated content, or more particularly the platforms that are home to user-generated content and the exchange of user-generated content. So, for sake of argument, let's just not debate the question of whether or not the government is purporting to do this. Let's just accept, for our purposes today, that the government does intend to regulate the services that host user-generated content, and that therefore user-generated content and the individual programs of user-generated content may be indirectly regulated by the government, in particular the CRTC. Now, just by way of reference point, under the current Broadcasting Act, the CRTC has passed regulations pursuant to which all programming undertakings that control the content that is carried on their programs are responsible for said content, regardless of whether the programming undertaking is a source of the content. Now, again, just to provide a touch point for our discussion, I think it's noteworthy that there's a proposed section sub 2.2 of the new Broadcasting Act would provide exactly the opposite, as I read it, in the case of online undertakings that provide a social media service. So proposed section 2 sub 2.2 would provide that an online undertaking that provides a social media service does not, for the purposes of this act, exercise programming control over programs uploaded by a user of the service who is not the provider of the service or the provider's affiliate or the agent or mandatory of either of them. So this deeming provision is then carried over, again, as I read it, to proposed section 9.1, which empowers the commission to establish conditions of service, and section 10, which gives the CRTC regulation making power, which I'm sure we're going to be talking about at some length later on, or at different points in our talk today. So with this backdrop, and I know both of you have strong views on the issue of user-generated content under the Act. What's at stake here?
You know, if it's okay, I almost want to pull the discussion back first, because to get into what's at stake and to get into some of that minutia, I think, of user-generated content, we almost need to think first about what it is that we're trying to regulate here. And I think that the starting point with broadcasting regulation is that you know, it's always been exceptional in nature. Like, the justification for this type of regulation and the impact it has on freedom of expression has been about points of, you know, promoting and protecting Canadian culture. It's about spectrum scarcity. It's also been just about basic points that things like television and radio were kind of pushed into your home in a way that individuals didn't really have as much control over in the same way they would have in picking out a newspaper that they want to read, or picking up a pamphlet, or whatever else it is out there, right? So broadcasting regulation has always been somewhat extraordinary in nature. And that means that it's not light touch regulation in the least. That's just not how it operates. So what we're looking at now then, of course, is modernizing it in the context of kind of the new consumption and creative space that exists now with the internet. Fine, this kind of modernization is absolutely key. But it's really difficult to layer on top of internet regulation, which has, you know, certain driving principles behind it that, you know, we have to be faithful to, which is that the internet, generally speaking, has been open, right? It has been a space that is relatively free-flowing, that has been innovative and encouraged different types of kind of creativity, and it has been global in nature. And the global aspect of it is so important because, you know, I sympathize with the arguments in response to this, where we say, well, it's global in nature. We have to think through what the impact of Canadian law would be globally. And some of the responses are often, yeah, but it doesn't mean that domestically we can't pass laws on this. That's absolutely correct. It just has to be done delicately and sensitively to what the potential impact might be and how that might interact, right? So if we impose laws in Canada that are, you know, deeply focused just on Canada, it might have a negative impact on creators that actually have global audiences, for example, and we might get into digital first creators in a little bit. So it can have this ripple effect, and we have to think through not only in terms of, well, how does this work with other trade agreements, but, how does this disrupt the internet ecosystem generally? And so I think that from there, that then becomes a key point once we start trying to dig deep specifically on user-generated content, because I think that there's the internet regulation discussion point, which we can have there about what happens when you try to regulate TikToks and YouTubes in this nature. And then we have a very kind of legal discussion we can have about how does this comply with the charter and the right to freedom of expression? Would this actually survive a constitutional challenge?
I'll pick up that. I mean, I think that those are great points, and I think that for a bill that has spent so much time at committee, especially at the Senate, the lack of discussion around some of those questions, I think, is inexcusable, quite frankly. I'm struggling to even know where to begin because there's a lot to say, but I want to pick up just on, I guess, a couple of things. One, I must admit, I don't want to let the government off the hook so easily and to sort of say, this is what's an intent. I'm willing to give, benefit of the doubt as much as possible. But if we're honest about it, the Heritage Minister has not been honest about this. And I find that exceptionally disturbing because so many creators, quite frankly, have come forward, not just the platform, but creators, other experts, all made it very clear that their read of this is pretty plain in terms of the fact that the government has left the door open to the CRTC to establish some conditions and regulations over user content. And so the government's insistence that there's nothing there, I think, not only undermines the process and public confidence in the legislation, but I think it's caused enormous harm to the CRTC. And I'm not one that typically is out there trying to defend the CRTC, to be sure. But there was a piece in the Globe and Mail over the weekend talking about TikTokers and YouTubers who have been successful who are now contemplating leaving the country if this passes as is. And we can get into why, if you like, why that would be, why the approach of imposing discoverability rules onto user content actually is likely to cause significant harm to those creators. And I think it's an important point that clearly has been lost on the government. But in that same piece, you had the CRTC say they hope TikTokers follow the website and participate in the process as they establish rules around registration. I should pause there to say, literally, we have the CRTC talking about people who post TikTok videos contemplating registering that content with the CRTC. This alone is craziness. But beyond that, in the same piece, you've got the Heritage Minister saying, oh, no, there's nothing to see here. And I think, we've seen that regularly, where the minister says there's nothing to see here. Ian Scott, to his credit, has appeared multiple times before committee and made it clear what the legislation says. Same on algorithms, where the government says algorithms aren't touched. Scott says otherwise. You might want to know that just in the last 2 hours, the Senate committees put forward its calendar for next week, and that it includes an hour and a half with the CRTC again. And so I'm pretty sure these questions will come up again. The CRTC will answer them truthfully again. And so I think Scott and the CRTC have been put in a very difficult position because they read the legislation as I think most people read it, and the government has turned this into something that it's not in terms of some of their answers. And I think that really hurts our broader policy objectives. I can stop there if you want, but if we have time, I really do want to get into this question because it's not intuitive for people. It's not always necessarily intuitive for everyone as to why the imposition of what are called discoverability rules on user content actually are likely to backfire on many individual creators, and why so many of them are speaking out.
Yeah, no, I think I'm going to let you continue, but just to interject one clarification. So what I'm hearing is a concern about discoverability rules potentially being imposed on user-generated content platforms, and freedom of expression concerns, and I just want to clarify whether in both of your minds those two issues are flip sides of the same coin. Are those related concerns? Is that the principal concern? And that's sort of what I was driving at when I asked, what's at stake in this discussion about user generated content and whether they should be regulated under this extraordinary piece of remedial legislation. So maybe you just answer that and then carry on.
Sure, I can answer. Well, I'd be happy to. I think that they are certainly correlated. I think part of expression is not just the ability to speak, but the ability to be heard, and the ability to be heard can be maybe negatively implicated by some of these discoverability rules. So I do think there's quite clearly an expression piece. I think, as Emily pointed out, broadcast regulation is speech regulation, something that was seen as necessary in a world of scarcity. I think that we haven't seen a compelling argument as to why we should extend those same kinds of principles into a user content world. But I also think some of the most successful people involved right now in Canadian culture are at stake. If we had well-known Canadian singers or actors saying, we're really troubled with what the government is doing with a piece of legislation and we're thinking about moving, I don't think the response of the heritage minister would be to say, oh, they got nothing to worry about and there's nothing here. People would be paying attention and saying there's something wrong if we are literally raising the possibility of driving a really fast growing part of our cultural economy out of the country. And yet that's precisely what's happening. We see the heritage minister denying it. We see the ISED minister, ISI minister Champagne, who clearly is focused on digital economy issues, silent as if this is not his issue at all. This is like an alarm bell that is ringing. And if we are genuinely concerned about the so-called telling Canadian stories and a successful cultural economy, we have people who are right now some of the most successful in this sector, drawing global audiences, exporting the Canadian story all around the world. And they're saying, if you go ahead with this, we don't know if we can continue to practice our craft in Canada. That's what's at stake.
Well, if it's okay if I jump in here, I think that one of the issues here, I agree with Michael here that it's the idea that this is all correlated, right? And I think one of the issues that we need to unpack, and maybe we can do a bit here, is we toss around the idea and this word freedom of expression without then digging into the different ways that it's implicated, right? So the freedom of expression at its base is the idea that you have the right to seek, receive, and impart information and ideas regardless of frontiers. Like, this is the basic right. So it's so it has a lot of elements to it. It's the idea that you can search out information, that you can receive that information, that you can impart those ideas. And so when Michael is exploring these ideas of discoverability, the specific regulations that have been put in place put rules around what can be sought and received and how these creators can then impart their ideas. We at least can acknowledge up front that this is a form of speech regulation, and then it can be a discussion point about, are there, is this justified in some way? Is the objective strong enough, and is it correlated to broadcasting regulation? But we never end up getting that far. I mean, there are people trying to have these discussions, and Michael has done that very actively from the beginning, right? But it's not being engaged with. It's just, well, this has nothing to do with freedom of expression. And I think one of the first steps to talk about is, what precisely are we trying to regulate here when we're looking at user-generated content and social media? The Act doesn't even define social media, which is in itself problematic because social media is just a million different things, right? Are they really just writing a law here that is a YouTube law, right? Or a TikTok law? Okay, because then in not defining social media, they could end up capturing all kinds of different kind of audiovisual content that wasn't intended, and creates a real regulatory burden for the CRTC, where so much of this has been kicked to sort of figure out later what is in scope and what is outside of scope. But there's the base question too about, why exactly is user-generated content captured here? Like, what precisely is the objective? And I think one issue is thinking through the different roles that these players play, if we can call it that. You know, they're not always acting in the capacity of a host of user-generated content, right? So, I mean, I'm strongly of the view that all user-generated content should not be included in this legislation. It makes absolutely no sense given the way the internet works. But let's think through precisely what is being targeted here. I mean, there's different capacities of the YouTubes of the world, and to the extent that they have different, you know, contractual relationships or licensing arrangements, this is with particular users who post. I don't see that as user-generated content, strictly speaking. I don't even think it fits into that category. This is commercial content that they have some sort of contract, that they've set out certain rights of access to. There's a commercial arrangement, fine, right? But the different sort of organic nature of the content that people post, even if it's monetized in some way, I mean, some Canadian version of like the Holderness family or something, right? Are they suddenly going to be captured by this? Yeah, presumably. But why? Like, why would they be captured by this? Because they don't fit the traditional notions of broadcasting. So the objective has to be clear about what the target is of them, and, you know, what qualifies as generating or not generating revenue. And a lot of people who post this type of content, I mean, they start doing it personally. Some of it's sort of professional, some of it's mixed together. Sometimes they start figuring out, hey, I can kind of make some money from this. Like, it's not clear, that line between one thing or the other. And why? Because this isn't some kind of television program. This isn't some, you know, finely tuned piece until it reaches a certain level of commercial activity. And even then, it's really hard to compare that kind of user-generated social media content. And, you know, you think of the millions of posts that are out there to this sort of slick production and control that we're talking about when you think of traditional television and broadcasting.
Okay, so there is a ton to unpack, but I guess the key message is the key message that I'm hearing from both of you is that you think that there's a lot of unorthodoxies here, and that there is a lot that has been miscommunicated or is unclear. Including what is the objective being pursued by purporting to capture user-generated content platforms or services within the scope of the act. I take your point about the lack of clear communication or selling by the government of its proposals in relation to this. You know, I'm struck by, you know, section 9.1 sub 6, which clearly states that, you know, the discoverability provisions in 9.1, 1A to D are not supposed to apply at all, right? The discoverability powers are not supposed to apply at all to programming that the platform doesn't control. And then if you cross-reference that to, you know, section 2.2 or 2 sub 2.2, I think that's the link that I guess completes the exemption from discoverability regulation for user-generated content platforms. Similarly, you know, on the theme of free expression, the Commission has a wide power, which we can unpack if we have concerns about that under section 10. But section 10(1)(c) is clearly within the drafting, within its existing drafting, clearly states that, again, 10(1)(c) is not to apply to programming over which the service has no programming control, which I think must be a reference to user-generated content or social media content. I completely agree with you that it's highly unorthodox to not define a term like social media in a piece of legislation like this, but that if that's the intent, perhaps it doesn't seem that the government has actually effectively communicated that, okay, it's not discoverability, it's not to impose content standards. And so what's left, I guess, is some kind of funding, some sort of funding obligation on the part of user-generated content, or so-called social media services. But if after 9 months of constant debate and untold witnesses coming forward, that hasn't been communicated and that hasn't been debated or scrutinized, then there's clearly a misunderstanding about the scope of this legislation. But just to close out this topic, and before we move on, can I put it to you then that in your view, the definitions in the Broadcasting Act should make it clear that none of these types of services or content should be regulated, and then just close that chapter? Or do you think like this very convoluted exception, exemption, definition of no programming control type scheme, which is the approach that the government seems to want to take with respect to user-generated content, could work? Is it a question of it's just not done right, or is it a question of no, this type of service should just simply not fall within the definition of broadcasting?
No, we can come to the question of whether or not it should fall within the definition. I'm sorry, but respectfully, my read is very different of the bill. Section 9.1, the discoverability provision, is 9.1e, involving the presentation of programs and programming services for selection by the public, including showcasing and discoverability of Canadian programs and programming services. People should understand that the definition of programs is really anything. It's anything any audiovisual content. And so in fact, this provision is even more than just discoverability. Discoverability is an example of the CRTC power. It extends to presentation of program and programming services, which could of course extend to things like requiring warning labels for certain content, or even demotion of certain content in the way that it's promoted. It isn't just about CanCon. But more to the point, Monica, you referenced sub 6, which you said then takes it out. It doesn't. Sub 6 says orders made under any paragraph 1A to D. It doesn't cover E. It doesn't cover the discoverability provision. And so my read of this bill is apparently pretty different than yours. It is fundamentally about the content. And a number of times I've heard you say platforms, you keep inserting it. It's about user-generated content platforms. Sorry. The platforms will be forced to execute on some of these issues. The content being regulated are the individual content themselves. TikTok's analysis says it's any video that has music on it, as an example.
Well, and I think that raises the issue that I'd love to dwell on for a second, which is these key insertions about the commitment to freedom of expression, and that this is a priority in any interpretation or exercise the power of the CRTC or any interpretation of any provisions in Bill C-11. Fine, but that doesn't give me a lot of comfort here that on the ground, that tells us what to do. For one thing, the fact that all user-generated content by default is a program, and then there are exceptions that sort of remove it, is just totally unprecedented. And it's frankly inappropriate for that to be in broadcasting legislation, period. And I think that itself might be a real constitutional hurdle for this legislation if it was challenged, because there'd have to be some sort of justification to use exceptional broadcasting legislation to scope it all in to begin with, to then sort of create these exceptions after that. What is the basis that all the different ways that we engage and participate in the world, which now happens to happen online, is suddenly scoped in, but we'll create exceptions. And as you can see in the discussion between the two of you, all kinds of different confusion and like uncertainty about what's in and out, uncertainty about the power of the CRTC. But more fundamentally, just tossing out the word freedom of expression as though we clearly know in law what that means to be able to tell us the scope of these provisions is not true. And I think one of the issues that we have in Canada is that our jurisprudence on freedom of expression isn't particularly developed. And it's in particular not developed when it comes to exploring what the meaning and the protections and limits are when it comes to low value expression, right? And I say low value expression because we say, okay, we can point at political speech, or we can point at different types of speech and say this has high value, right? But when working through that jurisprudence, the courts tend to almost select values because it's not done at the first stage of Section 2B. It's just sort of this proportionality analysis. Now, none of this is about broadcasting right now, but it is about understanding the breadth and the limits of the right to freedom of expression. We now, where is the everyday ways? How are the rights that we express ourselves when we post low value TikTok videos, maybe that have a commercial element, in this sort of space? We don't know, right? And when we try to then transfer that to something like broadcasting legislation, which is then reaching into the arm of social media, we really are in territory where there isn't a lot of guidance. So then saying, oh, but we should take account of freedom of expression really enables regulators to hide behind the cloak of proportionality and freedom of expression in an environment which is still really about selecting values, right? They end up selecting values, but there's no principled basis for that analysis. And that's what's worrying me right now.
Okay, I truly appreciate like getting into it with you both. I think you raised some issues that are relate basically to the structure of this legislation and that go to like the whole scheme of the act and how it's designed, and that certainly goes beyond just this issue of the provisions that relate to social media. But do we have time for just your quick thoughts in okay, if it's not broadcasting legislation where we should be dealing with UGC because not all of it is even is broadcasting audiovisual. What, if anything, about UGC do you think should be regulated, and by whom? Quickly, if I can get you to do that.
I got excited and didn't unmute properly. Platform regulation is like its own field of law, right? And so I think we need to stop thinking about it as like one silo, right? We have to think of it more in terms of, I mean, it would be almost looking at like tort law or like contract law that delves into all these different areas. And one of the most, so what we need to look at and say is, well, there's a competition law element. There's a privacy element here too. There's an online harms element to this. And that to take on platform regulation, which we absolutely should, it really is about looking at the entire landscape of all the different laws that are engaged in like national security legislation, et cetera, to say, where are the different spokes of responsibility and how do we kind of develop this in a way that makes a lot of sense? I think one of the most concerning things I've seen with Bill C-11 debates is where you see a bleeding of topics where individuals argue that, oh, platforms aren't accountable, hate speech is bad, and that means we can justify it through this one step in regulation and broadcasting legislation. And that's absolutely incorrect. We need to be dealing with this specific narrow area of the law that we need to be engaging with and then go from there.
Yeah, 100% agree. Listen, there's already regulation on user content. Copyright law applies to user content. Hate applies to user content. Defamation applies to user content, like it applies to anything. But your question seems to presuppose, is there a role for broadcasting regulation on user content? And my answer would be no. I mean, should this Zoom be regulated? You're broadcasting to large numbers of people who are watching this. Should we have a CanCon requirement? I mean, you have Canadian speakers. What if you brought in non-Canadian speakers? Is there any reason at all that the CRTC should have a role for what I say or what you say or what anyone has to say as part of this broadcasted event? And the idea that we would bring it into that system, even if it is viewed as potentially competitive, still strikes me as a non-starter, because it moves us directly into basic rights of expression, for which the CRTC nor the government should not be stepping.
Yes, our news and information programming. All right. Thank you so much. Let's move on to, because we've only got 15 minutes left. So let's move on to looking at this broadcasting legislative proposal and its intended effect on large online undertakings that provide their own programming. So there's proposals to impose discoverability requirements, funding requirements, exhibition requirements with respect to CanCon, which the CRTC has yet to define. So what is any of this controversial, or should it be controversial in your minds in the context of professionally produced audiovisual content?
Well, I'll start by saying well, it depends which. I mean, you laid out several different things. I don't know. We're at the point where if this was nothing more than saying Netflix needs to put a banner with Canadian content, or a bar that has Canadian content, I don't think anybody is going to get too worked up about it. If this was exhibition requirements, quota that required a certain amount of Canadian content, absolutely. The simple reality is there isn't enough good Canadian content, all respect to great Canadian producers, for Netflix and Disney and Amazon and all the other streaming services to be able to license without having the effect of forcing them, frankly, to limit the scope of what Canadians are able to access. Because it can't sit alongside, if you have, say, a 30% requirement, for example, of Canadian content. And I don't believe that we've seen a few groups who have lobbied for something along these lines, but I'm hopeful that that's not what the government has in mind. But if they were to require, let's say, a 30% CanCon requirement, there isn't enough content. Netflix has got a 5,000 to 6,000 title library. You're going to tell me that they can find 2,000 titles of Canadian content that are worth licensing and available to license, and Amazon can do the same and Disney can do the same? Of course they can't. And so the effect of that kind of requirement, when you have services that are not like broadcasters, that's part of the problem with this thing. They're not the same. And so the idea that you'd impose in your library, you have these kind of exhibition requirements, you can't force people to watch it, even though sometimes before the Senate, you do hear senators say, we would like to force it. They don't get enough of it. Keep making an analogy that, they get their ice cream and they're not getting their broccoli, and somehow Quebec music has become broccoli. I don't think it's a particularly apt analogy, but the idea is we should be able to force people to listen or to watch things. I think that's a non-starter, and requirements that might result in forcing services to remove user choice, because they effectively, the CanCon exhibition requirements set a threshold on how much non-Canadian content you should have, should absolutely be controversial.
Yeah, Emily, do you have anything to add?
No, I don't really have much to add to Michael's comment, so I might leave it there.
All right. Well, how about let me put this to you. So Bill C-11 does not purport to say how the exhibition requirements, discoverability requirements would have to be implemented. But it does suggest that the CRTC would have the ability to determine it may impose these kinds of requirements. Now, as I understand it, C27 proposes transparency as an organizing principle of the oversight of artificial intelligence and dealing with personal information. So, on the theme of looking at these issues of internet regulation, proposed internet regulation holistically, how do you see any potential conflict between, say how discoverability mandates under Bill C11 would apply to online undertakings versus the proposed amendments to privacy legislation? Or is there some way to reconcile those?
So I would say that this is a difficult one, and I know something that we were all talking about, right? And I would say that there are a lot of unknowns right now, right? So the AI Act, with Bill C27, it's pretty empty, right? Everything is left to be dealt with later in regulations. But what we do know is that as a regulatory structure, it's targeting high impact systems. And so my first reaction is to think through, were you asking specifically about the AI Act element of it?
Sure.
Yeah. Sorry, that's where my mind was. And I realized that maybe it wasn't your specific question about it, but because I keep thinking about if there's specific algorithmic requirements that are going to be imposed out of this, right? And how is this going to work? Well, you would have essentially a minister and potentially someone underneath them that would have oversight of high impact systems. So to the extent that it might be high impact system, they might cross wires with what the obligations might be under Bill C11. So high risk of this happening, maybe not entirely, but the process, the structure of who has power, how it will be exercised and in what direction, that is where there might be some sort of difficulty. And I've seen I've had the same questions about the intersection with online harms, right? The second that you start taking on these sort of algorithmic systems, but you're splitting oversight and the risks of monetary penalties across these different parties with oversight over the same system, that is a recipe for chaos.
Yeah. Okay.
Yeah, I agree with what Emily had to say, especially with the intersection with C27. I'll just say on the issue of algorithms and C11, there's, I think, two quick points to make. One, government, it's another illustration or another example of the government saying one thing and doing something else in the bill. So it says algorithms are out, and there is in fact a provision that talks about the CRTC not being able to dictate specific algorithmic choices. But when Ian Scott appeared before Senate committee, he made it clear that, well, no, of course algorithms are still in. They're not in the sense that I can tell a platform what to do with its algorithm. I think the way he put it was, I won't tell you what to do with the algorithm. I'm going to tell you to fix the algorithm. So not specify the algorithmic change, but specify that there should be effectively an algorithmic change by the platform. It strikes me as a distinction without a difference, and I think it was understood as such. So it does get into that. And that does allow me to very quickly note that the way these algorithms function, especially for user content, is likely to be exceptionally harmful to Canadian creators. Because if you do have the CRTC effectively mandating algorithmic change in what people see in their TikTok or YouTube feeds, leaving aside that it's at this stage, we don't even know how you identify what's Canadian or what isn't. But those feeds are driven by user interest. They're not driven by a regulatory fiat. And once you start inserting regulatory choice into what people see in their feeds, it's likely that it's going to be some content that people just aren't interested in, because frankly, the platforms know more about what people are interested in than does the CRTC. And if that's where we find ourselves, people are not going to click on that content, or if they do, they won't watch it to completion. The signal sent to the platforms is it's not good content. And the impact of that for Canadian creators is that it gets demoted on a global basis, because when presented to people, they haven't watched it. And so that's why there is this huge risk of trying to take something that seems like, well, why shouldn't we want to try to promote Canadian content? To recognize that it's a fundamental misunderstanding of how this internet-based content and algorithms intersect, and what happens when you're trying to deliver to a market not of 35 or 38 million people, but of 2 billion people. And the impact for Canadian creators, quite frankly, could be devastating.
And let me piggyback on that, because I think that's such a crucial point. And I think it does tie back to the freedom of expression point, because one thing that I have been wrestling with here is, is this a form of almost compelled speech, right? That this, we're not, regulating the algorithm, but we're regulating essentially the algorithmic output. So are you mandating then almost like tobacco health warnings, right? Is this sort of like this algorithmic output that is an important health warning telling Canadians that, smoking is really bad for you, right? And as we know, it was, the first case on that found that it was unconstitutional to impose those types of health warnings. And then the second case held that they were constitutional. But what was interrogated so closely by the court? It was, how important is this objective? What is the objective? Does it actually achieve those goals? Like, is this narrowly scoped in a way that is delivering on these pressing and substantial objectives, and done in a way that is proportionate? But that is then where I think Michael's points about, it's not just about Canadian, pushing Canadian content, is then the impact on these Canadian creators, that it's going to backfire. These then become those really important points about it, making it much more difficult to justify compelling a certain result by these providers. So I will leave that there.
Thank you for taking. Yeah, I got bumped off, but thank you, because I think you have led the discussion to where I want to go next, which is to link the algorithms and regulation of algorithms to freedom of expression issues. I don't see any questions from the audience, and we have just 3 minutes left. And so I want to give you an opportunity to touch on a theme that you both referred to in your opening there, and that's extraterritoriality and the ambition of this bill to apply to online undertakings wherever they may be. So that Bill C-11 doesn't expressly state that it will have extraterritorial effect. It is a piece of federal legislation. And so, it can state that it has extraterritorial effect. It does not state that, but it's arguably necessarily implicit that it will have that effect. I note with interest that the CHPC committee did amend Section 3 sub 1A of the Act to provide that the Canadian broadcasting system is a single system, and that it does include foreign and online broadcasting undertakings, and that the expectation is that they will contribute to the implementation of the Canadian broadcasting policy. I know that you're both probably familiar with the USMCA digital trade provisions, the cultural exemption. I guess there's a rule with an exemption and then a further exemption. But quickly, can the audience have your thoughts on that aspect of this legislation?
I'll just very quickly respond by saying the overreach is frankly stunning. And it will, I guess, fall to the CRTC to establish some kind of rational limits. But the starting point is that this applies to everyone everywhere. And the idea that somehow our regulator that our government should be saying our regulator has that kind of power over any streaming service, literally anywhere in the world. And we should note that there are many services that are niche or that are servicing particular communities, especially in a domestic level outside of Canada, but still may have some Canadian subscribers, may touch Canada in some way. The government repeatedly voted against any attempt to create thresholds in the legislation that would have made clear exemptions of certain kinds of services. So it wanted to reserve that kind of flexibility. And I think it's a mistake, in part because once you start moving into a world where if Canada says we have jurisdiction over everybody anywhere in the world when it comes to a streaming service, there's nothing to stop other countries from asserting much the same kind of thing. And that's not to say that we shouldn't be asserting jurisdiction over those services that have a direct impact, a material impact in Canada. But I think it fell to the government, or should have fallen to the government in this bill, to provide greater guidance into how they might define them.
Yeah, I agree. And you know, if we don't want this to be the blueprint for a law elsewhere that will negatively impact Canadian creators, then it should, you know, cause some reflection about whether we want that in Canada, right? And I don't think we do. I mean, the ripple effect of this is going to be negative. In terms of trade specifically, I wrestle with that, and I guess the premise is the idea that they're, you know, facilitating these cross-border data flows, and this manipulates this in a different way. That may be legitimate. You know, it might fail for other reasons that we've explored this last hour. But I would be turning to a trade lawyer, because I think it's almost a very specific question about, look, is this legitimate or trade distorting? And on that point, I'm not certain what the answer is.
All right. Thank you both so much for being so engaged in this discussion that you have had many, many times over the past a year, maybe longer. I'm going to now pass the baton on to my colleague, Julie Fashion, to discuss the feasibility of reforming privacy law while continuing to foster innovation. Thank you both so much, Dr. Laidlaw and Dr. Geist.
Thanks, Monica, and thanks, Dr. Geist and Dr. Laidlaw, for a really interesting discussion about online streaming. I'm, as Monica said, I'm Julie Fashion. I'm counsel in the Dentons Litigation and Dispute Resolution Group in Vancouver, and a member of Dentons National Privacy and Cybersecurity Group. And I'm pleased to introduce our next panel, Reforming Privacy Law and Fostering Innovation. So with me today are Dr. Teresa Scassa, Tim Morris, and Kelly Osaka. Teresa is at the University of Ottawa. She holds a Canada Research Chair in Information Law and Policy. She is a faculty member at the Centre for Law, Technology and Society, and a full professor in the Faculty of Law Common Law section with cross-appointment to the School of Information Studies. Tim is counsel with BMO's Canadian Personal and Business Banking Group. He has experience with multiple lines of businesses and regulatory functions within the financial services sector. He's also a contributing author to the Comprehensive Guide to Legal Research, Writing, and Analysis. And Kelly is co-lead of the Dentons Litigation and Dispute Resolution Group in Calgary, and a member of the Dentons Privacy and Cybersecurity Group. An experienced commercial litigator, Kelly has particular expertise in cyber breach coaching, cyber risk analysis, class action defense, and regulatory investigations. And just before we get into our discussion, a reminder that you can put questions into the Q&A box. I'm hoping to have some time at the end to pass some of your questions along to our panelists. So Kelly, we'll start with you. If you could give us the legal backdrop to our discussion with the recent and upcoming legislative changes in privacy here in Canada.
Sure, thanks, Julie. Welcome. Good morning from snowy Calgary, where it's -22 outside. So the rest of you and the rest of the country can enjoy that. I'm happy to talk about Bill C-27, also known as the Consumer Privacy Protection Act. As we heard from Monica and the previous panel, this bill was previously C-11, and that was back in 2020, but was scuttled because of the federal election. So hopefully Bill C-27 has a better trajectory going forward. It's basically a complete overhaul to our federal legislation of PIPEDA. Part 1 of Bill C-27 would enact the CPPA, and that would contain some wholly new provisions from what we saw with the original bill, Bill C-11. We know just from last week that the federal government presented the Bill C-27 for the second reading and debate in the House of Commons. And we also know that the Minister of Innovation, Science and Industry, when presenting the key provisions of Bill C-27, specifically highlighted the fact that it does contain new protections for children's privacy. So perhaps I'll start there when I'm just talking about what we can see that's new in Bill C-27. Now, I'll just start by saying that the CPPA does not define a minor or provide a specific age threshold for the application of children's personal information. So this is a departure from what we've seen in some international law, like GDPR has its age defined as 18. The new UK age appropriate design code similarly has an age definition for a minor. So this does create some ambiguity, which will make it difficult, I think, for organizations to determine what personal information, children's personal information they have actually collected and how they're using it. The default would likely be the age of majority province by province. So for example, in Alberta, that would be 18, whereas where Julia's in BC would be 19. So I guess that would give us some guidance on that issue. The other new thing with children's personal information is that it's actually defined as sensitive information. So we know that when that sensitive information title is given to personal data, it does come with heightened safeguard requirements, express consent for collection, use, and disclosure. So knowing that children's personal information is sensitive will also create these additional obligations for organizations to comply with if they are collecting that type of information. Also new is that because it is sensitive data, parents and guardians can consent on the child's behalf. However, the child can also exercise control and provide consent if, it says in the bill, if they are capable of doing so. Of course, we don't also have any definition of capacity or what capable of doing so means. So this creates some ambiguity as to whether the parents are the ones consenting to the collection of this children's personal information, or if it's the child doing so. One way that an organization could potentially address this would be by creating something like age gating mechanisms, or actually defining the age to which parents or guardians need to give consent. So just moving away from children's privacy for rights for a moment and looking at the bill separately and also what's new, we have this obligation under Bill C-27 to implement privacy management programs. So that means policies, practices, and procedures that organizations will have to have ready to go once the bill is implemented. These policies are going to need to use plain language and be made readily available upon request. Also new is the fact that the service providers will have to provide a level of safeguard equivalent to that which it is transferring to another organization. So this means that we're going to have to take a look at all of these vendor management contracts, and those will need to be updated to reflect this requirement. And the bill also creates the ability for an individual to request de-identification where an organization modifies personal information so that the individual cannot be directly identified from it. It also creates the right for requesting disposal of personal information and with limited exceptions. So that's kind of what we're seeing with Bill C-27. The part that the litigators get excited about, of course, is the enforcement mechanism. I think we're the only ones that are excited about this. We know from the previous bill that the Privacy Commissioner would oversee compliance and make recommendations to this newly created Data Protection Tribunal regarding penalties. We also know that the penalties are going to be quite significant if implemented. So an administrative monetary penalty could be up to 3% of global revenue or 10 million Canadian for violations. And that includes violations of all those provisions I was just talking about, such as failure to establish a privacy management program, failure to give that or ensure equivalent protection when transferring personal information, failure to adequately specify the purpose for which you're collecting this information. So there's a lot of potential risk there from a regulatory enforcement perspective. And then, of course, once you have the regulatory enforcement perspective, you also have that litigation risk, that potential class action risk that comes with it. And baked into this bill is also the private right of action when the commissioner or tribunal has made a finding that there is a statutory tort that could potentially lead to a lawsuit as well. So I won't get into the new AI and Data Act, which the previous panel had kind of touched on. I imagine Teresa has a few things to say about that as well. I do want to just touch really briefly on Bill 64 in Quebec. The first set of requirements came into force in September of this year. It was inspired by the GDPR, and just at a very high level, it does have mandatory privacy impact assessment requirements, mandatory breach reporting requirements if there's a risk of serious injury, which Julie, I think, leaves BC as the only jurisdiction that doesn't have mandatory breach notification requirements. And then it also, Bill 64 also has enhanced consent provisions and actually defines a minor as under 14 years of age, and personal information may not be collected of a minor without the consent of the parent or guardian. So those are some of the highlights from Bill 64. Alberta, we have PIPA. It's supposed to be substantially similar to the federal legislation. There hasn't really been any movement yet to do a full review and report or any sort of consultation as to how that process will take place yet, though I expect we will be seeing more information from that from the Privacy Commissioner going forward.
Thanks, Kelly. And building on that and your comment that BC is now the only jurisdiction without mandatory breach reporting. You know, we do have regular legislative reviews, regular special committee reviews of the legislation. And there's been, I'll say, noise in the privacy community in BC for a while about needing to, you know, harmonize the mandatory breach requirement, mandatory breach reporting, otherwise bring, you know, our 20-year-old legislation in step with technology today. And, you know, most recently, that's last December, the special committee recommended more or less those things. But those same, you know, let's stay caught up recommendations have been made before with the prior special committees. And we just don't seem to have the political interest in making the legislative changes. I mean, we do have a new premier, maybe it'll happen. I'm sure it'll come eventually. At some point, BC will have to catch up, but who knows when that's going to happen. But thanks for that overview, Kelly. I hope that can kind of frame our discussion for the rest of the questions. And Tim, I'm going to turn to you now from the private sector perspective. Can you talk a little bit about how you see privacy and the changes in regulation playing into the process of innovation?
Sure, I am happy to do that. And so we're all lawyers in the room, or not all, but I will preface, and I think this will come as no surprise, that I'll just add the disclaimer that my views are my own and they don't necessarily reflect. It's a timely discussion. I really do think we are sort of in this age of digital transformation. You know, people want things to be done efficiently. They want things to be done easily, with minimal interruptions to their day. And really sort of companies in the private sector need to focus on sort of meeting people where they are right now in all the services they provide. And so companies now are faced with the challenge of trying to innovate and provide these sort of streamlined services to their customers. But those innovations really do need to be balanced against certain necessary functions and within the requisite regulatory frameworks that we're talking about. And so the challenge and the work isn't just the innovation, but it's also balancing that innovation and implementation against what your regulatory obligations may be. And so what that means practically is when there is an idea or whether there's a particular innovation for a new product, any kind of new development, there are lots of sort of things I'll say kind of like floating around. And I think that's really sort of like where legal comes in. And as you know, in my role as in-house counsel, where we really do sort of begin to provide that value to the business. And so normally you're brought into on the outset of a project and you begin mapping out sort of some of what these legal and regulatory considerations may be for any particular innovation. Sometimes, you find yourself in a situation that is going to be a bit more straightforward and settled, and then you just have your sort of checklist of we'll go through A through I, and we know if we can satisfy all these things, we'll be on side and everything's good. Other times, you find yourself in territory that's a bit more uncharted. And that's where I think things can kind of get sort of interesting and fun. And I think one example of this sort of uncharted but very, very fun area of innovation in the technology and digital space is BMO's development of a Twitch channel. And so those who are sort of unanointed, Twitch is a streaming service owned by Amazon, and it primarily was for gaming and now has since expanded into something much larger where people stream games, art, real life, all of these things. No other bank, as confirmed by Twitch, in the world was doing this. And so this was an opportunity for the bank to say, well, let's develop a presence and move into and innovate a new way of approaching customers. There was no playbook for that. No bank had ever done it. And when the group came to us, I was very excited. I'm a gamer. I love Twitch. I've used it. I've streamed on Twitch. And so I was very excited. But then you also have to take a step back and say, okay, well, what are we going to do? Like, how do we do this in a way so that we're on side all of the various requirements that we need to be on side of? And so that's where you sort of begin to sort of loop in groups like Privacy, for example, to say, this is the plan, right? This is what we want to do. Here is how we think we're going to do it. And this is what we want to do to sort of create value along the way. And what are your thoughts? What are your concerns? And sometimes when there isn't that kind of playbook, you sort of need to look at what the landscape is and really try to apply it and sort of think, how could this play out? Like, what are the things that we need to think about? And, do we need to go sort of above and beyond what might be I'll say the baseline requirement? Is there something else we should be turning our mind to? We'll almost need to think ahead a little bit to think, well, how could we do this? How will this be interpreted? And what, we want to make sure that we're giving the best presence and service to the customer, but we also need to make sure everyone is going to be protected. And so I think that that's always going to be the challenge, right? Is going to be saying that this is the innovation, but we need to make sure that we are going to be on side of whatever regulation or legislative framework is there. And really, it's bringing together, at least in sort of the in-house world, bringing all the stakeholders together to have that conversation, particularly when you're in these like new innovative projects or ideas that won't necessarily have a roadmap. And as we move forward with the development in these areas, it's not always going to be as straightforward. And so I think there's lots that can be done. And I think that's just going to be the balance for private sectors, is to say, we might not always have this like playbook that we can go from because we've changed and because we've come so far. Legislation may be very old. It won't always necessarily reflect the current reality. So what do we do to not only innovate by way of product and service delivery, but how we sort of balance those new things in this sort of new legislative world?
Thanks, Tim. Teresa, turning over to you, and some of this may overlap with the end of the last panel that we heard, but now that we have the AI Act coming, now that we have AI specific legislation coming, can you discuss some of what you see as the potential impacts or the potential difficulties of what's been proposed so far on innovation in the AI world in particular? Sorry, I'm not sure if it's just me, but I can't actually hear you, Teresa. I don't know if
Yeah, we can't hear.
Andrew as our tech support. I'm not sure if you can assist there.
Hi there, Teresa. Can you hear me? Do you want to just go down to the little arrow beside your microphone and make sure that it is set to most likely your computer microphone.
Does it
I
work?
still can't hear you.
Can you hear me now?
I can now, yes. Thank you
Yeah,
very much.
Okay, I'm sorry
Thanks.
about that. So I got to be the person today who has the Zoom issues. Wow, I feel so privileged. Okay, so sorry. Now I've just closed my window. Okay, let me get going then. Sorry. So I was just saying that when Chantal opened this conference, she framed it the themes of the conference around tensions and some of the tensions that we're experiencing in this context. And so I thought I would shape my comments around the idea of tensions. And so when it comes to the AI and Data Act, which I'll call the ADA, there are, I think, a number of tensions that are evident there. And the first one that I'd flag is speed versus public engagement. Because with ADA, I think what we see is a desire on the part of the government to get this thing through quickly. We did not see this wasn't part of Bill C-11 in the last go round. It's newly added. There has been no public consultation on ADA. There has been, very, very little opportunity for any kind of engagement around this bill. In the minister's comments on the bill when it went to second reading, he talked about how Canada will be the first or among the first to actually enact legislation of this kind. And so it feels like it's some kind of race. And speed is this overarching value. And yet what is left to the side with that kind of speed is public engagement. And so, as I mentioned, there hasn't been any public consultation on this. The response of the government, I think, has tended to be, well, so much of the bill is left to development and regulations, not necessarily a good thing, that there'll be an opportunity for consultation as the regulations are developed. And all I can say to that is that the regulation processes are more remote for ordinary individuals and not necessarily the best place in which to have public engagement around issues of AI regulation. And if you compare it to the EU's AI Act, of course, not only did they have considerable public engagement before the draft was made available, but there has been ongoing debate and discussion of the draft. And so there's, by comparison, there's just so much more consultation and engagement around the EU AI Act than we're seeing with this portion of Bill C-27. The other thing about leaving the consultation to the regulation making process is that nonetheless, in passing this bill, we are going to bake in a framework that itself received no consultation. And so there are certain elements of this framework that will simply be there and choices that are made already on which there is going to be little consultation. And to just pick up on a point made by Emily Laidlaw on the previous panel, we have to be asking ourselves how this bit of AI regulation fits in with so many other pieces that are relevant to AI regulation, from regulating online harms to medical device regulation and so on. And how does this fit in? And we haven't had that conversation or discussion. So I think that that's an important first tension with this bill, which is this tension between speed and public engagement. Another tension that I think is interesting, and I haven't heard a lot of discussion about it, are the federal provincial tensions, the jurisdictional tensions with this bill. And I have been trying to dig into them and pull them apart, because I think there's some things going on here, certainly that I don't fully understand in terms of the constitutional dimensions of this bill, but it refers to the regulation of international and interprovincial trade and commerce in artificial intelligence systems in the purposes section, clearly invoking the general trade and commerce power as a basis for jurisdiction. And yet a substantial part of this bill addresses the design and development stages of AI. So many of the obligations relate to the design and development stage. And that design and development stage is often entirely intra-provincial, not always, but in many cases, for example, development that takes place in universities, in hospitals, and many hospitals or workers within hospitals are involved in developing AI systems, researchers, small startups, and so on. You have intra-provincial design and development in a bill that is focusing on inter-provincial and international trade and commerce, and yet so you've got obligations that apply before you have that kind of movement. And so to me, there's a question is what's going on there. There's also the broader general trade and commerce issue, and please forgive me for talking about the Constitution and the technology panel. I think everybody in Canada has a little bit of constitutional anxiety syndrome when it comes to talking about jurisdiction. But, for general trade and commerce, the Supreme Court has been clear that you can't use the general trade and commerce power to govern, to regulate a specific industry. And it raises the question is AI an industry or is it a broader phenomenon? And I think the government has been very careful not to refer to it as the AI industry, but many people do. And so there's this question as well in terms of that general trade and commerce power. I note as well, if you look at section 3, sub 3 of the bill, provincial departments and agencies can be excluded from the application of this bill by regulation, which I think is just odd and interesting as well. So I think there's some constitutional issues here that need to be aired, that haven't been aired in terms of how this bill is supposed to work. And rather than just be the person who raises the constitutional issues and says, yeah, we have to think about the Constitution, I actually think this poses the further question, which is what is the role of the federal government in this space? What should the federal government be doing with respect to AI regulation? Is their role to pass this type of legislation? Is their role more to facilitate and convene consensus, federal and provincial consensus with the private sector around what proper AI governance should look like? And here I'm thinking of the NIST framework that is developed at the federal level in the United States, which has received a lot of consultation and input and has been refined and developed and could be, a framework that is adopted more broadly for governance of AI systems. So that's the second tension I'd identify, the federal-provincial tension. There's also just the broader tensions that you find in legislation of this kind as to what to leave in and what to leave out. There are some interesting things going on, I think, in this bill. For example, anonymized data was left out of the CPPA part, is excluded from scope of CPPA specifically. We pick up anonymized data again in ADA. Although there is no definition, and it should have incorporated the definition from CPPA, it didn't, but there is no definition of anonymized data. And I think this is meant to resolve a governance gap for anonymized data that we're reassured that it'll be dealt with here. Although there I would flag that the only anonymized data that will be governed by ADA will be in relation to high impact systems, which it's not a defined term, that's also left to regulation. It won't apply to uses of anonymized data by the list of actors that are excluded from the application of ADA, which is most of the federal government, DND, CSIS, CSE, and so on. So I just flagged that issue around anonymized data. Harm, I think, is an interesting issue in this bill. The focus in terms of the definition of harm, the focus is on individuals and not on groups. It should, in my view, be on both. And I think it's very clear that we're moving to this broader concept or broader understanding of the harms that can be caused by AI and how they may not just simply be individual harms, but also group harms. And yet we don't see that reflected in this legislation. There is a reference to biased output. And so the response might be, yeah, but if the harm is kind of discrimination more broadly, it'll be captured by biased output. But bias is not the only potential group harm from AI. The definition that's adopted of biased output focuses also on individuals. And the terms harm and biased output are used sometimes separately in the bill, with only harm and not biased output as a trigger for some ministerial actions in the bill. So again, I think that there's stuff that needs to be worked out there. If only we had consultation and discussion prior to it being introduced, we might have been able to raise and address some of these issues. The huge knowledge and resources gaps between public and industry seem to also call out for independent governance and oversight. And that's something that we don't really see in this bill. And a fourth tension I'd raise would be governance versus agility. I think it's a false tension. You can have both. Agile doesn't have to mean kind of frantic and last minute. It's not supposed to mean that in any event. But this bill, I think, is very weak on governance. Oversight is by the same ministry responsible for supporting and developing the AI industry in Canada. There isn't an independent regulator, and we've also got features, for example, where audits are privately commissioned, where an audit is required. Again, there's no independent regulator or auditor, and that brings me to the fifth tension, which is trust versus lack of trust. And I think there's a huge trust gap generally when it comes to technology in our society, and other speakers have made reference to some of the trust issues that we have had recently. And so I think that the lack of engagement with this bill certainly doesn't help with the trust issues, but it also manifests itself in other in other features of this bill. So if you look at the blanket exclusions for the Department of National Defense, CSE and CSIS, the bill says it doesn't apply to any product, service, or activity under the direction or control of those agencies, which seems to mean that anything they do is exempt from this kind of governance or regulation. So there are no AI no-go zones as we see in the EU AI Act, or specific limitations. And in the EU AI Act, for example, with respect to the military, the exception is only for military applications as opposed to all potential uses by the military of AI. And so you only have to think of, for example, the publicity over the domestic PSYOPs experiment by DND in Nova Scotia to think that, maybe it would be a good idea to have a narrower carve-out exception here as an element of trust building with respect to government and AI. So I've done that really quickly, just trying to give you an overall arching view of some of the themes that I think and tensions that that arise in this bill, which we've had so little time to debate and discuss and chew over publicly. And the messaging from the government seems to be that this is going through, it's been added into Bill C-27, I think, as part of that, and that there's no appetite to slow down and take longer on it. And I think that that is unfortunate.
Teresa, I think that raises some real issues from an innovation perspective and from a private organization's perspective, especially the issues around compliance with a regulation that's not, or a law that's not well defined, as you point out, and has some extraterritorial jurisdiction issues. That puts a lot on the organization in terms of trying to figure out how it will comply and what the risks are for non-compliance. And I just note that in the bill, the penalties for non-compliance are quite significant as well. It could be up to $10 million Canadian, or 3% of gross global revenues for non-compliance. And then you talked about harm too, and if there is serious physical or psychological harm through the use of the AI system, it could be a fine of Canadian 25 million, or 5% of gross global revenues. So the penalties we're talking about are quite significant. A lot of these organizations, or many of these organizations who are trying to be compliant with the statute, will most likely be smaller startup organizations. So you also have to think about this from a cost perspective and overhead perspective as to how much this is going to eat into potentially their profits as well.
Yeah, I think that there's a lot of uncertainty, and I see the uncertainty as a problem from a public perspective, but it's also a problem from an industry perspective as well. With so many of the issues being left to regulation, it's really hard going into this to really understand what this bill is about, what is actually going to cover, what's being left to some other bill or some other context like online harms regulation, what the carve-outs are going to be. There's also the challenge that I didn't mention that, with regulation making, first of all, it's slow. So we've got this shell of a bill now that will be filled out by regulations, but how long is it going to take for those regulations, and which ones are going to be prioritized and which ones will never ever get drafted? Because we've seen that before too with, Castle's private right of action is still waiting on regulations to become a thing. And so it just, these are also, I think, issues and challenges with this particular bill. It almost feels as if you pass the bill and then you can check the box that says we did something about AI regulation, but there's the real work is still to come, and it's not clear when or how that's going to get done or what the content of that will be.
Thanks, Teresa and Kelly. And Teresa, I'll just say, you are not the only one having Zoom disappeared for a little while. Am I gone again?
Oh, we can hear you.
Okay. I am not sure what's happening with my Zoom today. I have sent Kelly my in case I somehow get dropped again, because I'm not.
Oh.
I'm really sorry about this, everyone. I'm going to try to get the next question in, and hopefully I will not disappear again. This one's for all three of you, and kind of building, Teresa, on the tensions theme. There can be an additional tension between what the regulatory standards are or are going to be, and public perception of what standards should be, what is, I guess, more broadly appropriate in the privacy sphere. And I was hoping the three of you could comment on that particular tension and how it plays into innovation, risk analysis, reputational considerations, those sorts of issues. And if no one's going to go first, oh, go ahead, Kelly.
Well, I was just going to say, I think that there can be definitely a gap between where the regulation is, especially in Canada, where we've sort of lagged behind what's gone on internationally, in Europe and US and elsewhere. So their public perception of where the regulation actually is in Canada can actually be quite far apart from where the regulation itself is. And I think Tim already mentioned this when he was talking about the Twitch channel and implementing that, and knowing that perhaps that the Canadian regulation was going to change, but those changes not actually having been implemented. When I talk to my clients about, what are the best practices from a compliance perspective, you're probably looking at the highest threshold that there is, whether that's GDPR or the UK or California, because we know that the regulation is eventually going to get caught up there. Or you might have jurisdictional issues where you have users outside of Canada who are using your product or service, and you may get captured by those other laws that are held to a higher standard. So there definitely is a tension there from an organization's perspective as to where they should be from a compliance perspective.
Yeah, and Kelly, if I can pick up on that, I think that's quite right. And you see this sort of in the and again from the in-house world, is that you do have sort of the regulatory expectation and the obligation put onto the organization. But that's not sort of where the conversation ends. Specifically if we're discussing a new innovation or something that we might want to do, we sort of will use that as the guiding and say, this is sort of the groundwork that we have. So this is what we need to do. But then it's, well, how would this play out in the court of public opinion or from a public perspective? And is it enough? And I think that, I think increasingly we're finding that customers and consumers are, they're more tuned in, they are more savvy. And so where you have these sort of regimes that are kind of lagging behind in some instances, like it's just not good enough in some cases, right? And so part of the challenge, I think, and I think companies can do this well, is anticipating, well, what would a consumer say about this particular practice, particularly if it's based on, a regulation that is a little bit more dated? Would they expect more, even if the current black letter, be honest about that, because if not, I think that, it's not enough to say like, well, yes, we were on side of this particular regulation. One of the risks for any corporation or company in the private sector is the reputational risk, and that isn't always going to be tied to, did company A comply or not. It's going to be, well, how did that impact somebody, and what was the risk to the customer, and what was the harm to the customer. And you really do need to be able to sort of take a step back when you're innovating and developing and say, well, we know what we need to do, but how do we take that further? How can we build on that to make sure that the best interests of our clients are going to be sort of considered and maintained throughout this? So it is a difficult difficult but achievable kind of conversation to have, of balancing the regulatory obligation, whether it's in its current state or what you think it might course of action or the other.
Yeah, and so I'll just jump in because I think those are really important points. And I when I was thinking about this question, I was thinking about a particular example that got an awful lot of media attention recently, and led to a parliamentary ethics committee hearings, which was the PHAC mobility data issue, right? Where you had the Public Health Agency of Canada using mobility data that it sourced from 2 private sector companies for analytics purposes during the pandemic. And that just blew up in the media and caused this big public outcry. And so in that context, you had, if you look at the parliamentary committee hearings, it's not as if there was an obvious or flagrant breach of any of the laws that we had in place. And in fact, the private sector companies had created these mechanisms that were in compliance with the law, the existing laws, to share data for public, and in TELUS's case, data for a good platform that had been certified and accredited and all of these sorts of things. And yet you had this scandal that erupted around it, and which has significant reputational impacts for companies that have in good faith engaged in compliant activities. And I think some of the takeaways from that experience, well, first of all, there were many recommendations that were made by the ethics committee with respect to amending legislation, the legislation we have, which goes to Kelly's point that our laws are out of date and they're not addressing the context or the situation or the ways in which people use data, the needs that people have for data. And so the laws need to be updated, and that work hasn't been done. And this bill is only going to do a small part of that. We still have the Privacy Act, the Federal Privacy Act to deal with, another legislation as well. So there's one of the issues is out-of-date laws, but the other issue goes to a point that was made by Chris Parsons earlier this morning, which is that transparency is becoming so much more of an important element. And I think that theme runs through that particular instance and the at the hearing report as well, which is this idea that there wasn't, people didn't know what was going on or what was being done, and the means that were chosen to convey that information to people were not effective means. People had apparently consented to their data being used in this particular way, but that was not a realistic consent, and I think Chris Parsons talked about this as well. It wasn't a realistic consent. So how do we create a context in which people have a much better understanding, where there's much better transparency or knowledge about how data are being used and for what purposes, and the responsibility there falls on both public and private sector actors. And so I think that's an important question to have, and a really important piece of this puzzle in terms of ensuring that the public expectations match the legally compliant practices that or activities that organizations are engaged in. And I have to say that's partly at the root of my frustration with ADA is this lack of transparency and lack of public engagement. It's hard to tell what this bill is about with all of its moving pieces, and there's been no public conversation about it. And I think that's a really bad start, if I can say that enough times here. I think that's a really bad start to governance in this space.
Yeah, in the PHAC blow up after the fact. The criticism of the government and of the organizations, even though they had been compliant and did get the requisite consents, was basically that they took advantage of outdated privacy laws in terms of what they were collecting, how it was used, and for what purpose, without, as you said, Teresa, transparency. And I think that's what it comes back to. It's this need to be in constant conversation, if you're an organization, with your customer base to figure out where they're at in terms of what their expectations are on transparency. Another thing that comes to mind on this issue is the UK age appropriate design code. So this is going back to children's privacy rights, and one of the standards actually being that yes, these products and services that are directed to youth will have parental monitoring provisions in them, so allow parents to see what their kids are up to. But the flip side of that is that they also recommend that the children be made aware of the fact that they are being monitored by their parents, so there isn't this sort of unknown monitoring that's going on. So anyways, it comes back to, like we said, transparency and what the expectations are from customers.
And speaking as a litigator, and my camera's off now because I'm advised that gives me a better chance of actually staying here with everyone. But speaking as a litigator, it'll also be interesting to see how that spools out in class action litigation, since we're starting to see, that there is some divergence between what is a breach of the legislation and what is actionable harm, at least in some contexts. And it'll be interesting to see if that starts to spool out in litigation as well. And as a litigator, of course, as Kelly mentioned, the part that we are most excited about in the Act is the changes, the litigation changes, the new tribunal, the drastically increased penalties, the new federal private right of action. And so I'm hoping the three of you can comment a little bit on how you see that impacting innovation.
Well, I can start with that. I mean, I think we have to look overseas again to see how these penalties, these large penalties, have been implemented and what effect, if any, that's had on private organizations. We had a recent example with the Irish Data Protection Commission fining Instagram, or Meta as the parent company, as the controller in question for 405 million euros, and that was for multiple violations of GDPR. Meta is appealing that decision, but the two types of violations that fine was meted out for was basically that children's contact information, including phone numbers and emails, were automatically being made public when they switched from a regular account to a business account. And then the other piece of it was that there was public by default on these children accounts that they were creating, which was in violation of the GDPR as well. So basically, there was this finding that there was a failure to provide an explanation during the registration process in plain language about what the difference between public and private accounts actually means, and the fact that the accounts were public by default and it was not provided for in the data policy. So during the course of this investigation, and I've been involved in these regulatory investigations before, and they're very lengthy typically. So there is a lot of opportunity to sort of address these issues during the course, even before the final findings come out. And then that's what happened in this case. So Instagram went ahead and gave children users the option to choose between a private or public account as opposed to making it public by default. And then they also created the option to refuse the publication of their contact details as part of the design of the program. So I guess I'm just pointing to this as an example of where we have these fines, we have these large fines, and of course regulators always like to go after the big juicy targets, these big social media platforms, to make a point out of them. But we do see some changed behavior as a result of these investigations. I guess my concern with these large penalties and this compliance risk is not so much with those large social media platforms, it's with the smaller to medium-sized businesses which will also be obliged to comply with these new laws. And specifically from a data breach perspective, when a medium-sized business experiences a data breach, it's very, very harmful to the business, and from a cost perspective, from a customer relationship perspective, um, and um, and just trying to revive itself afterwards is quite difficult. Having regulatory risk for other provisions, like such as not having a privacy platform or privacy program management in place, just creates more compliance issues for these small to medium-sized businesses, which will then have to pay for someone to come in and assist them with that as well. So I do think it adds to overhead and just creates more risk and uncertainty for organizations.
There's something, if I can jump in on in here, is one of the things that I think is really interesting, or that I'm kind of tracking and following, relates to just the way in which the federal commissioner and the provincial commissioners that have private sector data protection jurisdiction have been increasingly cooperating. And we've seen that over the last little while, where they have more and more joint investigations into large data breaches. And these are joint investigations where I think there's increasingly an assertion of concurrent jurisdiction. And not just overlapping jurisdiction. And so what I think is going to be really interesting is to see what happens post CPPA, once we have the CPPA in place. Quebec already has the power to administer significant administrative monetary penalties. If BC and Alberta amend their laws to be substantially similar to the CPPA, they may also introduce AMPs, significant AMPs. So we've moved from a soft enforcement environment where the commissioners have collaborated and cooperated in an attempt to sort of harmonize interpretation and application of data protection laws across the country, to one in which, if they continue to do this, you're going to have interesting situations where you might have multiple AMPs, for example, being imposed by different commissioners in relation to the same breach, where you also have a federal privacy commissioner who now has had his interpretive authority shifted to the data tribunal, right? So the findings, not just orders, but findings of the commissioner can be appealed to the data tribunal. And so they may be doing joint investigations and coming up with joint conclusions, but with respect to the federal commissioner, those might be overridden by the data tribunal, which has an impact on that cooperation and collaboration. So I think that we're going to see some changes in practice, or some impacts on practice that maybe we haven't fully thought through yet in terms of how these different issues are going to be handled. And I think that will be something that will be very interesting to watch.
Thanks, Teresa. Tim, did you want to add anything on there?
Well, I would just add that, I think it is something that, will be consideration, though I think that from my perspective, I don't know that it will necessarily hamper the innovation of an institution like BMO, for example. We always strive to be the very best business partner that we can with any regulator. And so and because we are a heavily regulated industry, we have lots of practice about that, or around that. And I think that, you establish the regulatory framework, and the way that I always kind of imagine it is a bit of a back and forth, right? Is that, you get this sort of idea of what needs to happen, and oftentimes it's not too prescriptive as so it doesn't become too stale too quickly. And then there's going to be a private sector sort of interpretation of what that looks like and how that plays out. And I do think that, in this sort of de facto kind of way, there's this kind of like mutual development of, here's what was said, here's how it actually works out in practice. And then that sort of, I'll say, like, gains momentum over time, and you see that the development of that and sort of new ideas and new trends sort of develop from that. And I think you kind of see that, in, I don't want to call them adjacent, but in new regulations, for example, like the Consumer Protection Framework, you get this idea of that was born out of a development in certain trends, and now we see this sort of in a similar kind of way. And I think that in a lot of ways, banks, for example, they can look at, well, what did we learn from that? What did we learn from the development of CA6 into the Consumer Protection Framework? And what can we now do for, like, can we take some of that learning and see how this would apply to a new regime that's coming forward? And I think we can do that. And I think that we do that well. And so there we have this sort of resources and expertise internally to look at, well, here's the new landscape, here's the new world that we're operating in, and we can deploy that in the expectations in a way that, you know, doesn't hamper innovation, and we're still able to move forward.
Yeah, thanks. And you know, building on that and some of Kelly's comments, and this is perhaps trite, but you know, how new regulations, how increased, what I'm going to call increased litigation risk as a litigator, is going to impact will impact different industries differently depending on their risk appetite, and will impact different organizations depending in part on their size and sophistication. You know, as Kelly put it, it is the compliance burden on smaller organizations that aren't as used to complying as BMO is going to be different in nature and bigger. And you know, also, again, speaking as a litigator and a class action defense lawyer who thinks about these things, you know, there's a couple of things that strike me with this. You know, one, and related to Kelly's point about that, you know, organizations are already starting to deal with this in the issue in the regulatory process. But with the private right of action not being triggered until there's a tribunal decision, that could be a really long period for defendants to be at risk of litigation, effectively a really long limitation period. And it'll be interesting to see how that plays out, and whether plaintiffs' counsel wait to plead it until the time has run, or whether they, you know, preemptively plead it to get in there and get carriage of the action before somebody else does. And there's also, you know, some increased complications that I see coming in class actions, partly because we're adding another cause of action, and we already see, you know, we see the torts, the common law torts pleaded for Ontario. We see BC's Privacy Act cause of action pleaded. Now we're going to have another cause of action to deal with. And, you know, as Teresa was just saying, also a potential for a divergence in underlying facts as found by, say, the BC Privacy Commissioner in a joint investigation, and then the tribunal. And that's going to make it's going to make it much more interesting for us litigators, much more fun. But, you know, for organizations, potentially much more challenging and much riskier. We just have a couple of minutes left. And I'm not seeing any questions, so perhaps we can close with this. You know, we know, as has been already discussed today, the federal bills just gone through second reading. Do any of you have any thoughts coming out of that on what we might see and what impacts that might have? Teresa, in particular, in relation to ADA?
Yeah, I think the messaging was pretty clear around ADA, which is that being first is somehow like all that matters, and so that this is going through, and I think, you know, I think that's problematic messaging with respect to a bill that has a lot of issues and that hasn't had full and proper debate, as I've said. So, you know, I was disappointed by that messaging. I also think the minister is overselling children's privacy. And I know Kelly talked about, you know, what's in there and what's not with respect to children's privacy, but that's been pulled out as I mean, whenever there's difficult legislation, I think children always get invoked, is because, you know, everybody likes children. And, you know, we have to protect children. So, you know, I think we're seeing children being brought out as, you know, this is why we have to do this. And there's just not that much. I think it's kind of overselling what C-27 does with respect to children's privacy.
Yeah, I agree. I think that was just a talking point, really, to sort of sell the bill. But it looks like it's going ahead probably in 2023, barring another federal election.
Okay, well, unless there's any further comments, we may give people a minute or two additional break time. So thanks, Teresa, Tim, and Kelly, for your insightful thoughts today. And thanks to everyone who's spoken so far this morning. This wraps up our first session, or for those of you on Eastern time, the morning session. We'll now take a break. That's lunch for those of you on Eastern time, and what I'll call a mid-morning break for, say, Kelly and me in Alberta and BC. But please come back in half an hour at 12:30 p.m. Eastern time. We do have a great lineup of topics after the break. And immediately after the break is our keynote address by our Privacy Commissioner, Philippe Dufresne. So see you all in a bit. Thanks.
So welcome back, everyone, either from break if you are in the West, or from a quick lunch if you are rather central and east. We're absolutely delighted to have with us the new Privacy Commissioner of Canada, Commissioner Philippe Dufresne. I will not hide how pleased I am to see the role fall upon Philippe Dufresne because of his eminently relevant background as a human rights lawyer, as general counsel to the Human Rights Commission, and as the law clerk for Parliament, Canadian Parliament. And now it seems to me in an excellent position to advise as an agent of Parliament on how to essentially bring privacy legislation to a new era. And that is really what we are going to talk about today. So welcome, Commissioner Dufresne. This morning, perhaps you have heard or you have been told by your staff, privacy was at the center of almost every discussion, because regulating the internet and enforcing that regulation necessarily involves a form of identification of individuals, but also privacy comes into play in relation to what we've come to call capitalist surveillance, where we want to bring in line online advertising to protect privacy, but then we have the goal to have a free internet. In fact, our next panel will address precisely that. All this to say that you have truly a big challenge in front of you, and we really would love to hear you now on how you will approach it, what you see the issues, and essentially how you feel the way forward is designing itself. So welcome, Philippe Dufresne.
Thank you so much, Chantal. Can you hear me? I just want to do a sound check before I begin. Yes? Okay. Thank you for this kind introduction. And it's great to be here. I'm so grateful to the ICJ Canada. I see some friends, former colleagues along the attendance. So it's grateful. I would wish that it were in person, but that will come. Thank you to Dentons as well for the opportunity to speak to all of you on the subject of regulating the internet while respecting the rule of law and protecting the fundamental privacy rights of Canadians. My remarks will touch upon my current role as Privacy Commissioner of Canada, but also on my previous experience as a Senior General Counsel of the Canadian Human Rights Commission, where I was personally involved in some of the key cases involving the regulation of hate messages on the internet, as was my colleague Monette Maillet, who I'm thrilled to see here. As a former president of the Canadian section of the International Commission of Jurists, I also know firsthand what an important role the ICJ plays in bringing attention to key issues impacting Canadians, including the promotion of human rights and freedoms and the rule of law, both within Canada and internationally, and the importance of having an independent judiciary and of ensuring the appropriate balance between national security and civil liberties. The ICJ's commitment to protecting and promoting these principles is invaluable, and I'm so thrilled to be here today to contribute to this important work and this important discussion. My appointment this last June as Privacy Commissioner of Canada was for me a logical progression in my career as a lawyer and senior executive committed to the promotion and protection of the fundamental rights of Canadians, while at the same time ensuring that pragmatic and important objectives and interests such as public interest and security and innovation were also achieved. This approach also applies certainly to the world of privacy, and finding the right ways of protecting and promoting our fundamental right to privacy while harnessing new technological opportunities will be a key challenge for Canada's institutions and for jurists in the coming years. Technology offers tremendous potential for public and private sector innovation, and that includes the internet, for improving the lives of Canadians. Ensuring that we are able to use these innovations while protecting privacy and achieving other public interest goals will be critical to our success as a free and democratic society based on the rule of law. To do so, Canada's federal public and private sector privacy laws will need to be modernized, both to respond and adapt to these societal and technological changes and to keep pace with legislative developments in other jurisdictions domestically and internationally. The government took an important step towards this goal with the tabling of Bill C-27, the Digital Charter Implementation Act, in June of this year. The bill is a recognition by the government that Canadians need and expect modernized privacy laws. As Privacy Commissioner, I welcome the tabling of this bill, which is an improvement on its predecessor C-11 and on PIPEDA. I look forward to providing my advice to Parliament on how the bill can and needs to be further improved. In doing so, I will apply the three elements of my vision for privacy that I presented to the House of Commons and Senate during my confirmation hearings in June. The three elements are privacy as a fundamental right, privacy in support of the public interest and Canada's innovation and competitiveness, and three, privacy as an accelerator of Canadians' trust in their institutions and in their participation as digital citizens. This vision reflects the reality that Canadians want to be active and informed digital citizens, able to fully participate in society and the economy without having to choose between this participation and their fundamental privacy rights. Canadians should be able to benefit from the public interest and economic advances brought by these new technologies with the reassurance that their laws and their institutions are there to appropriately safeguard and protect their personal information. In short, privacy is fundamental, it supports important public and private interests, and it builds necessary trust. I want to talk briefly about the 2014 R.V. Spencer decision of the Supreme Court of Canada, because it touches upon the internet and privacy. As many of you will know, in this momentous decision, the Supreme Court of Canada found that there's a reasonable expectation of privacy in subscriber information held by internet service providers, and that as a result, the police could not request this information without a warrant, even when investigating a serious crime like child pornography. The decision therefore recognized an understanding of privacy as anonymity protected by Section 8 of the Charter. I want to note that my office now, the OPC, which was not my office then, but was under the great leadership of then Interim Privacy Commissioner Chantal Bernier, was a key intervener in that case and was represented by an impressive legal team led by now Supreme Court Justice Mahmoud Jamal and now Ontario Privacy and Information Commissioner Patricia Kosim. All I will say is I would not have wanted to be on the other side of such a formidable legal trio. I believe that this case serves as a good illustration of what I mean when I say that privacy is a fundamental right, that it supports the public interest, and that it accelerates trust. Let me explain why. In 2019, talking about privacy as a fundamental right, the OPC and its international colleagues in the Global Privacy Assembly declared in the resolution that, quote, privacy is a precondition for citizens' other freedoms, as well as a keystone right for democracy and personal and social development. We said that there is a, quote, indispensable link between the protection of the right to privacy and a society's commitment to promote and respect human rights and development. This description of privacy as a necessary condition for the existence of other fundamental rights is consistent with the Supreme Court of Canada's long-standing interpretation of privacy law as having quasi-constitutional status because of the fundamental role that privacy plays in the preservation of a free and democratic society. In Spencer, the court, written in the decision written by Justice Cromwell, reiterated the, quote, the strong claim to privacy in relation to information that is at the biographical core of personal information, which individuals in a free and democratic society would wish to maintain and control free from dissemination to the state. So again, this notion of privacy and free and democratic society. The court also added that the understanding of informational privacy as control, quote, derives from the assumption that all information about a person is in a fundamental way his own, for him to communicate or retain for himself as he sees fit. And there, the accent on fundamental nature of privacy. Finally, the court cited with approval the statement from the Federal Court of Appeal that, quote, personal privacy protects an individual's ability to function on a day-to-day basis within society while enjoying a degree of anonymity that is essential to the individual's personal growth and the flourishing of an open and democratic society. This treatment of privacy echoed international law and the inclusion of the right to privacy in the 1948 International Declaration of Human Rights. I note that Bill C-27 contains a preamble that would make explicit Parliament's recognition of the importance of the privacy and data protection principles contained in various international instruments. Treating privacy as a fundamental and quasi-constitutional right means treating it as we do other human rights, as a priority. It means that privacy must be legally protected with a strong, fair, and enforceable legal and rights-based regime, a regime that offers meaningful remedies to prevent and address violations and that acts as an incentive for institutions to create a culture of privacy. Let me repeat that, a culture of privacy. Privacy by design where it is considered, valued, and prioritized. Privacy that is embedded at the outset of innovation, not as an afterthought or regulatory irritant. It means that the collection, use, retention, and disclosure of personal information must be limited to what is demonstrably necessary and proportional, that employees and law enforcement officers are trained about the importance of protecting privacy, and that ongoing monitoring to ensure policies are followed. It means having mechanisms in place that identify and address privacy issues early and on an ongoing basis, particularly when introducing new technologies involving the collection of personal information. And on this, pitch for my office, our business advisory and government advisory directorates are available to consult with organizations and departments and agencies on their data collection initiatives to ensure that appropriate steps are taken to protect privacy. Treating privacy as a fundamental right also means giving privacy an interpretation consistent with the purpose and objectives of the legislation, which can, in the case of PIPEDA, the private sector privacy law, be the promotion of trade and commerce as a matter of federal jurisdiction. It means that in cases of conflict, and these will be rare, between privacy rights and private or public interests, privacy will prevail. I say that these cases will be rare because by creating a culture of privacy and protecting personal information at the front end, we will be able to avoid most conflicts and achieve both privacy and the desired public or private interest. This brings me to my second pillar, privacy in support of the public interest and Canada's innovation and competitiveness. This second element is a recognition of the positive impact of privacy protection and a rejection of the false choice between privacy and the public interest. Just as we can and we must have national security and human rights, and just as we need freedom of expression and protection from hate propaganda, we can and we must have privacy while fostering the public interest, including the prevention of crime. It is not a zero-sum game, and as in so many things, we must reject extremes in either direction. Canada can have a strong and effective law enforcement regime, including online, while at the same time providing a strong and effective legal regime to protect the personal information of Canadians. To make a comparison with the justice system, we would all as lawyers agree that procedural fairness and natural justice in trials are essential. But we also recognize that legal proceedings must be concluded without unreasonable delays and that the cost of the justice system must be managed effectively. We do not look at these goals as a zero-sum game where we're trading off fairness for cost savings or expediency. Instead, we need to work hard together as a legal profession and in whatever our roles in the system to ensure that the fundamental right to natural justice is protected while we achieve the other important public interest goals of timely and affordable justice. I'm not saying that this is easy, but I am saying that it is necessary. In my former role at the Canadian Human Rights Commission, I successfully argued in the Saskatchewan Human Rights Commission and Watcott case before the Supreme Court of Canada that hate propaganda prohibitions and human rights codes could be a reasonable limit to freedom of expression under Section 1 of the Charter. To do so, I put forward a narrow interpretation of the prohibition that applied to messages that dehumanized and demonized individuals, as had been held earlier by the Supreme Court in Keegstra and Taylor. This was another example of the court refusing to find a conflict of rights when rights could instead be reconciled and brought into balance. In Spencer, the Director of Public Prosecutions had argued that recognizing privacy as anonymity would impede the effective investigation and prosecution of online crime. This was another way of saying that it was a zero-sum game between privacy and the rule of law. The court properly rejected this argument, saying that, quote, recognizing that there may be a privacy interest in anonymity depending on the circumstances, did not, in fact, threaten the effectiveness of law enforcement in relation to offenses committed on the internet. In that case, the court said it seemed clear that the police had ample information to obtain a production order requiring Shaw to release the subscriber information corresponding to the IP address they had obtained. The way to avoid conflicts and to achieve both privacy and the public interest is by considering privacy at the front end, not after the fact. Doing so will be more cost efficient and effective, and the costs will become investments that are good for business and good for governments. In a survey earlier this year done by Cisco, 81% of respondents reported returns on their privacy-related spending. Money spent on protecting and promoting privacy is an investment in trust and the security of clients in both the private and public sectors. It is not an either-or proposition. Even in the context of privacy intrusive tools, such as facial recognition technology, my federal, provincial, territorial privacy commissioners in Canada, all of us have not called for an outright ban, but rather for a clear and strong legal framework to regulate its use. This was the subject of a recent report by the Ethics Committee of the House, which recommended a moratorium on the use of facial recognition technologies until they could be reviewed by courts or by my office. I welcomed the committee's report, which confirms and reiterates the pressing need to ensure that the appropriate regulation of privacy impactful technologies such as facial recognition and AI. I noted that the report confirmed the need for critical measures such as mandatory privacy impact assessments and consultations with my office prior to the adoption of creation and use of facial recognition technology, improved accountability and transparency through enhanced oversight and public reporting and consultation, strong and effective legal frameworks to set limits on the use of facial recognition technologies by police, and to ensure that privacy is protected at every stage of the process, and a need for the modernization of private and public sector privacy laws. Just last month, my provincial and territorial colleagues and I issued a resolution on digital identification. In announcing the resolution, I stated that the development and implementation of a digital ID ecosystem is a tremendous opportunity to demonstrate how innovation and privacy protection can coexist. We can all see the benefits of a system that will allow individuals, businesses, and governments to confirm identities and carry out transactions online with a high degree of efficiency and confidence. But we must also recognize that unless digital identity projects and the frameworks that support them meet high standards of privacy, security, and transparency and accountability, they will not be trusted enough to be widely adopted, and those benefits will not be realized. Our resolution called on governments and other stakeholders to build those characteristics into the ecosystem from the beginning. Earlier this summer, I attended the meeting of the G7 Data Protection Authorities in Bonn, Germany. The theme of our meeting was Data Free Flow with Trust. And our discussion focused on international data spaces, data transfer tools, privacy enhancing technologies, and de-identification standards. All of these themes support the proposition that privacy and international trade can and must coexist. Private sector privacy law reforms put forward by the government have sought this balance by giving organizations greater flexibility to use personal information even without consent if it was done for legitimate business interests. As you may recall from the OPC's submission on the former Bill C-11, which died on the order paper last summer, my office agreed with that intention if it was done within a rights-based framework in a necessary and proportionate manner and with greater corporate accountability. Some of the tools to achieve both the public and individual interest while protecting privacy include privacy by design, the preparation of privacy impact assessments in appropriate cases, and the regulation and use of de-identified information. Treating privacy as a fundamental right and finding ways to achieve the public interest and innovation at the same time is not only possible, it is indeed a virtuous circle that will generate trust and that will further benefit these interests. This brings me to my third pillar, privacy as an accelerator of trust in the digital economy. When Innovation Minister François-Philippe Champagne introduced Bill C-27 in June of this year, he emphasized the importance of trust. I agree, but would add that the way to achieve this trust is through the effective protection of privacy. When individuals trust that their rights will be protected, they feel confident about participating freely in the digital economy. This is good for Canadians, good for government and industry, and good for innovation. Yet in our most recent survey of Canadians, more than half of respondents felt businesses do not respect their privacy. How do we restore this trust? Let me highlight 3 ways. First, we need a strong set of public and private sector privacy laws that fairly and effectively regulate the collection, use, retention, and disclosure of personal information so that Canadians know that they're not alone in protecting their fundamental right to privacy. The Spencer decision is an example of this, where the legal system confirmed and protected Canadians' reasonable expectations of privacy. As I stated earlier, our laws need to be rights-based and provide effective remedies in cases of violation. Second, and this touches my office directly, we need to ensure that data protection authorities have the necessary authority and resources to provide not only compliance and protection mechanisms to deal with complaints, but to also play a strong advisory and promotion and prevention role in giving independent and expert advice and input to organizations. A recent example of the importance of organizations obtaining and being seen to obtain independent advice arose in the case of the RCMP's use of on-device investigative tools that can access content as well as activate the camera and audio functions of smartphones without the user's knowledge. In June of this year, the RCMP confirmed to Parliament that it had been using such a tool with judicial authorization, but without having notified my office, despite being required to do so under government policy. Canadians expressed concern about the situation, and the Ethics Committee of the House launched a study into the matter. In my testimony before the committee this summer, I noted that while there may be valid reasons for the use of such tools in appropriate circumstances, the RCMP's failure to consult my office had resulted in a reduction of Canadians' trust. I indicated that it was imperative that a privacy impact assessment be provided to my office in such cases, and that this should be made a binding legal requirement in the Privacy Act. In another appearance this summer before a Senate committee reviewing proposed amendments to the Broadcasting Act, I made a similar recommendation that the CRTC be required to engage with my office when it considers the issuance of orders that could have an impact on privacy. My hope is that in most of these situations, we would either be satisfied with the measures taken, or we would be able to provide advice resulting in course corrections at the outset. What is certain is that the very fact that these consultations would take place with my office would reassure Canadians that their privacy is properly considered and protected. A third measure to restore trust, we need to create a strong culture of privacy where Canadians do not feel that they're being nudged or encouraged to provide more information than what is strictly necessary and proportional to achieve an organization's purposes. We need to make it easy for Canadians to choose the most privacy protective settings and make it clear to them when, how, and why their information is collected, used, disclosed, and retained. Our findings in the Tim Hortons investigation, where the company's app tracked users' locations even when the app was not in use and without the user's knowledge or consent, demonstrates how trust can be undermined when privacy is not sufficiently considered and protected. serves as a reminder of the work that remains to be done as a society to promote a culture where privacy protection is the default setting and where Canadians have the reflex to always ask why their personal information is being sought. A culture of privacy, with privacy by design and privacy by default. In conclusion, there's no doubt that the modern economy and governments increasingly rely on the value of data extracted through digital technologies, but we have also seen the risks and the harms of technologies with inadequate privacy protections. Canadians should not have to look over their shoulders when using technology. The way forward is through reform of our privacy laws in a manner that recognizes and protects privacy as a fundamental right, while at the same time supporting the public interest and innovation and accelerating Canadians' trust in their institutions and in the digital economy. And with that, I would welcome your questions. Thank you, merci.
Thank you very much. Let me start by saying how impressive it is to see you have such a clear vision, barely, 4 months into the position? So, yeah. So
almost 5.
Yeah, so that is truly inspiring. There are questions from the audience, so I will go through the first and the second and the third. So the first question is, why do you think privacy by design is not specifically mentioned in Bill C-27, understanding that you are reserving your comments on Bill C-27 for your appearance before Parliament? If you could, as much as you can, say, why would you surmise privacy by design was not expressly included?
Right. Well, it is interesting, and I have to say, certainly with my current role and my former role as the law clerk of the House of Commons, I certainly would hesitate to put forward intentions or purposes of parliamentarians or ministers if I'm not if I was not involved in those discussions or not aware of them. But what I can say is that, and I've said this to the Ethics Committee this summer, and I've said it today, I view privacy by design and the preparation of privacy impact assessments in appropriate case as being not only important, but hugely beneficial to the organization itself. And so that's why I talked about the example today where the RCMP using what the acronym is audits, using these tools, quite privacy intrusive tools, and not having consulted my office or provided a privacy impact assessment, diminished trust because Canadians were concerned about these tools were so powerful. They were concerned to ensure that the privacy was considered. And privacy by design and privacy impact assessment does that. It makes sure that there's a culture of privacy that is considered in the design. It's always easier to put in place these things when you're designing projects, tools, and initiatives than after the fact. It's like building a structure with accessibility in mind as opposed to putting accessibility at the end of it. And so this is something that certainly my office recommended in the context of the previous C-11, and I've recommended it in the context of my committee appearances, both in the Senate and the House, with respect to privacy, potentially privacy intrusive measures.
Well, building upon the example of the RCMP, another question from the audience is, has the RCMP submitted a privacy impact assessment yet on the spyware?
We are waiting for that, but there have been good exchanges. There was a meeting between the RCMP and my office. We have received a presentation and information, and we have provided them with our input. And so this is what should have occurred before the parliamentary hearings, but it has occurred now, and it is progressing.
Mm-hmm. And if I can just add, in my experience, both as in the Office of the Privacy Commissioner of Canada and now as counsel to companies, privacy impact assessments are actually protective of the organization because they give the organization the lay of the land. What are the privacy risks? How do we have to mitigate it? What's our action plan? And so it really is, to me, critical to risk management. So I emphatically agree with you that they are critical to protection of the right to privacy. I would like to add that I also see it as protective of the organization. There's another question.
I agree.
Yeah?
Let me just jump. I'm sorry. I don't want to interrupt you, but I
go
just
ahead.
want to echo that, and that's why I spent so much time talking about privacy in support of the public interest and of innovation. It's really to see that you can be a champion for privacy, and at the same time, and as you are, Chantal, and others, advising or private organizations in a way that also supports their interests and also supports privacy. And that's a perfect example of it, where at the end of the day, it's not just about complying with your legal obligations. It's actually beneficial to you and to your clients and to your reputation.
Mm-hmm. And there's another question from the audience. If when you look at how the, let's say, the context of Bill 27 is occurring, do you have any idea, any sense, and of course nobody is asking you to predict the future, but if you had to say when you think it would be adopted, would you say, for example, that it's realistic that it be adopted before the end of 2023? Do you have any framework that you would put around what you see as a realistic expectation of the adoption of Bill C-27?
It's very difficult to say. We have a minority parliament. What I can say, it's now being debated last Friday at second reading. So that is a positive step. That there is a tabling of the bill in June is positive step. It's now being brought forward for debate. So I don't have a sense in terms of how quickly the House tends to. They will sit later, and this is with my hat of law clerk of the House. The House sits later, and there's always a push towards the end of the December session, and then also towards the end of the June session. But really, one of the things I learned with my time at the House is that time is a very precious and very rare commodity for the House and for parliamentarians. So difficult to say, but it is certainly overdue to have a modernization of both private sector privacy legislation and public sector privacy legislation, which is even older. And so that is something that we have been calling for some time, as have many. It'll be important to get it right, and I look forward to being able to provide my advice to Parliament in this context. And I know that there'll be many others, but I've had a good. One of my early priorities was to engage with stakeholders, both from industry, government, academia, civil society, and so I've done that, and it's been very helpful. And I'm confident that there'll be a good debate in Parliament as there should be.
Mm-hmm. One question that I have heard from several private companies, they are musing, wondering how your attachment to human rights, to privacy as a fundamental right, how will that impact your enforcement of the law? In particular, they will wonder how much of their interests and operational realities would you take into consideration through that prism of privacy as a fundamental human right?
Right. No, that's an important element, and I mentioned it in my remarks today. Privacy as a fundamental right ultimately means what is the result of it being a quasi-constitutional right is that it will, if there is a conflict within privacy and other interests, privacy will prevail. That's the same thing for anti-discrimination provisions, or it's the same thing with constitutional provisions. But before you get to that, you need to do all the work necessary to avoid getting there. And that's what the Supreme Court of Canada said in the same-sex marriage reference when there was discussion about conflicts of rights between the right to equality for the protection of same-sex marriage and the right to freedom of religion, which was being put forward as an obstacle to that and as, again, a sort of a zero-sum game. And the court, rightly, obviously, I have to say that it's the right decision, that the court's decision at the end of the day found that before you reach the conclusion that there's a conflict, you need to really explore all the other ways to avoid it. And it's only in those rare cases where there actually is one that you will need to resolve it. And that's why you need principles like privacy as a fundamental right for these situations. So it's the last resort. It's not the first resort. And that's the same thing for enforcement mechanisms. I see those as last resorts. They should be used in major cases where there are significant violations, but I see them mostly as very helpful incentives to encourage prevention and discussion and remediation early on. That's the approach that I used to take when I was at the Human Rights Commission, to try to prevent and to understand, I think to the point you mentioned about understanding the realities and imperatives of organizations, that will be a priority. It's something that I did when I was at the Human Rights Commission and as law clerk of the House to the same extent, where we were in a way, I was in a way the Department of Justice to the legislative branch. It's imperative to understand the realities and implications of parties, partners, and certainly regulated entities. And I certainly am, and very proud to be a human rights lawyer and a promoter and protector. But I am also a senior executive. I am also an employer. I am also responsible for compliance with legal regimes and legal obligations. And when I was with the House, I was essentially the chief legal officer. And so I understand the realities and challenges and difficulties and sometimes frustrations for CEOs and VPs and boards of directors to juggle all these many pressures. And I understand and appreciate the value that privacy champions such as yourself and private sector counsel, in-house counsel bring to the table. And so this is and I've reached out to stakeholder and industry early on in my mandate as privacy commissioner. As you say, this is my 5th month, but it is important. We need to understand those realities. And I can say with a smile that I have been, in a sense, in your shoes vis-a-vis my now colleague, the ethics commissioner, Mario Dion, because he regulates members of parliament. And I had occasion to appear in parliamentary committees to comment on some of his proposed strengthening of the ethics code for members of parliament. And my job there was to put forward the realities of parliamentarians and say, look at how they operate and look at what the impact will be on about these rules that you put forward. It may make sense in theory and in principle, but there may be some unintended consequences on the reality of this important function, which is the role of a parliamentarian. So it's a similar approach that I will be bringing as privacy commissioner.
You and I have had this discussion before, and I came out of it with the description of your approach as being pragmatic. Is that a fair description, would you say? A pragmatic approach?
I think so. I would add principled and pragmatic. So again, it's not an either or proposition. I am very firmly committed to the principles, and as you have seen, I have been from my confirmation hearings onwards, and in every presentation, I start off with privacy as a fundamental right, and I spend a lot of time on that because I do think it is essential. And I know that there have been some questions raised about whether it should be so or whether there are concerns about that. I am firmly of the view that it is and it should be so. But I do not see that as being contradictory to a pragmatic approach that also makes sense and that also will be supportive of government's needs in terms of public interest and industry's need in terms of innovation and competitiveness.
So let me turn to another question from the audience, and I will read it to you to be faithful to it. You described trust as one of the 3 pillars of privacy. You also described a culture of privacy as an important part of promoting trust. what concrete measures, activities, or tools do you see the OPC using to assist, motivate businesses in developing a culture of privacy?
Well, we need to be present and open and available with businesses and with government. So I talked about the need for privacy impact assessments and consultation with my office. We need to be able to deliver on that, and we will need to be properly resourced to be able to do that. We have a business advisory section, directorate in Toronto. We have a government advisory section, and we are available to advise. We need to be trusted to do so, and I've had discussions with stakeholders in industry about why there has not been as high a take up as we would have wanted to see of those services, and concerns about how do we manage this with our compliance functions, and can organizations do that while managing their risks? And I absolutely understand that. So we need to have that service. We need to be able to provide insights and inputs to assist Canadians, individuals to know their privacy rights, organizations how to put them in place, how to correct, how to redress. I really see the twin roles that we have in terms of protection and promotion working together. I want the promotion to come first and the protection to come if necessary, but ideally we are able to assist and to publish guidance documents. There's going to be certainly lots of, again, I don't want to presume what Parliament's decision will be, but in its current form, there is a regulation making power under C27 to provide certain more precision on certain concepts. There is opportunity for my office to provide guidance. So that's very important. I think we need to be, and I will do this myself as Privacy Commissioner, publicly communicating on the importance of privacy. And I mentioned in my confirmation hearings in the Senate the importance of children and youth. This is something that is in C27, but I do think it is important that we communicate with Canadians of all ages, but certainly in particular teenagers and minors about privacy, about its importance. They are living in the world where they're using digital tools more and more. They are being asked to share information more and more. So it's important for them to have a good understanding of what the implications are, and that they value this, and that they be aware of what it means. And so all of this, I think, and again, it was striking to me to see how both with respect to the RCMP's use of tools, on-device investigative tools, but also in terms of the mobility tracking, in terms of the public health, the pandemic situation, the fact that there hadn't been a meaningful consultations with my office was a missed opportunity in generating trust for Canadians. And so that's something I want to make sure that we can certainly do our part as the OPCs.
So building on that, if we look at a possible formalization of, yes, the new powers that Bill C27 would give you in terms of guidance to companies, as well as your existing business advisory program and your own approach, I would like to put to you whether you would envisage formalizing this approach in a sandbox model, a bit akin to what the United Kingdom Information Commissioner's Office did, whereby a company can bring to the sandbox team, so to speak, their project. The ICO will say, these are the privacy issues we have, these are our recommendations, very concrete. The company is able to truly put forward its intentions without fear, because the sandbox is truly a safe space for that. They know that coming to the ICO with a project that the ICO has issues with will not lead to an investigation. So that sandbox model has been adopted by other, in fact, in Canada, the financial regulators use the sandbox model. Is that something that you would consider? Is that could be envisaged to formalize it in some way?
Absolutely. I think this is something that has been explored elsewhere. It's something that offers many benefits. I think the to some extent there's some elements of that in C27 in terms of having us review privacy management programs or certification codes. But there is this issue that you highlight in terms of doing so. How do you do that with the certainty that this is not going to be usable in compliance functions? So it's certainly something worth looking at. I think one of the issues that is top of mind for me in looking at initiatives like this is really the concept of resources. They're finite resources for my office. They're finite resources for government and for Parliament as a whole. And so that is something that would be beneficial, but we want to make sure that there are sufficient resources overall in the system before we can do this.
All right, very interesting. I would like also to put to you a discussion we've had this morning with respect to a notion of the collective right to privacy, specifically the regulation or not of anonymized information. And we're talking where the data, the substantive information, is truly irreversibly severed from any identifier. And so Dr. Teresa Scassa was mentioning this morning, saying we need to pay attention to that in the name of a collective right to privacy that she would say needs to be addressed further. I would love to hear you on that notion of a collective right to privacy.
Well, I think that this is something that we have been hearing more and more, and it's been raised also, and this may well have been mentioned earlier today, but it was raised in the context of Indigenous peoples and consulting Indigenous peoples with respect to privacy law reform. I understand this is happening with respect to potential Privacy Act law reform for public sector. And so looking at these concepts, I think it is a question worth asking, to see certainly the focus of privacy legislation has been in terms of identifiable individuals, so at the individual level, and certainly need to make sure that we get this right. And definitions of anonymization and de-identification, I think, are built on that premise of ensuring that you cannot identify an individual, or that you're mitigating the risk as much as possible. But it is a good question to ask as to whether there may not be the ability to identify specific individuals, but are there other types of harms that will nonetheless flow from this with respect to identifying certain groups of individuals and drawing some conclusions. And so that could give rise to a number of questions, from privacy questions to equality questions. And so that is, again, without commenting on the ADA part of Bill C-27 in terms of proposed regulation of artificial intelligence, but that is one of the concepts being put forward in terms of looking at harms, including human rights harms, and in the decision making.
So possibly going outside of the realm of the right to privacy, which attaches to individuals, but not forgetting that there are human rights issues beyond the right to individual privacy. Another question has come up from the audience. I'd like to read it to you to be faithful to it. The OPC has historically highlighted non-compliant activities by organizations. In the future, would the OPC be willing to highlight companies that do privacy well and have a culture of privacy to encourage engagement? In other words, could there be a carrot as well as a stick?
I try. I usually don't say this is a great question because I don't want to suggest that the other questions I've been asked before or after were not great questions. But I will say this is a great question. In here, I am biased on it, but I have stated this in my confirmation hearings. I think both in the House and in the Senate. It's certainly something I believe in. And it's part of the element of trust as my third pillar of privacy. I think generating trust of Canadians in their institutions also includes Canadians seeing not only when there are breaches and concerns and violations, but also seeing when there's good protection and good action, good promotion and prevention. I think it is important to highlight this, and I think it's important for me personally as privacy commissioner, but also for my office to do so, because our voice is credible and has an impact. And so certainly important to call out concerns, and we do that. But I'm a big believer in incentives. I want to put incentives in the right directions and encourage behaviors. I believe that in-house counsel and privacy advisors everywhere can be champions of privacy. And so we need to give the incentives, give the arguments when you're convincing your clients or your organizations to do the right thing. And I've been in those shoes. It helps to be able to say, well, not only are you going to avoid this potential negative outcome, but also you can have good outcomes. And perhaps to get the good outcomes, you need to do a little bit more than what you need to do to avoid the bad one, but it is worth it. And so that's certainly something that I will want to do.
Thank you. Another question that comes out of Dr. Teresa Scasa's presentation this morning was, what is the future of cooperation between federal and privacy commissioners provincial after there is the creation of a tribunal? Do you see that having an impact on the collaboration between yourself and your provincial counterparts?
Well, I think that the collaboration with the counterparts is excellent. It will continue to be excellent, and it needs to continue. I've heard from industry stakeholders about how beneficial it is when we can work together as regulators, and we've done joint investigations. As you know, we've done joint statements. I talked about some of them today. We did one on health and making sure to protect health information and stopping to use the fax and using more secure and modern technology. So that's important. It's beneficial for everyone. I know that, and certainly looking back at C11, there were discussions about the tribunal and the proposed tribunal and what the impact will be. Obviously, I won't comment specifically on that because I will wait to make my comments and recommendations to Parliament before I make them publicly. But what I can say is that we will always find ways to work together and to coordinate. And if there is a tribunal or whatever review process, there are review processes in the provinces as well with the court systems. So it's something that we'll need to manage. But it has been raised by my office in the context of C11, the risk that if one process, whether it's the federal one or others, becomes so much less advantageous or quick or helpful, then that may raise challenges in terms of interoperability. So that's certainly something that we have been pushing and supporting in terms of ensuring that the regimes are interoperable, that they can work. That's important in Canada. It's important internationally as well. When I was in Bonn with my G7 colleagues, we talked about data free flow with trust. Obviously, that touches upon the issue of adequacy. It's important to Canada maintain adequacy under the GDPR, that our regimes are considered to be robust. And to me, I see this as the contrary of the lowest common denominator. It's the highest common denominator. We want to push towards the best regimes, but this idea of making sure that they can work with one another, very important. And I would add, so not only in Canada do we need to do it between federal, provincial, territorial, not only do we need to do it internationally, but we also need to do it with public-private relationships. So we're seeing more and more public-private partnerships between the government and the private sector in the delivery of public service. I think that's a good thing from a standpoint of innovation, and there can be benefits to taking the best of both worlds. But we run into challenges if the legal regime for public sector privacy is so different from the one for public sector, or vice versa. So it will be important, and I've said publicly that I hope to see private sector modernization happen, and for it to be followed shortly thereafter by public sector modernization, which is even more overdue if you look at the years. The Privacy Act is 40 years old.
Another crosswalk of cooperation that is created in Bill C-27 is between yourself and other non-privacy regulators. And this morning, Christopher Parson in his keynote mentioned the issue of competition law with this agglomeration of companies leading to data accumulation with the privacy impacts that we can imagine through the potential of triangulation of data and therefore very precise profiles. So then the question is, how do you see yourself cooperating, for example, with the director of the Competition Bureau? How do you find that appealing? Is that in your mind the right way to go? And if it is, then how do you envisage it?
I think that this is something, it's a very important topic. There are more and more issues of intersectionality between privacy and competition, privacy and broadcasting. So these situations arise where you may have issues where is privacy being used as an anti-competitive measure, vice versa. So is there an opportunity to work together? So this is something that I will look forward to doing within the confines of the legislation that we have. And so it's important to review that, but where it can be done without prejudice to the parties, without prejudice to confidentiality. And this is something that I was recently discussing with the Senate committee on the new C11 on broadcasting and the regulation of internet streamers. We had a discussion with the Senate committee about privacy implications when the CRTC would make orders to broadcasters with respect to certain potential algorithm use and so on in order to recommend certain content. And so there you have the intersection of broadcasting and privacy. And so there is a mechanism in the Broadcasting Act for there to be interventions in CRTC hearings when they're considering orders. I've indicated that's something we would explore as an ability, but certainly an important topic. And we are more and more in an interconnected world, whether geographically in terms of technology, but also in terms of legal regimes. And so it's important that we, as much as we can coordinate those things. It's better for the evolution of the law, but it's also better for the regulated entities who can have it dealt with in a consistent manner.
Thank you so much. Sadly, we have come the top of the hour. You have been so generous, so insightful, so open. This truly bodes well for your term as Privacy Commissioner of Canada and for Canadians. And so thank you very much. And we look forward to hearing you before the House on Bill C-27 and hearing you throughout the next 7 years, guiding the protection of the right to privacy in Canada. Many, many thanks.
Thank you so much, Chantal and colleagues. Great to be here.
Wonderful. I turn then to Amanda Branch, who will moderate the panel on regulating advertisement online and yet keeping a free internet. So over to you, Amanda.
I am excited to introduce my panel, which will address the tensions between controlling advertisement and keeping the internet free. I'm privileged to be joined today by Marina, Sonia, and Stephen, all experts in the area of privacy, advertising, and internet policy. So in brief, Marina Pavlovic is co-director of the Center for Law, Technology, and Society and an associate professor within the Faculty of Law at the University of Ottawa. Her research focuses on consumer rights in the contemporary cross-border digital society and technology policy and regulation. Sonia Carreno is the president of IAB Canada, the recognized voice and thought leader of the Canadian interactive marketing and advertising industry. Among her many accomplishments, she has been developing standards for the Canadian market in response to GDPR regulations in the UK and has presented to the Canadian House of Commons about privacy regulations. Stephen Bonner is the Deputy Information Commissioner at the ICO, the UK's independent body set up to uphold information rights. His current role includes leading the teams reviewing the technology ecosystem around ad tech and the teams auditing and enforcing in this space. So to briefly introduce our topic, I think advertising and privacy on the internet is such an interesting space, particularly as consumers and users become more aware of advertising online. And in particular, how their personal information is central to some types of advertising. And there can be a lot more going on in the background that users aren't even aware of. So in the panels this morning, we heard a lot about the importance of transparency, particularly ensuring consumers understand what's happening with their data, coupled with the responsibility of the organization to describe their practice accurately. And this is in an effort to help consumers adjust their expectations. As we know, expectations are important. In the privacy world, we talk a lot about not being creepy, as in not doing things that are surprising or unexpected that will creep out your users. But advertising can be full of creepy things. I am sure many of you remember being a little or a lot creeped out when you found your Google search following you around the internet in the form of ads popping up on unrelated web pages when you least expected it. But what is creepy does depend on public opinion, the specific expectations and understanding of the user, and the outcomes. And I'm sure this is something we've all experienced. So by way of personal example, a few years ago, one of my favorite retailers was having their semi-annual sale, but I was on vacation, and in the excitement of traveling and time zone differences, I missed the sale and was super disappointed because I had a cart full of items. A few days later, I got an email from that retailer saying, "Hey, Amanda, we noticed you missed our recent sale. Since you always buy things from us during the sale, we'd like to offer you a discount code." Of course, I was thrilled. I also realized this meant my purchasing behavior was being closely tracked, and I don't recall being clearly made aware of that practice. But quite honestly, since it resulted in something I did want, in that moment, I was more than happy for the retailer to be tracking my purchasing patterns. But there's so much more to advertising than just not being creepy. And so I've asked each of our panelists to speak about a tension that's on their mind, and we're happy to take questions from participants. So if you have questions, please put them in the Q&A box, and I'll turn now to Marina to kick off our discussion.
Thanks so much, Amanda, and thank you to Dentons and ICJ for hosting this. I'm delighted to be here and sharing this panel with Stephen and Sonia, because I think we all approach this issue from very different perspectives. So I think it's not just about not being creepy. I think the challenge with advertising that it has shaped or is shaping the internet as we know it. And I think at this point, we may be at the point where it's almost breaking the internet. And so I think while advertising helped build the internet the way it is, I think we're at a point that we understand that the ad-driven internet is not necessarily sustainable, but it may not necessarily be as harmless as we used to think. So yes, we all like to get discounts for our favorite goods, But I think at this point, advertising is actually much more. It's much more than just the commercial aspect that we all tend to think about when we think about this. So there are considerable privacy concerns. I think there are considerable commercial concerns. There are competition concerns. There are functional concerns in terms of whether the internet can operate without advertising. And I think there are considerable concerns both for individual users, which is all of us, and the network operators, like service providers who actually run the networks. And from my perspective, I think most importantly, for the functioning not just of the free and open internet, but for the functioning of the free and open democratic society. And I'll touch upon political advertising in a second, because I think we have moved from an area where advertising was, again, just for purely commercial purposes, where we're pushing products, to entering a number of different areas that we haven't had it before, or if it existed, it was under a very strict and controlled environment. And so that the results that we're seeing are very, very different. So I think Stephen and Sonia will touch much more on privacy and commercial concerns and related tensions. And I thought within this introduction, perhaps to highlight some tensions that are not necessarily keeping me at night, but are of a growing concern. And so I think we're past the stage where we were kind of initially ignorant and then maybe tacitly accepting the fact that certain internet services, mainly social media, but not just them, a bunch of others, come nominally free, but are actually paid by users with their data, which is then used for targeted advertising. Like, I think we're past the stage where this type of social bargaining was acceptable. Because we're seeing that, first of all, the data that's being collected is much more robust and can be manipulated in ways that couldn't be manipulated before. That the sophistication of AI and algorithms is just growing, and what's being collected and what's being done with data is very, very different than what we knew before. And I think we're past the stage where advertising is just seen as an annoyance, right? Where certain products are being pushed at you. So if you browsed at your, again, favorite retailer, then for the next a month, whichever website you go to, there's going to be, oh, this particular shoe, is going to be on sale, right? So that it's actually like we're in a different era, I think, and we need different tools to approach this. I'm hesitant to say to regulate, because there are different forms of regulation. And I think, as the Privacy Commissioner mentioned, there's a considerable intersection of both issues and playing fields. And then, like, if you pull one strand, you kind of have to pull all the other strands. And I don't think we have reached the consensus where we can kind of approach issues holistically. We're still regulating things in their own silos, and there are lots of unintended consequences for some of that. So I think on the somewhat positive side, advertising does provide a revenue stream for unlikely players, such as individual users, in the influencer category. And I don't mean Kardashians, but like, mom and pop stores or solo businesses, who either run their stores or have some sort of, website where they provide content, and do provide, and do receive some considerable income from that advertising. And I think that's a good thing. I think it's a good thing to allow a variety of different people to, monetize on some of the expert knowledge that they may have. But I think the extra revenue for these categories of people who are not necessarily the ones that we usually think of has implications for individual users and who are consumers of that content, right? That there are very few web pages now that you can visit that are on the surface ad-free, and most of them in the background at the back end are not ad-free as well, right? So, and I think one of the concerns that we don't necessarily talk about when we talk about these things is the ad traffic consumes a large portion of users' bandwidth. And I guess a corollary to that is a network traffic. And there are various numbers and various studies being done, that the ad traffic is from 20 to 50%. Like, I haven't found one that I was kind of happy with that would put it in a specific percentage. But let's say even if it's like at the 20% range, that's a huge amount of traffic, right? Like, that requires a lot of networking power the provider side, and provides a lot of pressure for the network to ensure that the traffic is flowing. But it also provides a lot of pressure on individual users, and particularly in Canada, where we know that people in rural and remote communities are still struggling to have broadband access that's not limited, right? So that they have caps on how much they can use, and if 20% of that is invisible ad traffic, it is actually, there are considerable, I think, equity concerns in terms of that, we all use internet now, not just to play, but to work and study, et cetera. So I think there's a growing number of users who are using ad blockers, and those numbers have gone from 20% to almost 70%, depending on the category of people you're polling. In my household, we ran an experiment last week, because I live with a techie, and I said, could we just sort of see, how the traffic looks like when we run ad blockers, not on our individual browsers, but like at the network level. So we did put something on our server, on our router, to see, what the traffic looks like in a week. And what I thought was absolutely fascinating is that 155,000 domains that were accessed from our network were on the ad list, so that there were at least once there was a ping to a domain name, so the 155,000 domains, and I think the rest of our traffic was in sort of 50,000 domain category, not even, right? And that was things happening knowingly or unknowingly in a week's time. So I don't have the particular percentage of the traffic that it did, but for me, the volume was just remarkable in terms of that, any web page that I used would have had not one, but multiple ads. And I think what I found most fascinating is that certain websites were just not functional at all. So if I was looking at a blog post, to, I don't know, how to can green tomatoes, because it was a harvest season, right? That I couldn't see, half of the page was blank because those were the ads that were moved. But what I found fascinating is when I went to Canadian Tire to check whether they had mason jars for my canned green tomatoes, that I could not actually access the Canadian Tire website. It was literally blocked and it wouldn't open. And so then when I switched from my home network to my cell network, where we didn't have, the thingamajiggy that we had on our router, then I could totally access the Canadian Tire website, and I could look for mason jars, et cetera, right? And so for me, the fact that, the ads make the internet work the way it is, but if you want to eliminate them, it literally breaks the internet and it does not work, is a huge concern. And I think part of the challenge is figuring out where are the areas and pockets that we could potentially write, how do we fix this? And again, I don't think it's possible to have an ad-free internet, because we don't have ad-free media even in other mediums, right? So ads are necessary, they're what they are, but could we approach them from the perspective of, again, understanding how they function, and what are the areas where we could functionally eliminate them or minimize them? And then there are obviously issues of privacy, transparency, et cetera, right? So for me, I think the issue is, it's not just keeping free and open internet, it's how do we make it better? Because I think where we are right now, that it's not necessarily at the breaking point, but it might be at the breaking point, right? And that we're looking at these bigger issues, and some of the earlier panels talked about, and advertising usually, again, seems to be in that commercial category. It's somewhat harmless, it's pushing the things that you might like, and if you don't like it, you kind of just ignore it. And I think that's a problem, again, because it's not just who we regulate, what are jurisdictional parameters of that regulation. Can we actually jurisdictionally even regulate in the first place? Is it regulation versus self-regulation, as the Privacy Commissioner was talking about? It is necessarily going to be some sort of public-private partnership in terms of regulation. But because it goes through so many horizontally areas of law, including privacy and competition and consumer protection, and transparency, et cetera. Like, how do we do it in a way that the users feel comfortable continuing to use the internet, and if they don't want to see the ads and they have an ad blocker, that they can actually access the content that they want and they need. So I'm looking forward to Stephen and Sonia talking about some of their perspectives in terms of like, where do we go from here? I'm hopeful that it's fixable, but let's see if we can fix it one way or the other. Thank you.
Thanks, Marina. That was so interesting. And I loved hearing about your experiment that you did. And that's a huge volume of websites with ads. And it's so interesting to hear that some websites don't function when you turn the ads off. I know some of those like recipe websites where you have to scroll through a million ads before you can get like the 4-line recipe that you want are kind of annoying, but it's so interesting to sort of hear how the ad blocker really impacts that. So I'll turn to you now, Sonia, to let us know what tensions are on your mind.
Well, great. Thank you. Well, I feel like I now need to respond to about 7 points that Marina made representing the online advertising industry. I would like to first start by saying, yes, online advertising is absolutely necessary. It's not breaking the internet. I think the internet itself is in its very early iteration right now. We still have many, many innings of this game to play. And just having come off a couple of days of just a conference about blockchain and Web3, there's some really interesting developments happening in the next couple of years, and a lot of them are going to address some of the biggest tensions that we're faced with today. And so I'm just I'll keep it brief in terms of what we're seeing as the tensions, so that we can have a little bit of discussion around it. But for us, there's the major trifecta now of the consumers actually starting to understand what advertising is doing online and how it functions. And so that is actually a welcomed thing for the online advertising industry. There's been books written about the fact that consumers were eventually going to take control of how they experience the internet anyways. Yeah, it took 20 years for that to happen, but here we are, and they're actually putting their foot down and threatening things like ad blocking. A note on ad blocking, this is a $10 billion industry in Canada, and when you think about the headlines that you're seeing today, and this week, I mean, we're talking about tens of thousands of people that are losing their jobs directly as a result of advertising sales going down. So this is not just, oh no, I'm being followed around the internet for a pair of shoes. This is about people's livelihoods and employment and a big part of our economy. Can it be improved? Of course, but everything can be improved. So that's the first part, is the consumers. The second part is the fact that we're not unaware. So ad tech has had a head start on this. And as you could see by the demise of the third-party cookie, a lot of the creepiness that we're talking about is actually in the process of being eliminated as we speak, but we just can't wait for it. So we still talk about it, even though all of the headlines in the online advertising industry are all about the fact that that is going away by virtue of the fact that the technology is not going to be available to do it. Right. So I think that's a really important note. So before everybody sort of starts Googling, what's the best ad blocker, please don't do that. First of all, because there's, again, livelihoods at stake, and also because we're fixing it. And technology is actually making that happen. And then the third aspect is, of course, regulation. And so, and this has also been something that we've been getting ahead of since 2018, when even earlier than 2018, in 2017, the online advertising industry started taking note of the GDPR and started to build frameworks around transparency and consent that were more than placebo. Right. So more than just sort of saying, I don't like advertising, and now I've clicked a button and I've sort of made myself clear that I don't like advertising, but the advertising persists, that is going away. And now we're having meaningful consent mechanisms. In Canada, we're launching ours in the next coming week or so. And this is all about being able to get meaningful consent from a user and having that consent be signaled across the entire supply chain so that everybody knows whether or not they can process data or not. So, so that's kind of my third point, and the fact that regulation can sometimes be a good thing. I think that it helps to accelerate some of the technology and some of the solutions that we're looking at. I do think that I would agree with Marina in the perspective that regulators are looking at things in isolation and not necessarily from a holistic perspective. And one example of that we've seen in recent years is the regulation of marketing food and beverage to children in Canada, and some of the proposed remedies for that and some of the proposed legislation that we've seen has been extremely challenging. And I'll just share why. If you want to eliminate high fat, high sodium, high sugar ads landing in front of a, let's say, 16-year-old, and you also, and that's over here, right? So that's Health Canada. And then over here, the OPC is wanting to preserve privacy. Can you tell me how I can avoid a 16-year-old getting exposed to a piece of pizza without breaking about 4 privacy laws? Right? So that to me is very real tension. And one that, you know, again, I digress back to the Web3 and blockchain. We're solving for it. We're going to get to a place where there is going to be a world that has, you know, surgically available data that does not disclose whole profile information or where you live or all of the details of your life, but rather just, are you, you know, are you affected by this legislation? If so, then no ad will be sent your way. And that's signaling. And that's something that is currently in the very, very early stages. And we see that with our consent transparency mechanism that's being launched in Canada in the coming weeks. And we've got some, you know, information about that. So if anybody needs to read up on it, just go to our website. It's all free, and stay in touch on that. But recognize that this is a journey. It's an evolution. And the next iteration of blockchain infused web is going to address a lot of the things that are on everyone's wish list, and is going to create a balanced approach to privacy and allow the internet to thrive. And I do want to close my opening statement with also just saying, look, advertising is necessary. Advertising works. And if you look at some of the models that are out there, look at Netflix. Netflix has for years been built on the idea of subscription, and just recently said, you know what, we can't sustain this anymore. We can't sustain content without having an ad-supported model. And publishers depend on it. And if you want to talk about open and free and democratic access to information online, then advertising is the best opportunity to make that happen. And it provides livelihoods, it preserves Canadian national news and access to that news. And it's essential. It's essential to our culture, and it's essential to our country that we preserve some sort of a balance of privacy, and advertising does not get eliminated from the web. And ad blocking is a form of theft. Right, is our position. I mean, it's frankly, it's pirating content, right? Those journalists need to get paid. So that's but I look forward to hearing what everyone else has to say.
Thank you, Sonia. Stephen, we've heard a lot about regulation, what regulators shouldn't do. We're excited to hear your thoughts.
Thank you. Hello, everybody. Our fundamental view is the ways in which the current ad tech and online monitoring and tracking ecosystem function are broken. Now, I suspect I may have caused some immediate tension in the audience and perhaps other panelists, so let's drill down a little bit into that. For UK customers, the focus tends to be on the scene, the obvious visual elements such as improving the cookie prompts and pop-ups, which is supposed to give customers a level of choice in relation to what's put on their devices. And pretty much every customer I talk to has tension about these, the sort of get out my face reaction caused by inconvenient boxes popping up on every website they're trying to use in Europe and in the UK. previous commissioner very memorably put this, it sucks the joy out of browsing the internet, which is not the intent of our privacy rules. And we're getting tense too. A number of these things we see don't have the right wording on them. If you want to cause tension for us, make those pop-ups completely incomprehensible, not compliant with data protection law, and written in a highly complex legalese. I'm sure many of the lawyers on the session today can understand, but normal people just cannot. We're working from the very largest sites downwards, changing some of this. For instance, we contributed to changes that occurred in the UK and Europe at Google, where in their consent flows for new users, they now have buttons for accept and reject at the same level at the top. Now, it's a small change, but it's quite an important one. That's better choice architecture, and it's becoming the new standard to have that decision about your cookies at the very top level. And there's no way around this. If you need consent, you need consent. You can't trick people into consenting to things. And I'd say, even if you don't need it in your protection jurisdiction, you should want it. People should be encouraged and engaged to do this because you're offering them something valuable, or that they recognize the goal you're trying to achieve. We're already engaging about 30 other organizations to ask them make improvements in a similar way. But it's not enough to fiddle around at the edges. Many of the problems here are unseen. They're the hidden inner workings. Now, just to reassure Sonia, we absolutely love ads. The internet they funded is brilliant. As she highlighted, it was already in my notes here, so I can assure you we were already on board with this. They support a free press. They let small organizations generate revenue immediately that allows them to try new things and have innovation and growth that gives us some of the amazing things we use. But we're clear there are absolutely ways to reach customers without the illegal use of data. Things like contextual advertising are highly likely to meet our requirements in an easier way. We don't want privacy to just be for those who can pay for it. It should be a right for all. And we love that its change here is starting to be seen inevitable. Again, as Sonia highlighted, we get that everyone gets this needs to change. Now, we think it shouldn't just be tinkering at the edges. It needs to be substantial to become compliant. And its key benefit actually isn't only compliance with data protection laws in jurisdictions around the world, but it's to regain the trust of all players in the ecosystem. And that change needs to be global. And our work we've done so far around ad tech and data broking and real-time bidding has found some systemic issues. We've audited various companies, and we found evidence that many of the problems we identified in our pre-pandemic work on this topic still persist. The most common themes we see are insufficient transparency, poor consent practices, as I highlighted, weak security over the data as it's shared amongst third parties, and over retention of the data beyond the use it's needed to provide the service to the customer. Now, as well as those tensions, we also see that there is occasionally perceived a tension between competition law and privacy law, as some of your, I think was asked in the previous session. Ironically, we're not in competition with the competition authorities. We absolutely see that a vibrant and competitive environment actually allows users to make choices about who they use based on privacy if they care about that. It can be in a free and fair market without dominant players. That is more likely to occur. We published a joint statement with our UK competition authority, the CMA, last year, and laid the ways we're going to collaborate. One of those has been working with some of the big players about the post-cookie world to make sure they don't get an unfair advantage from the data that they have in their position. At our heart, we believe data protection laws are a how-to, not a don't do. This isn't a piece of elastic being stretched to breaking point from both ends. We're not here to tell you can't sell things. We're here to say there are certain things you have to consider when doing so. And any teeth grinding from our tension you hear because we don't think it might not be happening fast enough or far enough. We also consider our work in a wider context, as has been highlighted, potential harms being caused to children by advertising. And we've recently published an opinion that considers how age assurance mechanisms can cut through that potential tension between collecting extra private data to get to the answer, but also ensuring that children are protected from adult harmful or otherwise inappropriate content. It's great to be an invited event for the nation from the G7 because some of our international work has worked with them because, believe it or not, there's sometimes tension between regulators, a world in which British citizens can use Canadian services safely and with confidence, and that Canadian citizens can use British services with confidence and trust. We think the world is better if there is a free flow of data with trust. Nobody wants a system where we're all pulling in different directions. We want to coordinate and have a level of coherence on standards, while we absolutely respect that different countries have different laws, cultural attitudes, and behaviors. We want to get to the place where we have a smooth service that works for everyone, powered by advertising, but in a way that doesn't harm people's privacy. We've got a way to go. A recent survey we did, we saw 60% of UK customers agree or strongly agree with the statement. I find it intrusive when I get advertising that's been targeted specifically to me because of things I've searched for or done online in the past. And I think I would expect from conversations I've had that may be a similar feeling. We've got to get past that feeling. We need to alleviate that tension of intrusion by not stretching trust. Trust will allow us all to enjoy ad-funded services without that tension headache. Thank you.
Thank you, Stephen. That was really interesting and great to hear your perspective. So before I turn to questions, I know we've got a lot that's been said here, so I want to sort of open the floor if anyone has anything that this has sparked or anything. I thought so.
Yeah, no, but just very, very briefly. I really appreciated that, those notes, and I think that it's really important to reiterate again. Look, we're doing the best that we can with the current state of what we have, and while we recognize, honestly, we didn't invent cookie banners. We didn't invent them. We were actually forced into a place where we had to have something. There's no alternative. When you have a piece of regulation that says you need to notify somebody before or at the time of processing, there is no technical solution other than a cookie banner today, I stress, other than that. And so, yes, it's not ideal, but it is what we have. And at a very minimum, I think what the industry is doing is we're trying to ensure that at least that works, right? So we're trying to do everything that we can to keep the industry in check, to keep it in compliance with the tools that we have today, with the view that this will become outdated and there will be new technologies that address things in a more holistic and a natural way. That's the point I just wanted to make there.
So can I just jump in? I think, Sonia, I understand your perspective. I heavily disagree with it. And I think I would like to have a conversation that's not at the level ad blockers or theft, because people's perceptions are different. And, when we talk about livelihoods, there are other things and other technologies that are impacting people's livelihoods. Ads are impacting the election results and like literal lives of people in other countries. So I think we have to be really careful, again, not to put it purely on a commercial level where if you block ads, people are losing jobs, because we're past that stage. It is still largely commercial, but it's not. And the fact that, blockchain will solve everything, I'm really sorry, but I'm very, very skeptical. And I think at this point, we need to do better. Everybody needs to do better. And I'm highly skeptical of the consent model that, the users are going to agree, they're going to click on I agree, and, I'll be totally fine with being followed and stuff. My own work in user literacy says that even if people understood what they're consenting on, they have no choice, right? Like, and that's the problem in terms of a binary model. You either choose with the conditions that it comes with, or you don't get access to the service. And behavioral economics has taught us that, even if people understood, they make irrational choices. And I think at this point, people cannot not monetize, cannot even conceptualize the types of harm that can come from these kinds of trackings. And so I think we need to do better with the technologies that are today, and not just say like, blockchain is going to solve this in like 5 or 10 years time, because there are underlying concerns with those technologies too, including lack of transparency, that, it may be feasible to fix it on the technological level, but it's not going to be feasible to actually know, who has access to the data and who's actually manipulating the code. So I think we're all on the same page that ads are here to stay, but I don't think we're on the same page in terms of the volume and the scope of intrusion that the ads have into people's lives.
Well, I'd love to hear the solutions that you have in mind to fix the current state, right? So it sounds to me that you have something in mind that we could that we could do, that we could build in the current state.
Well,
Outside of the
stop
transparency.
monetizing on users' data. Like, you know, part of the thing is like all that's done is done for profit, right? So like the benevolence is, yes, it creates job, but it creates jobs for very few. I don't have specific solutions, and don't tell me, you know, it's an academic exercise and, you know, ivory tower can think about whatever. But I think there is considerable tension in terms of not just the volume of data that's being collected, but like what is being done with that data. And I think people have considerable concerns that they have become goods, right? And people are not comfortable being goods for the profit of very selected few.
And I think as well as those sort of probably big philosophical discussions we need to get on, but practically there are things you can do now to be compliant. I think, you know, I touched on it, the contextual advertising, where if I go to a page about a topic, we talked earlier about canning tomatoes, showing me ads on that for other ways to preserve fruit and veg are likely to be highly relevant, but don't need to know anything about me or who I am and what I'm doing. So we believe there are ways you can do it now. I do think there are closer technologies than blockchain enabled mechanisms that can give us benefit. Now, one of the things we're very interested in and actually took to the G7 to discuss, because we think this needs to be a global initiative, is this idea, I think as Marina highlighted, that you're trying to achieve something pops up in the way. That's a terrible experience for everyone. That's terrible for businesses because you can't actually rely on it being genuine consent and trust from the people. It's terrible for users because they're just trying to they're trying to buy the thing they want. They're trying to enjoy their content. They don't mind getting it, but they're still having to say yes every time. Or if they do want to, they say no, or as we found before we started making our changes, to have no as an option. They got more info, 30 things, doing everything. You know, it's a huge waste of human time and effort. And the one thing machines are brilliant at are talking very quickly to each other. So our kind of model for how this can be improved before we get to futuristic technologies that may or may not occur is that if users can express their enjoying preferences, and some of the preferences may be, yeah, I'm very comfortable, share my data widely, I'm delighted by the process I get, then that yes should be listened to. They shouldn't even have to say yes every time. But that model, we need that not just because it puts the joy back into browsing the internet and receiving ads that are either tailored and relevant or ads that aren't. We still expect there to be ads. You're not opting out of getting ads, you're opting out of using your data to profile and provide more detailed ads, or your data being sold on for other purposes. That's the control that people get. But fairly soon, a lot of the services we consume are not going to be through a laptop or our mobile device. It's going to be our fridge talking to the hydro company to make sure we get the right pricing in the middle of the night. That's going to be our personal data being shared. I don't want to be woken in the middle of the night to go down my fridge and click accept on a button, or when I'm driving in my car and it's connecting to the next charging station, or a pop up in the middle of the 401, press this button, do this. That's all going to end badly. So we believe that expressing enduring decisions that then are expressed in the moment can provide a real benefit, and we're not too far away from being able to do that. So I do think there are ways we can do it, and even within the current mechanisms, we absolutely see there are some players who are deliberately creating dark kind of word hostile choice architecture to force people into decisions they don't actually want to have. And that kind of behavior, when we see that, we're going to take action, because whatever the circumstances is, we can definitely see a spread of behaviors, and at those who have the largest, highest impact and aren't taking this seriously and are actively trying to manipulate people, that's where we definitely see data being misused, and there's no way you can claim it's that consent. Fascinating, in one study I saw, I think, when they moved to the better choice architecture, they actually found more users accepted, because they felt, actually, this is a site that's respecting my choice. I'm willing to trust them and engage more broadly. So I do think there are things we can do now, as well as solving the bigger kind of what do we do as a society? How do we power innovation and growth? But
yeah,
that's my kind of sense.
Sure. I don't think my intention was to say, oh, let's wait for blockchain, although what blockchain is here. So that's not futuristic, and it's not sort of like, you know, a Jetson story. But what I did want to make clear is that we are in the process of you know, the grand cleanup. In, you know, about 80% of the creepy factor and the reason why we're doing all these pop-ups is because of third-party cookies. And those third-party cookies are going away in 2023. And if that's not soon enough, I mean, that's pretty fast. That means that the entire ecosystem is working around contextual advertising models, is working around different addressability models that are going to be privacy first. And there's a whole new Lumascape popping up that is all about privacy technologies, privacy efficiencies, and all that sort of stuff. So it's not like the industry is sitting on its laurels and saying, okay, well, we're just going to wait. That's not true. I think it's you know, the stages were this. One is we have third-party cookies, therefore we need a consent transparency mechanism. So we built that because that was an immediate need. That's not to say that that is the Band-Aid solution and that, oh yeah, this is our answer to advertising. No, but the answer is certainly not ad blocking. And you know, again, I just think that if you're blocking ads, you're blocking revenue, and you're blocking, and is it responsible for the jobs? Maybe not 100%, but it's responsible for the content. The newspapers, television, all of the non-digital media has made their money and paid their journalists from advertising. It's not a new model. It's like it's not new for the internet. But in any case, cookies are going away. So technology is forcing the internet to move away from this kind of a creepiness anyways. So I think, you know, Steve and I agree with you. This contextual signaling is becoming the new norm again, and we welcome that.
Okay, so I'd like to step in, and I think there is a fundamental difference between an ad in the newspaper and an ad on television and an ad on the internet. So the ad in the newspaper is not following me around my house, right? And I can choose to flip the page and not read it and not engage. The ad on the internet is following me around and collecting my data, largely without me knowing actually what data are being collected. And so I think, Sonia, I think those are like I think those are false sort of comparators. And it's just like the volume and the intrusion of the ads on the internet is very different. And you know, like if ad blocking is theft, we can have a completely different conversation. And I think we really need to move away from that conversation that it's theft, because who am I stealing from when actually somebody's collecting my data and making money on it and I'm getting nothing out of it, right? So, and I think the whole notion of, you know, link tax and like, you know, ad supporting journalism is like a completely different area. And, you know, we have a bill on that right now, and which is hotly debated. So I think we don't have time for that. But I think we have to make a fundamental distinction between different media and the way the ads work in them. And I think that's the problem, that like they're so intrusive that people just don't trust ads anymore. And like the industry, you know, maybe doing things now, but like has not done things in the past. And there's you're not building trust from zero up, you're building it like from minus something to build it to zero. And so I think that's the piece that the industry has to be working on. And maybe blockchain will solve everything. I don't know if it will, but the lack of trust is why the users choose these mechanisms to protect themselves. Like, you know, and we're past the age where, you know, I have secrets and therefore I want to protect my privacy. I just don't want to know, you know, I don't want my fridge or my washing machine or whatever to know what type of stuff I'm washing, right? Like, or like, you know, what food gets spoiled in my fridge, and maybe I'll get a better sense of, you know, using my budget better because, you know, I'll buy less food and whatever. Like we're not really talking about that. We're talking about the fact that like the industry is monetizing humans without their control and without any ability of us to actually choose what we want to give somebody else to monetize.
I'm adoring being on a panel where the regulator is not at one extreme. This is very good. This is a fresh new experience for me. I had two quick thoughts, and then I think Sonia wants to come back on to those points. But first one, if you think the telly isn't tracking you, get ready for smart TVs, video on demand. There's a whole set of other elements there, but we won't. I don't mean to add to your level of tension, given we're trying to work past that, but just be aware we're seeing one of our concerns about this kind of online tracking ecosystem is as we move move to a more connected devices and a quantified self, we are seeing that stepping in. I do think there are enormous benefits of things like our fridge and washing machine, learning what is in it. But I think it's vital that users have a sense of control over that, so their privacy is respected, so they trust and are willing to share that detail, so they get better experience, can have better environmental impact, all good stuff. But the point I wanted to draw out, just answering Sonia's point, I let Marina go first, is I think the link's been included in the chat. We've done some work because we absolutely understand many businesses want to do the right thing. And one of the problems of a large, complicated global ecosystem is not always clear what that is. So what we've done is published our expectations for online advertising proposals and sort of highlighted, because there's a rich set of possible ways to move forward in a post-cookie world. Some of them, I think, are brilliant from a privacy perspective. Some are marginal improvements that probably don't go far enough. Some actually make things quite a lot worse, because at least with a cookie-based system, the user has some level of control and awareness of what's happening, even if, as we get to server-to-server communications, things like that, some of this tracking and profiling can occur without the users even being aware. And some of our largest enforcements in the last few years have been on some of that sort of wider data broking, where information is collected for one purpose, collected, added to other data to produce a much deeper insight use, far worse than the things we're talking about around trying to make ads more relevant, but actually being profiled and analyzed and used against without even no transparency at all, and often in ways that harm the individual, where I think at its best, advertising is entertaining, it introduces us to new products, it gives us value, and it funds and supports the things we get. So I think there are, perhaps this can diffuse the tension, because there are things even worse than the ad ecosystem, and we should get those as well. Yeah, I think it's not our position as regulators to pick winners, but if we set common standards and say you've got to be at least this good to thrive, and if you do that, we're not going to bother you, we hope that allows the innovation and thought to have these things kind of grow. Because you're exactly right, there's a lot of really interesting work going on in this space right now, trialing and developing things, because there is this great understanding from all the players, I think, in the ecosystem that things have to change. And whether or not it's theft, there's clearly a signal that if your key customers are spending time and money to avoid your service, something has gone wrong in that relationship. And we need to make sure that the level of trust doesn't decay to the point where many, many people are not engaging and using these services, because it will be an end to funding some of the critical and valuable things we have, as perhaps we've seen in traditional media, as some of the products and services we loved as children have disappeared because there isn't a model to support them in the modern world. We want to make sure that kind of innovation is kept.
Yeah, agree. I mean, I was comparing advertising in print and TV and the historical, the hundreds of years of advertising. I only raised it to highlight the business model of it, right? So it's about how the content is funded. It's not that it's different in online advertising. Of course, it's different in online advertising. Otherwise, there wouldn't be an association that actually specifically deals with only that and the data that's used. And I think the GDPR actually went a long way to start shining a light on that, and to shining a light on the different purposes, and being a little bit more clear and specific and transparent with the consumers. And as we start moving towards the different types of advertising that are non-cookie based, you're going to see that there's going to be an improvement anyways, because that is what enabled all of that collection and aggregation and sort of profile creation in the first place. And once that is gone, and that is a tech delivered thing, that's not a regulated thing, that's something that tech is just eventually evolving into, you're going to get more and more things like Apple's IFDA saying, hey, are you going to allow this app to track you, yes or no? And it's simple, and you get it right away. As a consumer, you know what your choices are, and it's been devastating to the ad industry, and that's fine. Right? Because we recognize that is what the consumer choice is. And honestly, as I mentioned, and I think it was 1996, David Weinberger wrote an amazing, he's a Harvard professor, wrote a book that was basically 20 years ahead of its time, that said that consumers were eventually going to take control of how this thing was going to play out. And it's just taken the industry this long, unfortunately, to stop taking advantage of the ability to use data, And that's the sad truth, right? And every time a new product comes online, like, you know, remember the early days of email, before there was Castle, before there was an anti-spam legislation, and how absolutely ridiculous it was, what your inbox looked like, right? So regulation has certainly played an important role in improving the user experience, in that it does step in and actually, you know, create the guardrails. And we welcome those. Again, this is not about arguing about the fact that the internet isn't a complete gong show when it comes to user experience, and that it isn't self-created. But at the same time, we think that the important moves that are being made, like the elimination of third-party cookies, is really a lot more substantial than what people are giving it credit for. Right? I think that it is a monumental move for the industry, and I'm not sure that you know, people on the outside of the industry who aren't living and breathing this really understand what that meant, or what it means to the industry in terms of the loss of opportunities to be able to follow you around with that pair of shoes that you just aren't buying, or the car that you once showed interest for, that you may or may not want to buy. That goes away. Third-party cookies gone, that means that goes away. We can't track anymore. It's just you go to a publisher website, and whatever you do with that publisher, namely, you know, add your language preferences, you know, whatever it is, what your experience is on that one website, first-party data that's collected fully transparently, that's what we're left with. And so I think that we've got, like, we know we've got the message. We don't, you know, we're not pretending that we don't understand that change isn't required.
Go ahead, Marina.
So Sonia, I think I'd like to pick on something that you said, which I find really interesting, that you said, you know, when Castle came in, you know, things changed, and every time regulation comes in, we change and we comply. And what I would like to see from the industry, because you're much more agile than the regulators are, is to actually say, okay, we know the new technology is coming in, and we're proactively gonna behave and structure our behavior in a way that we don't even need regulation, right? And so, because every time there is, like, regulatory intervention always lags behind the technology, and, like, by the time we regulate it, it's kind of obsolete already. Like, that's just a truism. And so I think with 20 or 30 years, or how many years of the internet experience, your industry is actually in a position to provide the lead and say, okay, yeah, you said we got the message, but I think the public needs to see not only that you got the message, that you actually have the ability to do it better in every next iteration, because the messages have been learned. Like, you don't have to wait for regulation. And I think that's their lack of trust, and that's what you have to build, because the trust has been abused. People have a really hard time trusting that, like, whatever models you come up now are actually going to address some of those concerns.
Agreed. But if you don't notice a difference on your Apple iPhone, and that you're getting asked whether or not you want to be tracked, I mean, I'm not sure how much clearer, how much more of a lead, you know, it's no secret that technology that is privacy protecting has become a competitive advantage in the industry right now. Right? It's why Apple is racing towards privacy profiles. It's why everybody is now putting ads on the internet and on television, right? Google is all about security and about protecting your personal profile. I mean, it has literally, privacy has become a competitive advantage for the publishers and for the vendors right now, right? So again, yes, agree. I mean, I wouldn't disagree with the fact that we want to show leadership, and you know, are we at a deficit? Okay, sure. I'm not going to argue that. I tend to like to think about moving forward, right? As you know, as being in technology and having been in this industry for over 25 years, I believe in moving forward, right? So we're doing what we can.
Rena, I think you raised a really interesting point, and this has been sort of a thread throughout the conference today, is that of consumer trust. And so we've talked a lot about the need for organizations to be transparent, but consumers are notoriously bad at actually reading information that's been presented to them. You know, you get cookie banner blindness. I've been guilty of this, downloading an app that I want to use right away. So, like, I don't care what any of the documents say. You know, I'm agreeing to whatever, partially because I know I can't negotiate it anyways. You know, and then part of me professionally is like, I'll come back and read this later. Don't often do that. But, you know, and we saw, Stephen mentioned smart TVs. Like a couple years ago when smart TVs came out, there were headlines all over the place that like, don't talk in the living room, the TV's listening to you. And like, that was the point of the TV. What were people expecting? And Sonia, like you mentioned with Apple, once you were given an explicit choice to opt out of the third-party tracking, tons of people took that and ended up being devastating to the ad industry, like you said. But, you know, people may have reacted on the basis that that sounds intrusive. They didn't really know what it meant. They didn't really know what the tracking was happening. So how, if consumers don't necessarily want to take the time to understand, if they're not reading what you're presenting, but you know, lawyers spend hours and hours drafting, then how do you build consumer trust?
I think the critical point I would convey about that is that when trillion-dollar organizations want you to understand something and not be confused about it, they seem perfectly able to do that in really interesting and innovative ways. When they'd prefer you remained somewhat confused and unclear, particularly if that guides you in a particular conclusion that helps them but harms you, not in terms of some evil conspiracy, but just they're optimizing for the values that they're being measured on. It's important to them, you know, and that's why we see when a third party unrelated to the topic writes those interfaces, we get very different answers. Now, as with our working competition, we need to make sure that authority is not using its power to drive those answers in a particular way to disadvantage competitors and push its own model. You know, there definitely is not. We need to make sure there's a level playing field at every level here. But I think the concept that it's the user's fault for not engaging or understanding, I find that hard to believe. And I would just call out to our lawyers and people here, there are many skills that lawyers have. I have many I've worked with over many years and really appreciate their skills and capability. Part of their capability is constructing precisely worded, what an outsider might call jargon, but for those close to it, these nuances have real meaning that is absolutely essential in contracts. But if you have someone who is brilliant at writing contracts, writing your privacy notice, it will be a terrible privacy notice for anyone other than another lawyer. And although lawyers are a fascinating market segment and definitely are valuable on all the services I've been on, I'm not convinced it's big enough to make it that way. So I think if you are a lawyer tasked with writing a privacy notice to getting people to understand this, get somebody else involved. And I would point to, we've seen this is particularly acute when working with children and children's privacy, is that the notices written in legalese, most adults have no hope. Most 5-year-olds have found it very difficult. What we've created, which people are interested, reach out to me and I'll show you the details. We did a transparency champion. So we found organizations, I think one of them might even be Canadian, but we found global organizations who'd found fantastic ways of engaging children, explaining to them in the right way at the right point of time to give them authority and control over what they were doing with their data. And there are fantastic examples in there. So I know this is possible. And I just think it is fascinating that when we observe this, oh yes, no, it is my fault that I'm not engaging with this legal-ish document presented to me. I'm sorry. If the organizations cared, and what's fascinating, I think many of them do. You know, if we do this well, we get such a brand loyalty, such an engagement, you're much more likely to click on ads if you're like, oh, I trust this site and it's serving me this guy. You get better click through, you get better users. You know, I think we haven't touched on it today. The other problem with this ecosystem, not only ads, is the massive levels of fraud, where poor advertisers and poor publishers, there's other players in the ecosystem just siphoning money out of this infrastructure. So I think I think it's about 30%, as PwC study talks about 30% of the funding in advertising is disappears somewhere else into it, not through the legitimate players. So if you want to really to link back to that theft statement, that's where we should be looking, because that kind of abuse is harming every player in this ecosystem. But that's thankfully a little bit beyond the privacy regulators. But Sonia.
Yeah, we've built a lot of things to actually help with that, to help, and not to call it blockchain, but it is a blockchain premise, right? There's handshake technology now that we've implemented that allows vendors only to sell to known entities, which has removed a lot of that siphoning of the impressions from the internet. I think that building trust is just to answer the panel question. I agree with everything that you say, Stephen. I would also add that we have to get away from placebo, and we have to become a little bit more, rapid in terms of showing that trust, right? So you make a change to your settings, and the consumer deserves to see immediate effect. And that when I hit this toggle and I turn something off, it has in fact turned off. It is not some sort of a straggling, oh, there were exceptions, or there was fine print here, or something like that. So, and I think that that's the next thing to tackle. And as you can imagine, when there's hundreds of thousands of players and websites and ad tech in the industry, it's very difficult to communicate and to make sure that everybody gets the same memo that says, when this toggle is turned off, it means, no means no, okay, ad tech. So I think that's kind of a really important challenge for us on the technical side, is to make sure that things aren't just, vaporware, and that they're actually, not placebo.
Okay. Well, as much as I would love to continue this discussion, the next panel does need to start. So I'm very grateful to all three of you for joining us today and sharing your fantastic insights. I will now pass it on to Chantal Bernier, who is counsel and co-chair of the Global Privacy and Cybersecurity Group at Dentons. And Chantal's panel will be discussing the topic on regulating our online harm and avoiding surveillance.
Thank you, Amanda. What a terrifically interesting panel. I was just riveted. So now we turn to our last panel. And what we hope to tackle is the tension between regulating online harm, online content, without falling into a surveillance state. And I'm really lucky to be surrounded, as they see them as they come up, with truly experts in the field. First of all, I will mention Owen as an architect of Canada's regulatory framework on regulating online content, as Associate Assistant Deputy Minister for Cultural Affairs at the Department of Canadian Heritage. Welcome, Owen. Lorna Wood, that I would describe as an architect of the British regulatory framework to address the issue of harmful online content, professor of internet law at the University of Essex. Errol Mendez, vice president of the International Commission of Jurists and professor of law at the University of Ottawa, and the vice president of the International Commission of Jurists, Manette Maillet, who is also executive director of the Correctional Investigations Office, but who will speak to us from her experience of having lived that intersection between addressing what has been referred to this morning by Christopher Parsons as harmful but lawful. So how do you actually resolve that tension within the rule of law? So I'm going to ask Manette to first set the stage on the basis of how you have been confronted, if I can use that word, that tension between protecting human rights and yet addressing harmful content.
Thank you very much, Chantal. Can you hear me okay?
Yes.
Okay. Yes, so I'm going to speak from the point of view of my experience as a former litigator with the Canadian Human Rights Commission dealing with cases of hate on the internet. So it's really a view from the trenches. I'll speak very briefly about the right of freedom of expression and the tension that arises between that right and the right to be free from discrimination, and of course the ensuing harm and sometimes violence that causes. I will also talk about what I observed regarding what hate on the internet looks like, just so that we can get, we can see it on the ground. What does this look like? It's not just something that we talk about philosophically or theoretically, it's real. And I'll end by sharing my experience with one of the hearings I participated in to flag the gaps that currently exist in the law. So I'm going to bring us back a bit so that the other panel members can bring us to a discussion about the future. So many of my litigation files when I was counsel for the commissioner were on alleged breaches of Section 13 of the Canadian Human Rights Act, the hate on the internet provision. Now, at that time, the mechanisms in place to deal with hate on the internet were the Canadian Human Rights Act as well as the Criminal Code. Now, as we know, the provisions in both of these laws were challenged before the Supreme Court of Canada as being inconsistent with the Charter's guarantee of freedom of expression. The court determined that while the laws did impinge on freedom of expression, the limitations were necessary and justified, and that people have a right to be protected from the harm caused by hate messages. Now, I'm going to talk about freedom of expression just for a moment, because we often look to the US and their absolute protection of freedom of expression. And one of the most cited rationales for free speech is found in a 1908 case at the Supreme Court of the United States in Abrams versus the United States. And it was in the dissent of Justice Holmes where he said, "The best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes can be safely carried out." So it's this marketplace of ideas that will generate what the truth really is. Now, this notion is based on the view that human beings are rational creatures who can distinguish truth from falsehood. And it, taking us way back, in 1966, a parliamentary committee on hate propaganda was formed. It was also known as the Cohen Committee, and they tabled a report. And in that report, they discussed this rationality of man. They took the view that individuals can be persuaded to believe almost anything as long as information or ideas are communicated in the proper circumstances and using the right technique. And I quote from their report, "We know that under strain and pressure in times of irritation and frustration, the individual is swayed and even swept away by hysterical emotional appeals. We act irresponsibly if we can ignore the way in which emotion can drive reason from the field." So that was 1966. I think it's safe to say that in 2022, we see so many examples in today's world where emotion and propaganda certainly drives reason from the field. And it has done at various times also in our history, sometimes often leading to tragedies. What I learned from my involvement in these hate cases is that hate propaganda has a goal, and that goal is to demonize the target community, to isolate them, and ultimately to convince the audience to participate in discrimination and attacks against them, or to stand by and do nothing when others carry out that violence. The natural and intended result of hate propaganda can be seen in many historical and recent tragedies around the world, whether it's in Nazi Germany, Rwanda, the former Yugoslavia, up to and including the Quebec City and Christchurch mosque attacks, or multiple synagogue shootings, and including the killing of a Muslim family in London, Ontario. The Cohen Committee concluded that Canadians who are members of any identifiable group in Canada are entitled to carry on their lives as Canadians without being victimized by the deliberate, vicious promotion of hatred against them, and that groups or individuals promoting hatred in Canada constitute a clear and present danger to the functioning of a democratic society. Also in the Whatcott case that Mr. Dufresne talked about this morning, the Supreme Court upheld the constitutionality of human rights law controls on hate speech, noting that the risk of substantial harm from hate propaganda to the society as a whole was amplified by the advent of the internet and its potential global reach. So I'll share a story about one case that I had before the Human Rights Tribunal involving a neo-Nazi white supremacist, Mr. Alex Kobashian. At that time, we were dealing with hate propaganda mostly on websites. So it takes you back a bit. We didn't have the extent of social media that we now have. The remedy we were therefore seeking was for the author of the material on the website and the internet service provider, if we could find it, to cease and desist, which meant really to shut down the hate site. Now, we had a police officer who was part of a hate crime team here in Ontario, and he contacted us about wanting to be a witness in this hearing. He did this because he had followed Mr. Kobashian online as part of his anti-hate work, and he saw how Mr. Kobashian was drawing in other disenchanted youth, living in their parents' basement like he was, and he knew that he was violent against racial minorities. He had been charged with having beat up a Black man on a bus. He'd been charged with assault, but the hate crime charge was dropped because the prosecutor felt it would be too hard to prove. And as we know, criminal code hate provisions requires the consent of the Attorney General. So not an easy thing to do. The police officer came to us because he felt that if we could shut down his website, at least it would limit Mr. Kobashian's ability to recruit others and to organize them to take action. Section 13 then was the only legal mechanism to get this material off the internet, as the criminal code was not an option. So it was certainly harmful, but not quite criminal. And as awkward as it is to have a Human Rights Commission deal with this type of material, for several reasons, complainants are afraid to come forward, getting cooperation of internet service providers was difficult. The material would show up the next day on a US website. You rely on kind of one brave complainant to file these complaints. It sucks up very scarce resources for human rights commissions, et cetera. It was still a tool in Canada's toolbox other than the rarely used criminal code. So Section 13 was repealed in 2014. And in today's environment, I think resurrecting this section would certainly not be the answer to dealing with hate on the internet. There's so much to address. There's so many issues beyond human rights laws that it's certainly not a panacea. I'm just going to take one more minute. I know I'm running out of time. I just want to talk a little bit about what hate speech looks like for those who are worried that controversial and offensive views will be shut down. In Warman versus Cuba, the tribunal member, who's now Justice Karen Jensen, provided in her decision a concise summary of 11 hallmarks of hate, which is used to distinguish between hate speech and robust political discourse. The hallmarks are really descriptions of what hate speech looks like. And it's really based on the premise that you have a group of people that is innately inferior, subhuman, of no worth to society, innately evil, dangerous, and that we must protect the white race against these people. And so I'll just leave you with this. Some say that we should let it be so that we can see what's out there and then we can address it, because clearly hate is a symptom and we have to get to the cause of it, whether it be misinformation, lies, etc. My question is, does it exist outside of internet platforms? Does the anonymity and the connections the internet provides allow for a platform and an echo chamber which motivates those who are less rational to take action by confirming a very dangerous ideology? that, to my mind, is very dangerous to our democracy and to a healthy and safe society. So I know that the other panel members have lots to share about what's going on now. So with that, I turn it over again to the panel.
Well, thank you, Manette. I mean, that is truly compelling about the urgency of actually addressing this challenge. And Owen, you have either the great luck or rather curse, but certainly challenge of designing regulation to address harmful content. So over to you. How do you see that probably being addressed?
Thanks, Chantal, and hi, folks. Luck or curse probably depends on where you sit. As Chantal said, my name is Owen Ripley. I am a public servant at the Department of Canadian Heritage, and I am responsible for overseeing the development of a legislative regulatory framework for online safety and supporting our minister in that respect. We agreed that, my role in today's panel would be a little bit to set the scene here in the Canadian context. In the image, I've shared this before in other settings, but the image that always comes to mind on the online safety file is, if any of you have ever kind of done a design thinking course, they give you that really squiggly line that kind of, talks about, the process to looking at a problem. I feel like that's kind of the squiggly line that we're currently in the middle of on online safety. So, if we think about where we started from in the Canadian context, the story goes back to just prior to the 2019 federal election here in Canada, where you saw, the Liberal Party put out this commitment to put in place new regulations for social media, including, a takedown of certain kinds of content within 24 hours. And after the Liberal Party was elected as government in 2019, this commitment made its way into the mandate letter of the Minister of Canadian Heritage, and he was tasked with moving that forward by the Prime Minister. I don't have any privileged insight into that election commitment, but what I can say, is if we go back to the lead up to 2019, the German Netz.de model was certainly one of the prominent international examples of online harms legislation at the time. Since then, we've seen a lot of international developments, and I think Lorna is going to speak to this, but we've seen kind of the UK online safety bill be fully fleshed out. We've seen the Digital Services Act in the European Union, and we've seen the expansion of the e-safety framework in Australia. So this has been a very active space since 2019, and these international developments have certainly helped, I think, expand the thinking around online safety legislation, and we've seen a lot of evolution in that space. So in July 2021, for folks on the call who've been following the space, they know that the government published a detailed proposal of what a 24-hour takedown framework could look like in Canada. And I won't spend too much time on what that proposal is. Happy to kind of get into it a little bit more if there's questions, but the focus was on 5 categories of content grounded in concepts of criminal law. So we were talking about the incitement to violence content, terrorist propaganda, the non-consensual sharing of intimate images, child sexual abuse material, and hate speech. And that proposal set out essentially obligations on platforms to moderate those 5 categories of content. And then the proposal also, set out in some detail kind of the procedural avenues that were available to users and civil societies to challenge those moderation decisions. The framework was to be overseen by a new regulator, the Digital Safety Commissioner, and it was also to include a Digital Recourse Council. So the objective of going out with that detailed proposal was to provide an opportunity for Canadians to understand what was being contemplated prior to the tabling of a bill. And I think it's fair to say that what the government heard from Canadians was that there was significant concerns with the framework that was being contemplated. Among other things, we heard about concerns about freedom of expression. We heard about concerns about privacy. We heard about concerns about linkages with law enforcement and national security agencies that were being proposed. And we heard about the risk of undue impact on certain marginalized communities in Canada, including racialized Canadians. We had an election at that point, so we had an election in fall 2021, and when the current Minister of Canadian Heritage was sworn in, he was again tasked with moving forward as quickly as possible with a legislative regulatory framework for online safety. But the key was he was also tasked to kind of adapt that proposal, taking on board the feedback from those 2021 consultations. So when we picked up the file again in October 2021 after the election, and we had concluded our preliminary briefings with the current minister, it was clear that there needed to be a reset. And so the first step in that reset was to publish a detailed What We Heard report that set out the good, the bad, and the ugly of everything that we had heard in those summer consultations. The next step was to pull together an expert advisory group comprised of diverse experts from different backgrounds with a variety of different expertise. So folks with background in tech law, constitutional law, human rights law, folks from civil society. And I think I saw that Emily Laidlaw earlier today. So she was one of the co-chairs of that expert advisory group, and I trust that she will make sure that I don't mischaracterize anything in that respect. But the goal was really to get this group of experts together, which included folks who had been extremely critical of the government's 2021 proposal, and to get them to give the minister and the government advice on how to move the file forward. And so those experts met intensely over the spring. They didn't agree on everything, but I do think it's fair to say that there was broad consensus on what should essentially be the core thrust of a legislative regulatory framework in Canada. And that was to move away, from a takedown approach to what the experts called a duty to act responsibly. And that I see Lorna chuckling at that. So the concept of duty to act responsibly, my impression was in having observed some of the expert discussions and reading the reports is that it really emerged from a reflection on product safety law more broadly, and the fact that generally in society we expect that when product manufacturers are putting out a service or a product, that they are required to think about the harm that could be caused by that product and to take steps to mitigate that harm. And the example that's frequently used is you think about seatbelts and other safety measures in cars. And so the question really was, well, why aren't we thinking about online services through that same lens? So at its core, and again, I think you do see parallels with some of the other frameworks that are emerging internationally. This idea of a duty to act responsibly involves three things: so risk assessment, so what harms could be caused by the service offering; mitigation, so what steps can be taken to reduce those harms; and transparency. So reporting on the results of that risk assessment and the effectiveness of the mitigation measures. And the idea, as I have kind of synthesized it, is really to create a cycle of continual improvement where platforms are meaningful, leaning in to making the online environment a safer and more inclusive space for Canadians, and that civil society and the public more broadly have a clear line of sight into how that's playing out. So, since the expert advisory group concluded their work over the summer and the fall, the minister has been on the road, so to speak, testing out this idea of a duty to act responsibly with civil society, community organizations, and other interested parties through roundtable discussions. These roundtables have been an opportunity to hear directly from organizations about how to best mitigate some of those concerns that I mentioned earlier, that are real concerns about the government getting into this line of business. We've also used the roundtables as an opportunity to solicit feedback on more specific elements of the proposal, which the experts struggled with, and that I think there's still debate about. So questions around scope, what kind of platforms and what size of platforms should be subject to this duty to act responsibly. Questions around meaningful recourse, and in this space, particularly as it relates to child sexual abuse material and the non-consensual sharing of intimate images, where victims and victim advocacy groups have been very clear that one of the legal recourse that they are looking for is for that content to get off those services. Questions about appropriate linkages with law enforcement in relation to criminal activity, and how you in the context of, if there are linkages, how you protect more vulnerable and marginalized communities from over-policing, from over-reporting, and those kind of things. So that's where we're at now. The final roundtables wrap up over the coming weeks, and then the job really is to work with the minister to finalize the proposed approach. And this was one of the 100-day commitments, so to speak, and so the goal does remain to table legislation as soon as feasible. There you go, Chantal. You're on mute there, Chantal.
The line of the year. So what I wanted to say, Owen, is that I see the intensity of the reaction to your first iteration of the bill as evidence of the complexity of the issue. And so I think it's very interesting right now that we're going to move to Professor Lorna Woods, who's sort of ahead of us because the UK has more of a defined path forward now. So turning over to you, Lorna, as to how the UK has addressed that challenge.
Thank you for the introduction, and thank you for inviting me. I'd like to start with a question, and I think I'm picking up from some points Owen has just made. And that's about what is the best approach to regulation. So I'm making a distinction here between what I've termed systemic regulation and direct content regulation. And in a recent debate on the Online Safety Bill in the UK Parliament, the then Under Secretary of State for Digital Culture, Media and Sport, Damian Collins, said in response to the debate, "I take exception to the suggestion that this is a content moderation bill. It is not, it is a systems bill. The content that we use and often refer to is an exemplar of the problem. It is an exemplar of things going wrong." So what's he talking about in this distinction? Well, historically, and if we look at, say, broadcasting regulation, what we've done is identified types of content, and these are usually on an item-by-item basis, ex-post response, and dealt with, on the whole, by the binary. Does it stay there? Is it allowed? Or does it come down? And in the context of social media, we've maybe backed that up in some instances with liability for third-party content for failure to act. Systems regulation does something different. We've got systems in the meaning, two meanings here. The first one is by systems we talk about the system itself, the software system, the business system, the product on which that content sits. The second meaning of systems regulation is the idea of having a process in place to deal with what we might call product safety. That is, look at what's happening, do a risk assessment, and try to mitigate. This approach is based on the recognition that social media platforms and search engines are not neutral as to content. They're designed to optimize user engagement, not user safety or informed discussion. And this seems to have led to the prioritization of emotive, extreme and divisive content a communications environment where frictionless communication removes space for nuance and time for thought, and moreover incentivized the creation of clickbait through advertising revenue sharing. So other complex industries are expected to engage in safety protocols. Most products undergo safety testing. So the question that the systems approach asks is, why not these? In essence, we're looking at safety, risk assessment and safety mitigation, whether through safety by design or safety tech and user empowerment tools. And as the UN Special Rapporteur for Freedom of Expression, David Kay, said in relation to hate speech, this means interventions can be more nuanced and proportionate than regulatory interventions that focuses just on takedown. What you've got is a range of places in the information distribution chain where there can be interventions that affect information flow and information creation. So what about the online safety bill? Well, there's a little bit of a glitch going on in the UK. It's been an interesting time politically, and that has meant that the online safety bill has perhaps not gone through Parliament as fast as it could have done. So it's temporarily paused. We're expecting it back. But what I'm going to talk about is the version of the bill that was 2/3 of the way through the Commons before we went into the leadership election for the Tory party. Top line news on this is there are substantial systems elements in this bill, and I think that's good. But these exist under a heavy wrapper of content concerns, and I think that's much less good. The content concerns may be necessary or natural. Damien Collins suggested that it's through content that we understand the nature of the problem. But it has led to there being a very complex bill. So I hope you're all well buckled in, because I am now going to rattle through the structure of the bill. Happy to recap or answer questions when I get to the end of this with a deep breath. First off, services in scope. We've got user-to-user services. That's the term used for social media platforms. We've got search services, and then some bolt-on provisions relating to what we might call professional porn services. I'm not going to talk much about that last group because it really is a bolt-on. Social media platforms are subject to more onerous obligations than search, and within each of those two service categories, some bigger, riskier platforms are subject to more onerous obligations than others. Duties comprise risk assessment duties and what are called safety duties. These are essentially duties to mitigate the risks. But the way the risks should be mitigated to some extent depends, first of all, on the classification of the service, and then the classification of content. There are three types of content which the bill distinguishes between: illegal content, that is content, the possession, creation or dissemination of which would be a criminal offence; content harmful to children; and content harmful to adults. The obligations in relation to the criminal content are more stringent and tightly drawn than those in relation to children's content, content harmful to children's, and then the harmful to adults category is very lightly regulated. Within each of these categories, there is a subcategory. Are you getting the theme here? This is the subcategory of priority content, which in each instance is subject to more detailed rules on the face of the bill. Illegal content duties apply to all services. Children's duties to those services likely to be accessed by children. Duties in relation to content harmful to adults, however, are only applicable to the large and risky social media platforms. They're called Cat 1 services. All services have obligations to take freedom of expression and, to a lesser extent, privacy into account. Cat 1 services have extra duties in those regards, plus duties in relation to democratic content and journalistic content. And then there's some more bolt-on duties with regards to fraudulent ads. The risk assessment duties focus quite heavily on functionality, design, and operation of the services, as well as the user base and the type of content. The safety duties, with the exception of harmful to adults, are focused on outcomes and expect the design of systems. So that's what they're phrased as. Please design a system, please take steps to mitigate. The harmful to adult duties, however, are pretty much just transparency obligations backed up by user empowerment tools, but only in relation to priority content. And I'd like to make it clear that there is no obligation to censor or restrict harmful but legal content. We've got a regulator, Ofcom, as well as enforcing. It has got to produce guidance and some codes of conduct on how to comply with the rules. But these are going to take a time to be drafted, which I think will affect the entry into force of the obligations. The obligations only kick in once that information is out there in public. So, you know, we're talking what, 2024? That's my guess. I'd like to finish with some criticisms of the bill. The first one, and one I've made, is the bill is very complex, as you might have gathered from the way I rattle through that and all the subcategories and the different types of rule. This is probably because the government wanted to chart a path through competing interests, but it's actually left with an untidy stack of rules focusing on these types of content, begging questions about definition, and then compounded by a very circular approach to drafting, and then the subsequent add-on duties relating to fraudulent ads and pornography did not help. The extent of the powers the Secretary of State has are a concern, and again, it's a concern I share. There are powers for the Secretary of State to designate through regulations, statutory instruments, the categories of priority harmful to children, priority harmful to adults, and add to the list of priority criminal offences. And so there is some, I think, legitimate concern about the level of oversight as that would go through Parliament. More technically, the Secretary of State has powers, I think, too much to interfere in Ofcom's code making and implementation of the regime. And I think there are concerns about Ofcom's independence, which actually is central to maintaining a pluralistic environment and maintaining freedom of expression. I'd like to conclude by talking about the category harmful to adults, which has got a lot of flack. And I think people are mistaken. Just in case there's any doubt, I don't have a problem with harmful to adults. And there are two aspects to this. One is the nature of the content in there, but also the nature of the obligations in the bill. So this content has been portrayed as regulating for hurt feelings, and I don't think that's the case. There's a triple threshold before content can be considered harmful. So the definition is content which firstly presents a material risk, of secondly, significant harm, and thirdly, to an appreciable number of adults in the United Kingdom. So that's quite a threshold to get over, and I wonder where it leaves minoritized groups. The distinction between harmful to adults and criminal content, I think, is an unhelpful binary. It implies that there are just two types of content, that contrary to the criminal law and that which is completely acceptable with regards to the law. And this completely ignores the fact that we've got regulation and civil law that are there to protect a range of other interests. And if we go back to the little saying, what is legal offline should be legal online, then I think if we regulate, for example, advertising or pornography offline, we should have regulation online. In any event, as I think Manette mentioned, content in this category can be very harmful indeed. It includes material that falls short of the criminal offences, sometimes just for technical reasons, or is just really, really nasty. We've got discussions at the moment about cyber flashing and what falls outside that for technical reasons, and extremism in the UK is not a criminal offence. Terrorism is. My final point is the nature of the obligations. As I've mentioned, what we're looking at is essentially information to be given to users as to how the platforms deal with certain types of harmful content, an obligation on the platforms to consistently enforce those terms of service, that is in relation to priority content only, not in relation to all harmful content, bizarrely enough, and also to provide user tools, again, only in relation to priority harms. So this is not a takedown regime. And I return to the point of the UN Special Rapporteur on freedom of expression, who suggested that other mechanisms beyond takedown, about tagging, about nudging people, may allow people to coexist more peacefully online than just saying, is it here or is it not? So happy to answer any questions, but I'll hand the mic back to Chantal.
Well, thank you very much. As I listen to you and to Owen, I find that there's a common thread there of the importance of having what I will call, if you allow me, a modulated approach, right? Nuance. I would like to turn to Errol now to bring this issue to another level of government, so to speak. Owen referred to the EU Digital Services Act. There's therefore like a broader context. Over to you, Errol, to place the subject in that context.
I will be focusing on the EU digital services, but I also want to have a larger framework, which you'll be pleased, Chantal, that I'm actually going to try and start with something which Chris Owen said, Chris Parson said at the very beginning of the seminar, which I think we should keep in mind. Remember, he said, he took us through this magical mystery tour from the start of the internet to where we may be now. And he emphasized the clash of ideas and the clash of ideology, starting with the libertarian approach, the free internet, etc. And then we went on to those who, as Manette has said, that there is a clash between freedom of expression and discrimination and targeting of minority groups. And one of the things which I have noticed, and I've been front and center in some of these areas as a human rights adjudicator under the Ontario Human Rights Code, and then later on under the Canadian Human Rights Tribunal, I saw front and center how those clashes were appearing not only between the people who were being accused of things, but also between those who were judging and those who were bringing the issues, including the commission and others. And one of the things that started occurring to me is that this is going to be resolved by government eventually saying, look, we cannot please everyone together. We may have to end up coming up with a system which will focus on process, something which Lorna has called systems. But I want to talk about it in the context of an even bigger form of a duty to show responsibility, not just a systems, but a duty to show responsibility. And ultimately, I think what the EU has set up is the mega contents and the mega systems approach. And if I can ask someone to put on the slide a brief description of what's on the the Digital Services Act. Okay, so I'm going to go through this very quickly because I only have 10 minutes. So let's just start with who the Digital Services Act covers, and it's pretty much everyone. Anyone who's basically an online intermediary. It basically covers also, it harmonizes the illegal content online. It also deals with some of the issues which was discussed in earlier panels on deceptive advertising, on actually the recommender system where where individuals are followed through in terms of what they look at. But I think the most important part of the in terms of the general framework. Okay, I'll just keep on talking as what you will see once they get the whole system up. So what the Digital Services Act has decided to do is we're going to have different obligations from the smallest online intermediaries to the slightly larger ones, which deal primarily with hosting, to the ones which deal with social media, and then ultimately the mega platforms, what they call the vaults, the very large platforms, and also the very large search operations. So that's the area where I'll focus most of my my comments, where essentially they've followed to some extent the same approach that the UK has, where they're focused on not on the content, but on a system which requires these platforms to first of all engage in very detailed risk management, which requires them to look at everything they have done to identify what are the potential risks, from the illegal to the harmful but lawful, to other areas, including the impact on children, etc. Once they've done that, they have to show it. So the next part of the focus becomes the focus on transparency. They have to show what they're doing in terms of their risk management. If they have in their reports that they do not have the ability to do proper mitigation measures, that will be required of them. So that's the next part of the approach which is required from that. So as you can see at the very bottom, the most significant thing of the whole process is a special due diligence obligations, which requires mandatory risk management, and then there is a requirement for them to subject them to independent audits. And the due diligence chapter of the Act specifically recognizes the systemic risks to the fundamental rights stemming from these platforms. And the effectiveness is really going to be measured by future delegated acts and guidelines, which have yet to be drafted by the Commission. Now, I just want to emphasize where this is at. So the whole Act was approved of by the Parliament. It is now in the form of a directive, which has to go through all the 27 legislatures to eventually become part of the legal system of each of the members. However, that being said, one of the issues which I would love to have a further discussion on with my colleagues on this panel, and indeed the audience, is if you look at all the different aspects of this process. If you just go up a little bit, if you look at the first part, okay. So in terms of the transparency approach, and what they call the algorithmic accountability, that's going to require looking into the black box. How effective is that going to be? And it very much depends on all the different types of the online intermediaries are willing to show what's in that black box. Also, in terms of the illegal content, a lot of it is going to be dependent on what's called the trusted flaggers, who will submit, and they're going to be authorized by a unit of each country to basically require platforms to look at what they consider illegal content, etc. There are huge scopes of controversy just on that point again. While we think of illegal content as fairly clear, no, it isn't. There's going to be many different aspects of what is going to be regarded as illegal in different countries. And then how do you respond to it? The next level down, the harmonization of response to illegal content, as you can see, requires that intermediary liability to act when they detect illegal content based on either individuals coming forward with what they consider illegal or these trusted flaggers. And how are they going to diligently respond to that is going to be very interesting to see how it works out. I'm not going to go into the other parts which actually dealt with some of the issues in previous panels dealt with, such as deceptive advertising and also the so-called recommender system. And so one of the issues, I think it's time for any country which is interested in dealing with this online harm is, what is at the root of this problem? And I would like to go back then to Chris Parsons' opening statement that essentially through his magical mystery tour from the start of the internet to where we are now, we have seen time and time again the clashes of not just interests, but ideologies and approach to how to deal with this. And so one of the things which I would love to have some discussion on is it at a certain point, is it time for governments to say, we hear that you all have your positions, your ideologies, but for the interest of society as a whole, we are going to start and take a risk, and what we're putting forward may work, it may not work, but we have to do something. And the way I like to analogize this is, and again, I'm going to use two forms of sports metaphor. The first one is American or Canadian football, where it's a whole Hail Mary pass. I think this whole area is a Hail Mary pass. Something has to be done. Now we have very, very detailed frameworks for it to be done. The US has one. Sorry, the UK has one. Now the EU has one. Canada is desperately trying to come up with something. We've abandoned what we started with, as Monette has said, because we repealed one of the critical laws in that area. So now we have these process and systems frameworks. But I really think that in the context, the metaphor of American football is a Hail Mary pass. I don't know whether people who don't understand American or Canadian football, it's when the quarterback just throws something as far as possible, hoping that someone's going to catch it at the end zone. In the soccer zone, the one I like to talk about is where a good player sees the goalie's out of the net and decides to lob it way over his head and into the goal, as the famous Pelé, one of the greatest soccer players, did. I think this is a form of Hail Mary pass, or the equivalent in soccer. And I think there's going to be a lot of problems with it, but I think it's a result of governments finally saying something has to be done. We can't just agree with one set of ideas or one set of ideologies. We have to do something for the benefit of society as a whole. And I think it's going to be very interesting. Keep in mind that the fact that the EU essentially has applied it to anyone who is established in the UK or is doing services in the UK, that has de facto an extraterritorial impact. So ultimately, whether or not the UK actually passes its own laws, or whether Canada does it, my prediction is this is going to be like the GDPR. Ultimately, I think the European Digital Services Act is going to profoundly affect what happens eventually in Canada, and indeed in the UK also. So I'll leave it at that.
Thank you so much, Errol. I cannot resist. I would love to hear, Owen, you have essentially sort of given a message to government that you hope government will take a firm stand and say, I'm not going to give in to ideology, I'm going to elevate this to the public interest. You also mentioned you think that the EU Digital Services Act will be a beacon, a model. Owen, can I ask you to react to these comments from Errol?
Sure. Maybe I'll actually try to kind of tie a number of threads together from everybody who's spoken on this panel. You know, going back to Monette, you know, a lot of the times, right, when we have these discussions about online safety, the conversations are dominated by, you know, questions around content moderation and systems. And I think, you know, one thing that we heard very clearly from the expert advisory group, and you know, I think Monette was getting to it as well, is the importance of also anchoring these discussions in human rights law and human rights law concepts. And I think, you know, the starting point for us is a recognition that right now, you know, depending on who you are and the color of your skin and your religion and your gender and your sexual identity, you know, the internet is not an equal opportunity place. And so, you know, yes, freedom of expression is important, but I think, you know, the driver actually from where I sit, or one of the drivers from where I sit, is actually, you know, ensuring that, you know, more Canadians actually feel like they can freely express themselves online, because I think there's barriers there that you know, we're not actually meaningfully grappling with. And so I think part of it is that, and you know, I think the message we got from the expert advisory group is make sure there's a healthy tension between kind of making sure that platforms understand that they are accountable for upholding human rights, freedom of expression, privacy, you know, in terms of the systems and processes they put in place, and that needs to counterbalance, you know, any obligations they have to mitigate harm, where, you know, some of those concerns about you know, undue impacts come up. And so if you get that balance right, and you kind of, you know, really make sure that platforms know that they're seized with that kind of a healthy balance there, it helps kind of ensure that we don't lose sight of what fundamentally we're trying to achieve. I really appreciated Lorna hearing, you know, about the UK experience from where you sit. Obviously, it's a big comparator for us as we've done our international comparisons, right? I think, you know, when I think about the reflections that are currently going on right now, you know, obviously there are kind of parallels between the duty to act responsibly and the duty of care type model that emerged in the UK. You know, I think the tension and that we're trying to kind of resolve and work through right now is, you know, one of the criticisms, and you'll know it, that's kind of come up in the UK context, is like, be wary about kind of too much of outsourcing to kind of self-regulatory approaches. And so, you know, that's again something I think that we're trying to sort through. And as you spoke about, Lorna, as well, I think that, you know, one of the criticisms that comes up in the UK is kind of this question around, you know, it's a duty of care approach, but there are still very specific obligations with respect to certain categories of content that are quite prescriptive. You know, what we've learned from the Australian model, which we haven't talked a lot about today, but I think, you know, it's interesting because it's a bit of a different model than either the DSA or the UK online safety approach, is that it's, you know, I kind of tend to characterize it as a complaints-based model. And again, I think, and I come back to the two categories of content that I mentioned in my remarks of child sexual abuse material and the sharing of intimate images without consent. Again, one of the key messages we keep hearing in that space is like, if I haven't been successful in getting a platform to take that kind of content down, I need someone to go to help me do that, right? And so, you know, the question has come up about, you know, an ombudsperson function, who would really be someone that, you know, a Canadian could turn to, and that you know, that individual would have the ability to potentially assess the merits of that, and ultimately really seek to have that content removed in those two categories. So again, you know, those are the pieces that we're juggling. You know, we're fortunate in that, you know, we now have some international examples to draw from, and so that's certainly, you know, what we're doing right now.
Thank you. Can you also tell us what you think about this idea that, like the GDPR for legislative frameworks, the EU Digital Services Act will become a reference?
So it's obviously, I mean, it's, you know, it comes up a lot now, right? Like the EU is a 300 million person market. So when it chooses to move, you know, it's important. I think, you know, industry is certainly advocating that governments work to align their models as much as possible, because again, obviously, if you're sitting in a platform shoe and you're running a global business model, you're concerned about approaches that vary significantly, right? So for sure, like the DSA, I think is going to be an important marker. But again, I think, if listening to me and Lorna and Errol, like I would say, I think for the countries and governments that are moving right now, you heard the echoes of similarities in terms of duty to act responsibly, duty of care, systems-based approaches, right? So I think there is a recognition that when you're balancing the competing interests in this space, and the really important competing interests in this space, that systems-based approach is a way to do that, as opposed to kind of a content moderation type approach.
Which really arcs back to Lorna's point. Unfortunately, we are out of time. Thank you so much, all of you, for at the very least putting forward the issue as at hand and the complexity of their interrelationship. On that, I'm going to ask my colleague, Monica Song, and the president of the International Commission of Jurists, Errol Mendes, to close this conference. Thank you so much.
Well, this was very good to sort of end the seminar with the topic we just talked about. To some extent, it actually included many of the topics from the very start with Chris Parsons. So one of the things which is quite apparent to anyone who's listening is that this area is so fundamental to the issues of how Canada responds to the challenges, not just of the internet, but how the internet reflects what's outside the real world, is the challenges to the rule of law, the challenges to human rights, the challenges to anti-corruption, the whole area to child sex trafficking, for example. And one of the things which I think is very important, that not just organizations like mine and law firms like Dentons, it's important that everyone in Canada starts thinking about what's your role in all of this. And we encourage you to start giving us your ideas. This one reason why we agreed to join up with Dentons, because we want people who are listening to this to contact us and tell us what you think. And maybe we can start a dialogue with you on the areas that you're interested in, to see how we can make progress. So for those of you interested, our website is icjcanada.org. And we would welcome you to join us, and look forward to maybe continuing the discussion online and offline in the future. And with that, I'll hand it over to Monica.
Thank you so much, Errol, and thank you for in your capacity as the president of the ICJ and as a panelist on the last panel today. I think everyone will agree that we've been brought up to the minute on all things in internet regulation in Canada and indeed across the world. We thank you so much for joining us today in this joint ICJ Dentons Regulating the Internet Really conference. We hope that you will join us in next year's iteration, because we do plan on being back next year. With that, I'm going to give everyone back maybe about 12 minutes of their day. Thank you so much for sharing this time with us.
Thank you. Bye.
Thank
Bye-bye.
you.
Bye, everyone.
Bye.